Good morning. Very good morning, and welcome to the marathon revision of jurisprudence, interpretations, and general laws. So, we're going to discuss all the chapters in detail. Along with that, at the end of each chapter, we'll be solving the previous year questions as well as the study material questions. Okay, so let's start with chapter number one. What is the chapter number one? Sources of law. So, sources of law. In this chapter, we'll discuss the legal theories of various jurists. Along with that, we'll be discussing the sources of law. What of law? Sources of law. So, let's start. What is the first word? Law. What is law? Article 13, Clause 3 of the Constitution of India defines the word what? Law. And the word law includes what? Ordinances. Who makes the ordinances? President or governors. When the parliament is not in session or the state legislatures are not in session, in that situation, the president or the governor can promulgate the what? Ordinances. And the word law includes what? Ordinances. It also includes what? Orders passed by the government as well as the bylaws. What laws? Bylaws. It also includes even the rules. Rules are made by whom? Executive within the delegated parts. What parts? Who delegates the power? Legislatures. So within the delegated power, when the executives makes the law, it is called as what? Rules. And we also have regulations. Also have what? Who makes the regulations? Regulatory bodies. What bodies? We have RBI regulations, SEBI regulations. So the word law includes ordinances, orders, bylaws, rules, regulations, even the notifications issued by whom? Various executive authorities, MC notifications, CBDT notifications. It also includes even the what? Customs and usages. Customs and what? So a set of patterns or behavior which is found in society, which has a legal force of law, is also called as what? Customs. So custom is also a law. And then we have usages, the practices, which are incorporated in a contract. If it is known to whom? Both the parties. They're also called as what? Usages are conventional customs. What customs? Conventional customs. So this is the definition of the word law as per what? Constitution of India. Which article defines the word law? 13. Article 13. What do you mean by law? Ordinances, orders, bylaws, rules, regulations, notification, customs, usages having in the territory of India the force of what? Law. Force of what? Law. Then jurisprudence. What prudence? What is jurisprudence? The word juris means what? Law. Prudence means what? So what is jurisprudence? When we study about the law, science of law, or when we inquire about how the laws are made, what are the rights available in the law, what is the punishment available in the law, all those, it is called as what? Jurisprudence. What prudence? So what is juris? Law. Prudence means what? Knowledge. Then we have legal theories. What theories? Various jurists, after thorough inquiries about the concepts of law, they are given their propositions, they are given their theories. Those are called as what theories? Legal theories. What theories? So we have various legal theories which are given by the various jurists, and we can classify them into various schools. For example, we have natural schools of law, then positivistic school of law, historical school of law, sociological school of law, psychological school of law, and also we have a realistic school of laws. So these theories given by the various authors are important from the examination point of view. They may ask you to write a short note on a theory given by the we have six important authors. So they may ask you guys to write a short note on any of the theories given by these six authors. First one, important one, Jeremy Bentham. Which Bentham? Important Jeremy Bentham. Whenever you get this name or whenever you come across with this name called as Jeremy Bentham, the first thing should come to your mind is happiness. What is that? Happiness. He believes that the purpose of the law is to maximize the what? Happiness of individuals, because he believes that a maximum happiness to an individual leads to what? Maximum happiness to the society or to the public in general. Correct, right? So he belongs to what school of law? So the first point you write in the examination, if you see Jeremy Bentham, a questions on Jeremy Bentham is what? He belongs to what school of law? Everybody must answer. What school of law? Analytical school of law authors believes that law is the command of sovereign person. What person? So he belongs to what school of law? Analytical school of jurisprudence. And he has given the definition of law. What he has given? Definition of law. According to him, law is a what? Assemblage of science. What of science? Science, nothing but what? Law or rules. It's a declarative of volition. Declarative of what? Now, what is volitions? Intention or will. Conceived or adopted. By whom? Sovereign. Either it can be conceived, means he is creating a new rule of law, or he is adopting what is already there in the society. Correct, right? Conceived means what? Creating a new law. What is adopting? You're just adopting the existing law. So, what is law according to Mr. Jeremy Bentham? Assemblage of science, declarative of volitions, conceived or adopted by whom? Sovereign. What is sovereign? Politically superior person in a state concerning the what? Conduct to be observed. What to be observed? In certain case. What case? By what person? Or a class of person who in the case in questions are supposed to be what? Subject to his power. What to his power? Subject to his power. So the first point you write about Jeremy Bentham is he belongs to what school of law? Analytical school of law. Then he has given definition of what? Law. What is the definition of law? Assemblies of science, declaration of volitions, conceived or adopted by whom? Sovereign, concerning the what? Conduct to be observed by what person? Certain person. In what situation? Certain situation. Simple as that. Next one. He is the first contributor. What contributor? Jeremy Bentham is the first contributor to the what? Role that law should play in the society. What should play in the society? The role of the law in the society. Who is the first contributor? About the what? Role of law. According to him, what is the role of law in the society? The role of the law is to bring a what? Maximum happiness. What happiness? Of whom each individual for the happiness of each will result into what? Happiness of all. He believes that the purpose of the law or the role of the law in the society is to what? Maximize the happiness of whom? Individual. Because he believes that happiness of individual results into happiness of whom? All or the society. Justifications for having the law is it's an important means of ensuring the what? Happiness of members of the community in general. What in general? And he has given the 8 different aspects or 8 different ways to look into the what? Concept of law. What of law? And these 8 aspects or 8 concepts are most important which you're supposed to write in the examination. So before I start with the 8 different aspects we should consider when we're studying about the law, first tell me, Jeremy Bentham belongs to what school of law? Very good. What school of law? Analytical school of law. Correct, right? And has he given any definition of law? What is the definition of law? Assemblies of science, declaration of volitions, conceived or adopted by whom? Sovereign, concerning the what? Conduct to be observed by what person? Certain person. In what situation? He is the first contributor to the concept of what? A role of law or the objective of the laws. Correct, right? What is the role of law? To maximize the happiness of whom? Because the happiness of individual results into happiness of what? Society in general. What are the 8 aspects or the 8 concepts of law, sir? What is the first one? Source. We should study about what? What is the source of law? What is the source of law? Law comes from the what? Will of the sovereign. According to Bentham, he believes that the source of the law is the what? Will of the sovereign. What of the sovereign? Because he belongs to what school of law? And analytical school of law author believes that law is the command of what person? Superior person. What person? And the sovereign creates a new laws or adopt the what laws? Previously issued or allows the laws to be made in a future by what authorities? Subordinate authorities. What authorities? So law comes from whom? Sovereign. Sovereign could create new law or adopt the existing law, or they can authorize the executives to make the laws in what? In the future. So what is the first aspect of law? Second one is what? Subject. Now what do you mean by subject, sir? To whom it is applicable? Law is applicable to whom? People or to the things. The subjects can be either what? Active or it can be passive. What do you mean by active? Those who perform the actions, the executives, are those who are affected by the what? Actions. Correct, right? What is the first aspect? Second one. Third one is what? Object. What is the object of the law? The reasons or the purpose for which the law has been made. As per Jeremy Bentham, what is the purpose of the law? Very good. Maximize the happiness of who? Individual. Because maximizing the happiness of individual results into happiness of what? All or the society. Next one, extent. What is the extent, sir? The extent to which the law is applicable. What is applicable? Law is applicable. Extent can be what? Two. It can be direct as well as what? Indirect. Direct extent refers to the specific geographical area. What area? Where what applies? Law applies. Indirect extent refers to how the laws affect the relationship between whom? People and things. What and things? People and the what? Things. So, what is the first aspect? So, second one, third one, fourth one, extent. Fifth one is what? Aspect. Law will have two aspects. How many aspects? What is the first one? Directive part and sanctional part. What is directive part? That tells what people should do or should not do. What is sanctional part? The consequences, the evil consequences that will follow if you follow or if you don't follow the instructions given in the laws. Correct, right? So every law will have how many aspects? What are two aspects? Directive and sanctional. What is the directive part? Tells people what to do or not to do. Second one, sanctional part gives the law its force by imposing the what? Consequences for not following the laws. Next one, sixth one, force. What is the force? The motivation behind the following the laws. The reason for which people follow the law is called as what? Force. Correct, right? It can be either a punishment or it can be a reward. Either it can be what? Or it can be a reward. That is called as what? Force. Next one is remedial appendage. What appendage? These are the set of subsidiary laws addressed to the judges through which the judges cure the evil. Cure the what? Evil. And stop the evil or prevent the what? Evil. Future evil. Correct, right? The judges can issue the injunction to prevent a person from doing something, or they can compel him to do something. Correct, right? That is called as what? Remedial appendage. Next one is what? Expression. So law is an expression of whom? Whose will? Sovereign will. And this is about Mr. Jeremy Bentham. What Bentham? Jeremy Bentham. He has considered the laws in how many aspects? How many aspects? 8 aspects. There is a criticism of Bentham's theory. What theory? Bentham's theory. What is the criticism of Bentham's theory of laws, sir? First one, oversimplifying the laws. What of laws? Oversimplify the laws. He has oversimplified the laws by saying that law is a command. Law is a what? He has simplified the law, saying that all the laws are commands or permissions, overlooking the laws that grants the what? Powers. He has oversimplified the laws by saying that all laws are commands or instructions, but there are few laws which does not command anything. They provide some benefit to the world, societies. Those laws are not covered by whom? Jeremy Bentham. Not only Jeremy Bentham, all the authors who belong to analytical school of law, they believe that law is the command of which person? Superior person. What person? But in the present, in the modern era, in the modern legal jurisprudence, there are laws which do not command the people to do something or not to do something. They provide some benefits. Those laws are not covered by who? Jeremy Bentham. That is the first criticism of whose theory of law? Jeremy Bentham's legal theory of law. Next one, he has neglected the what? Customs. Because according to him, law should be a command of which person? Sovereign persons. Next one, he opposed what laws? Nothing but precedents. There is no scope for precedents in the Jeremy Bentham's theory of law. Bentham's pleasure and pain criterion judges actions based on how much pleasure or pain they cause. But pleasure and pain are what in nature? Subjective in nature. What in nature? What gives a pleasure to one person may not give a pleasure to which person? Another person. So these pain and pleasure criteria given by the Jeremy Bentham to judge the action of a person is subjective. It is not universal in nature. That is a one more criticism of whose theory of law? Bentham's theory of law. Next one, happiness conflict. What conflict? It is not always true that happiness of certain segment of society leads to what? Increase in overall happiness level. Correct, right? If one person is happy, doesn't mean other person will also be happy. Correct, right? So these are the criticism of whose theory of law? Jeremy Bentham. What Bentham? Now you guys tell me, Jeremy Bentham belongs to what school of law? He is the first contributor to the what? Role of law. What is the role of law? Maximize the happiness of whom? Individual. So that it lead to happiness of whom? Society. Correct, right? So tell me, he has given how many aspects to? What are the 8 aspects? Source, subject, object, extent, aspects. There are how many aspects? There are 2 aspects. And next one, remedial appendage, then force, then expression. Law is an expression of whom? Sovereign. Clear with this? This is about what? Jeremy Bentham. Any question about Jeremy Bentham, you can mention these 8 aspects of laws. Next one, John Austin. Simple say simple, easy be here. John Austin also belongs to what school of law? Positivistic school of law. What school of law? The moment I say John Austin, 2 things should come to your mind. John Austin has distinguished the laws into 2 categories. One is law properly so called and the law improperly so called. Law properly so called means the command of sovereign person. Command of what person? What is law improperly so called? Nothing but morals. Nothing but what? Morals. So he gave command theory of law. What theory of law? Who gave command theory of law? He distinguished the laws properly so called from the what? Morals and other laws which he described as what? Law improperly so called. So he distinguished the command of the sovereign from the morals. He called the commands of the sovereign as what? Law properly so called and the morals as what? Laws improperly so called. Laws what? Improperly so called. According to Austin, law has how many attributes? The 3 attributes: command, sovereign, sanction. What is the command? The law is a command of whom? Superior person. It is a directive from one person to other person, another person. The one who gives the command is called as what? Commander. Other person is called as what? Commanded. Sovereign means what? Politically and legally superior. Politically and what? Sanction, it is the evil consequences that follows on the violation of what? Command. Violation of what? So according to Austin, the law has how many attributes? What are 3 attributes? Command, sovereign, sanction. So wherever the name Austin comes, you should remember or you should write these 3 aspects of law or attributes of law. According to Austin, the law has how many attributes? 3 attributes. What are 3 attributes? Command, sovereign, sanction. Criticism of Austin's command theory of law. What is the first one? Obviously, he has neglected what legislation? Social legislations, because all laws need not be a command. There may be laws which provide benefit to the what? Societies. Those are not covered by whom? Austin. Next one. Austin proposition that sovereign does not have to obey anyone is not always what? True. In the modern laws, what laws? Even the sovereign is governed by the international laws. What laws? Correct, right? So this proposition of Austin, proposition of whom? Law that the law is always a command of superior person and is not bound by any other law is not correct. Third one, he did not provide for what laws? He did not provide for what laws? Judge-made laws. What laws? Judge-made laws are also called as what? Also called as what? Precedents. Austin theory requires what? Sovereigns. Correct, right? Because he believes that law is a command of which person? Superior person, a sovereign. But there are many laws for which there is no sovereign. For example, international laws. What laws? They are just based on mutual agreement. What agreement? So this is the one more criticism of whose theory of law? Austin's theory of law. First point you write about Austin. He belongs to what school of law? What school of law? He is known for what theory of law? Command theory of law. He classified laws into how many categories? What are the 2 categories? Law properly so called, law improperly so called. Law improperly so called. How many attributes of law? What are 3 attributes? Command, sovereign, sanction. Clear with this? Next one, next term. John William Salmon. He belongs to a different school of law. He belongs to natural school of law. What school of law? He is a prominent law professor and a Supreme Court judge in which country? New Zealand. He believed that the main purpose of the law, what of the law? To deliver the what? Justice. So John John William Salmon believes that the main purpose of the law is to serve what? Justice, the dharma in the society. Salmon defined the law as a what? Body of principles. Body of what? Recognized and applied by the state in delivering the what? Justice. There is no concept of command here. Correct, right? He believes that law is already there in the society. The duty of the state is to identify them and apply them for what purpose? Delivering the justice. Delivery of what? That is the definition of law given by whom? Salmon. And Salmon belongs to what school of law? Natural school of law. In natural school of law, what is the main element? Providing the what? Justice. Justice is the key element, or justice is the main element. Clear with this? He distinguished a law and what law? The law. A law means what law? Specific laws. What laws? A law means what laws? General laws. What laws? Nothing but the broader legal concepts. When I say criminal laws, the laws. When I say BNS, a law. Clear with this? Next one. He believes that laws are secondary in nature. What in nature? And can exist independently of strict legal codes, although this is not ideal. So he believes that there is no requirement of law. There can be a delivery of justice even without what? A codified law. What law? So there can be a delivery of justice even without what? Codified law. That is what who believes? Salmon believes. And he has given more importance to the word justice, equity, and good conscience. What is that? Justice, equity, and good conscience. According to him, what is the role of law? To deliver what? Justice. And what is law? Body of principles which are recognized and applied by who? State in delivery of what? Justice. So he belongs to what school of law? He is from which country? New Zealand. Jeremy Bentham belongs to which school of law? Hostile belongs to which school of law? Positivistic school of laws. Court can deliver justice even without specific laws. Correct by what? Principles of equity and good conscience. Principles of equity and what? Good conscience. However, a structured legal framework is preferable. His contention is that courts can deliver the justice even without what? A specific laws guided by justice and equity. But however, he also advocates that there should be a proper legal structure. What structure? Proper legal structure. Criticism of Salmon theory, obviously the first criticism is that there are so many laws which are unjust. So it is not always true that the law is always serves the what? Justice. So there are few laws which are still unjust, but still they are legally valid and enforceable. This is the first criticism. Salmon argument that justice is the ultimate goal of law does not always hold true, as there are many laws that can be considered as what? Considered as what? For example, Jallikattu. Correct, right? So there are bullfighting. This may sound not justified. Correct, right? Which allows the fighting with animal or injuring the animals. There is no concept of justice over there. But still, is allowed or not allowed? Allowed, lawful. So it is not always true that the law serves the justice. Next one, the pursuit of justice not only the aim of law. The law serves what purpose? Various purpose. Nowadays, the law serves various purposes like providing benefit to the society or preventing unlawful activities. So the proposition of Salmon that law always serves the justice is not always true. Next one, Salmon claims administration of justice as the purpose of what? Law, but restrict the study of jurisprudence to what? Fundamental principles of what system? Nation's legal system. He is restricting only the jurisprudence into what? Only a particular nation's legal system. But however, justice is a what concept? Universal concept. What concept? If justice is the universal concept, then his theory should have universal application, right? But he is restricting his study only for what? A particular nation. That is why this is the one criticism of whose theory of law? Salmon's theory of law. What theory of law? Salmon theory of laws. Are you guys clear with this? So can you write about Salmon if they ask question in the examination? He belongs to what school of law? He is from which country? According to him, what is the purpose of the law? Delivery of justice. Is the law is a command or it's just identified and applied by the state? For what purpose? serving the what? Justice. Clear with this? We discussed three theories. How many theories? What is the first theory? Jeremy Bentham. Second one? Third one? John William Salmon. Then comes the Roscoe Pound, important author. He is also one more important author based on which we can expect questions in the examination. He belongs to which country? He is an American legal scholar. He is a key figure in the development of what? Sociological jurisprudence. What jurisprudence? So he belongs to what school of law? Pound linked the work of the lawyers to that of what? Engineers, aiming to create what? Society that efficiently meets the needs of its what? Members. So he linked the work of the lawyers to the work of whom? Engineers. Both try to create a structured system. What system? Structured system for a smooth functioning of what? Society. Advocates try to devise a system for the smooth functioning of society. Engineers try to devise a system for smooth functioning of what? Machines or any other things. Correct, right? So he linked. Who linked? He linked the work of whom? Lawyers to the work of whom? Engineers. Requirement of successful legal order important. According to him, to have a successful legal order in the society, there are three requirements. What is the first one? Recognition of what? Interest. Second one, definition of what? Limits. And the third one is what? Securing the interest. The state first should identify the interest. What do you mean by interest here? Rights. The state should identify the interest of the society, individual as well as the public, and they should provide the limit or the boundary within which those rights can be enforced. And the third one is those rights should be secured or protected within the defined boundary. What boundary? Defined boundary. For example, we have fundamental rights. What rights? That is the right of individual. You have freedom of speech, but with reasonable restriction. What restriction? Right is identified. There is a limit, and that right is secure. If there is a violation of right to freedom of speech, can you go to the court? Can you go to the High Court or Supreme Court? Can you approach High Court or Supreme Court if there is a violation of your fundamental right? Yes. So this is the requirement of successful legal order as per whom? Roscoe Pound. What Pound? So you should write these points in the examination for sure. As per Roscoe Pound, for a successful legal order, there is a requirement of how many things? Three things. What are the three things? Identify the interest, recognize the interest, define their limits, and also secure those interests. Let's read. Acknowledging the individuals, public, and what interest? Social interest. Definition of what? Limits. Establishing the boundary within which these interests are to be what? Identified and upheld by the law. Ensuring that recognized interests are protected within the what? Defined limits. What limits? Defined limits. Yes or no? So these are the what? Three requirement of what order? Successful legal order. What order? Successful legal order. So according to Pound, what are the three requirements of successful legal order? Recognition of interest, definition of limits, third one, securing those interests. Pound suggested that following steps will determine the what? Focus of what system? Legal system. What is the focus of a legal system for a successful legal order? First one is preparation of inventory of interest. Identify the interest, prepare those inventories. Second one is what? Selection of interest. What of interest? Select the interest of individual, interest of society, interest of public. One is what? Demarcation of limits for securing the interest so selected, and consideration of the what? Means exploring how the laws can effectively secure the selected interest. Developing the principles to evaluate the importance of what? Different interests, like which interests are more important in the society. See, that can be individual interest, so society interest as well as the public interest. You have to balance all the interest for what order? Successful legal order. What order? Successful legal order. The most important part in the Roscoe Pound's theory of law is classification of interest. What of interest? Classification of. See, either they may ask you to write a short note on Roscoe Pound's theory of law, or they may ask you to write classification of interest given by whom? Roscoe found. What is the first one? The interest can be classified into how many categories? Three categories. What are the three categories? Individual interest, public interest, social interest. Individual interest, nothing but what? Interest of the individual, family rights, property rights. All these are come under which interest? Individual interest. What interest? These interests are determined from the standpoint of individual's life and the concern. They are interest of the personality, interest of personality, interest in domestic relations, and interest of substance. Nothing but the properties. Correct, right? Family interest, interest of substance, as well as the individual interest, like personal right, right to freedom, right to liberty. Correct, right? Next one, public interest. What interest? Public interest is the interest of the state as a juristic person, as well as the interest of the state as a protector of what right? Social rights. What rights? That is called as what? Public interest. What interest? Public interest. The state, the role of the state, the rights of the state as a protector of the society rights or social rights, and also as the protector of what? Juristic person. Next, we have social interest. What interest? Nothing but interest of society, the terms of social life, and generalized as the claim of group of what? Social group. What group? It is from the point of view of protecting the general interest of what members? All the members of the society. Establishing parks, construction of roads, construction of dams. All these are the what? Social interest. What interest? So interest can be classified into how many categories? Three categories. What are the three categories? Individual interest, public interest, social interest. Are you guys clear with this? Yes or no? He belongs to what school of law? Sociological school of law. He belongs to which country? Jeremy Bentham belongs to which country? No, there is no. Okay. He belongs to what school of law? Criticism of Roscoe Pound's theory of law asserts that interests are pre-existing. What existing? Pre-existing. But it is not always true. Few rights are not there with the society. They are not there with the individual. Few rights are created by law. What by law? The proposition of Roscoe found that the interests are pre-existing in society is not always true because few interests or few rights are created by law. What by law? Next one. Found theory fails to provide clear criteria for evaluating the what? Interest. And what criteria you are deciding which interest is important, which interest is not important. That criteria is not clearly defined in whose theory of law? Roscoe Pound's theory of law. He gives more importance to whom? Compared to what? Legislature. Who gives more importance to the judiciary? Compared to what? Legislatures. Then which authors gave more importance to legislature? Austin, Jeremy Bentham. Next one. Distinction between interests are what? Doubtful. Which interest belongs to which category is doubtful. And last one, recognizing the new interest often depends on the what? Policy decision rather than a straightforward legal process. It depends upon the approach of the government or the approach of the sovereign. These are the provision with respect to what? These are the propositions of the whom? Roscoe Pound. He belongs to what school of law? Sociological school of law. And Austin belongs to what school of law? Analytical school of law or positivistic school of law. So we discussed how many authors now? Four. Four or five? Four. Is the first one? Jeremy Bentham. Second one, John Austin. Third one, John William Salmon. Fourth one, Roscoe Pound. Fifth one is what? Professor H.L.A. Hart. He is a British legal philosopher. What philosopher? British legal philosopher. He outlined the various meanings associated with the word from positivism. He also belongs to what school of law? Positivistic school of law. And he also believes that law is the command of what person? Superior person. What person? He also believes that law is the command of what person? Superior person. So positivism emphasizes that laws are the command issued by whom? Sovereign authority. What authority? Decisions under the positivism can be deduced logically from the word predetermined rules without needing to consider the what? Social aims, policy, or moralities. So he believes that without considering the social aims, policies, or moralities, we can devise the rules and regulations. Correct, right? Means again, same like Austin, who does not believe in the morals, positive morals. He also states that we can have a legal system which is purely based on the what? Command of a superior person without considering the what? Policy or moralities. Positivism holds that moral judgment, underline the word, moral judgment cannot be proven or defended through what? Rational arguments. Because morals will keep on changing, right? What is a moral to one person may not be moral to whom? Other persons. The morals will change from what? Case to case basis or scenario to scenarios. The law as it is laid down should be kept separate from the what? The law ought to be. What is ought law, sir? Nothing but morals. He has stated that ought laws. What is ought laws? Morals should be kept separate from the law as it is. What do you mean by law as it is? The law made by who? Superior person. What person? Superior person. Next one. Hart argues that legal concepts are distinct from what? Sociological and historical inquiries. What inquiries? Sociological and historical inquiries. These are the propositions of who? First, Professor HLA Hart. Next, we have Hans Kelsen. What Kelsen? Hans Kelsen is also one more important author. He has given the pure theory of law. What theory of law? Pure theory of law. I expect them to ask questions out of this topic. Important here. Hans Kelsen is an Austrian philosopher. What philosopher? So he is known for what theory of law? Pure theory of law. The moment you find Kelsen, the one thing which should come to your mind is norms. Norms. He has conceived the legal system of a country. It's an hierarchy of norms. Hierarchy of what? Norms. And at the highest level, there is a grand norm. What norm? Under that, what do we have? Superior norm. Under that, what do we have? Subordinate. So he believes that a legal system is a hierarchy of norms. What of norms? And he also believes that law is a command. Law is a law. Clear with this? So hence what? Kelsen, he has given what? Pure theory of law. He is a legal positivist. What positivist? And he also focused on what is law is and not what law ought to be, nothing but morals. He rejected the idea that justice is the essential to the law. Correct, right? So he is opposing whom? Salmon. Because Salmon believes the purpose of the law is to serve the world. Justice, arguing that law can be still valid even if they are what laws? Unjust laws. What laws? Unjust laws. Kelsen described the law as what science? Opposed to what science? Natural sciences. Because natural sciences has a what? Cause and effect relationship. What relationship? Natural sciences provides what is the cause and what is the effect. But that is not the case in case of what? Normative science. So he believes that law is a what science? Opposed to which science? Natural sciences. He gave what theory of law? Pure theory of law. According to Kelsen, law is a primary law. What law? Which stipulates the what? Sanction means there will be a punishment for not following that norms. So according to him, what is law? A primary law. What law? Stipulates the sanction. According to Kelsen, norm, sanction is the rules forbidding or prescribing a certain behavior. What behavior? Certain behavior. He saw legal order as the hierarchy of the norms. Important. He saw the legal system or a legal order as the hierarchy of what? Norms. Having what? Sanction. Having what? So sanction is the essential element of a law. Even as per whom? Kelsen. And jurisprudence was study of these norms, which comprised of what order? Legal order. So Kelsen considered the law as a what? Normative science. Law is a primary norm which stipulates the what? Sanction. Kelsen considered sanction as an essential element of law. What element of law? You should also write this point. Kelsen considered that what is the essential element of law? Sanction. Kelsen pure theory of law is based on the pyramidical structure of hierarchy of the what? Norms, which derives their validity from the basic norm. What norm? Yes. And the basic norm is also called as what norm? The grand norm or the basic norms. Under Kelsen pure theory of law, the grand norm does not derive its validity from any other norms. Its validity must be what? Presupposed. It is presumed or presupposed. Correct, right? Every norm derives its authority from the other norms, except the grand norm. The validity of the grand norm is already presumed. It is already there. For example, Constitution of India. What of India? Is the grand norm, the basic norm. Under that, we have a supreme norm. What is supreme norm? The laws made by the legislature. Then we have a subordinate law, that is the law made by the executives by using the powers granted by the legislatures. So he saw the legal system as a what? Hierarchy of the norms. What are norms? At the top level, what do we have? Grand norm or the basic norm. Under that, what do we have? Superior norms. And then what do we have? Subordinate norms. Norms in a legal system. What system? There will be a basic norm. What norm? Basic norm. Under that, what do we have? Superior norms. What norms? Under that, what do we have? Subordinate norms. Top level, grand norm. The validity of the grand norm is not dependent upon any other things. The validity of the grand norm is presupposed. The validity of the supreme norm or superior norm derives from which norm? Grand norm. So superior norms cannot go against which norm? Grand norms. Subordinate norms cannot go against which norm? Superior norms. Clear? And he also considered that what is the important element? What is the important element of a legal law or a legal system? Sanctions. Every law will have what? Sanction. Every law will have. Criticism of Kelsen pure theory of law. What is the criticism of Kelsen's pure theory of law? First one, difficulty in tracing the what? Grand norm. It is very difficult to trace the grand norm in every legal systems. Correct, right? Kelsen did not define how long the grand norm effectiveness should last to ensure the validity of what system? Legal system. He has not given a clear time frame. Kelsen theory ceases to be pure the moment one tries to analyze the what norm? Grand norm. Because the grand norm depends upon the political sciences and other subjects like sociology, history, as well as the morality. Correct, right? Because there is no clear criteria for establishing what norm? Grand norm. Last one, international laws. What laws? They do not sit well with whom? Kelsen's pure theory of laws. And these are the legal theories given by the various authors, 6 authors, which are important from the examination point of view. Either they may ask you to write a short note or they may ask you to write a note on the specific topics. Okay? Who is the first author? He belongs to what school of law? According to him, what is the purpose of the law, role of law? Maximizing the happiness of whom? Individual. Because happiness of individuals results into happiness of what? All. He has given how many aspects of law? What are the 8 aspects? Source, subject, object, extent, aspects, source, remedial appendage, and as well as the expression. So law is the expression of what? Sovereign. Correct, right? Who is second author? Who is the second author? John Austin. John Austin belongs to what school of law? He has given what theory of law? He classified laws into how many categories? What are the 2 categories? Law properly so called, law improperly so called. What are the 3 attributes of law? Human, sovereign, and sanction. Who is the third author? John William Salmon. Belongs to what school of law? What is the purpose of law? Delivery of justice. According to him, a law is a law only if it delivers the what? Justice. And he believes that law, the state should identify and apply the pre-existing laws to deliver the what? Justice. So he believes that laws are there in the society. It's an unconscious growth of the society. Correct, right? And for him, law is a law only if it serves the what? Justice. Justice is the main element. What element? And he also contended that court can still deliver a justice without what law? Pre-existing laws. What laws? Is there a requirement of law? He believes that even without a pre-existing law, the court can deliver the justice based on justice and equity. Justice and what? Equity and good conscience. Correct, right? Next one. Kelson. Kelson is also important. Kelson gave what theory of law? Kelson, what theory of law? Pure theory of law. And wherever the word Kelson comes, what should come to your mind? Norms. There are how many norms? Three norms. What are three norms? Grand norm, superior norm, subordinate norms. Correct, right? And we also discussed one more author. Who's that one more author? Roscoe Pound. Belongs to what school of law? Sociological school of law. Whenever I say Pound, what should come to your mind? Interest. There are how many interest? What are three interest? Individual interest, public interest, social interest. What are the three requirements for a successful legal order? Recognition of interest, demarcation, defining the limits, and securing those interests. Securing those what? So we got the point to write in the examination. Yes or no? Next, we have schools of law. What of law? We have classified the authors into various what schools of law. What of law? Schools of law. What's the first school of law? Natural school of law. Keep this in mind. Natural school of law authors believes that justice or dharma is the essential element of what law. Salmon belongs to what school of law? Natural school of law. Okay. Next one, analytical school of law. What school of law? Legal positivists like Austin. Then Bentham also belongs to what school of law? Analytical school of law. They believe that law is the command of one person, superior person. So it's a command of one person to the other person. The one is called as the commander, other person is called as what? Commander. Next one is what school of law? Historical school of law. These school of law authors believes that law is an unconscious growth. What growth? It is not something which is new. It is already there in the society. The duty of the legislature or the state is to identify them and to apply them to the given situation. Next one, philosophical or ethical school of law. They consider law from the what? Morals point of view. Next, we have what school of law? Sociological school of law. The best example for sociological school of law is what? Roscoe Pound. What Pound? Theory of interest. He considered that for a successful legal order. What order? Three requirements. What are the three requirements? Identification of interest, definition of limits, securing those interests. He compared the work of lawyers to the work of whom? Engineers. So both are trying to derive or devise a or invent a legal system or a system which works smoothly without any confrontation or minimum confrontations. Yes or no? Or minimum conflicts. What conflicts? Minimum conflicts. Next one, realistical school of law. What school of law? You study the law based on how the law functions. One should go to the court, then to the legislature to understand the law. That is what who believes? Realistical school of law. They place more importance to what? Precedents. More importance to what? Than the codified laws. That is what realistic school of law. They believe that if one wants to understand the law, should go to where? Not to the legislatures. Because they believe that court is the one who does the better interpretation of the laws. So these are the various schools of law. If they ask any questions about schools of law, you can manage with the what? Authors. Okay? Next one. How the laws are made effective. See, every law must have a sanction, must have what? Sanction, force behind it. Then how the laws are made effective. How the people are made to follow the laws. What is the first one? Requiring damages. Requiring what? What is damages? Compensation to be paid. What to be paid? So the laws are made effective by requiring the compensation to be paid by the whom? The one who has done the wrong. Correct, right? Second one, requiring one in some instances to what? Complete an obligation. What of an obligation? To complete an obligation which is pending. Specific performance. What performance? Specific relief can be granted, right? Third one is what? Preventing the disobedience. That is injunction, preventive relief. What relief? Preventive relief. Or imposing the some form of what? Punishment. Remember, BNS, Bharatiya, Nyaya Sanhita. What Sanhita? Nyaya Sanhita. What are the forms of punishment? What is the first one? Death, Second one, life imprisonment, imprisonment, forfeiture of property, community service. What service? Community service. Correct, right? So the punishment can be imposed to make the what effective? Laws effective. Then comes the major part of chapter number one, based on which they can ask questions in the examination. Either they'll ask questions based on those six authors, or they'll ask questions based on these sources of law. Simple say simple. There are how many sources of law? Two sources. How many sources? Concentrate everybody. There are how many sources? What are two sources? Primary sources, secondary sources. What are the primary sources of law? Next one is customs. Second one, precedents. Third one, statutes. And the fourth one is what laws? Personal laws. What laws? Secondary sources of law, simple say simple, that is justice, equity, and good conscience. Follow? Everybody must tell what are the primary sources of law? Customs, precedents, statutes or legislations, and the fourth one is what? Personal laws. Let's start. Sources of law. Primary sources. What is the first one? Customs or customary law. Second one, precedents. Precedents. Third one, statutes or legislations. Fourth one is what law? Personal law. Secondary sources is what? Justice, equity, and good conscience. What conscience? Good conscience. Let's start. Primary sources of law. What is the first one? Customs or customary law. The first point you should write in the examination is what is the custom? What is the word? Custom. Custom is an activity. What is an activity? Or the way of behaving or an event which is usual or traditional. Usual or what? In a particular society or in a particular circumstances. I repeat, custom is an activity. What is an activity? Or a way of behaving which is usual or traditional in a particular society, particular circumstances. Or we can also they say that when certain things are practiced again and again in a certain way, it is called as what? Customs. Called as what? So what is custom? An activity or way of behaving or a practices which are practiced since many years. It should be immemorial. Correct, right? That is what called as customs. Most ancient of all sources of law. This is one of the ancient sources of what? Law. Correct, right? Second point मिल गया आपको to write in the examination. What is the ancient sources of law? Customs. Third point, customs have played an important role in molding the what laws? Ancient laws. So we can classify the customs into two categories. Customs without sanction, customs having sanction. See, customs without sanctions are not having legal force of law. They're just called as morals. Called as what? Morals. They're also called as positive morals. What morals? People follow them because of public pressure. What pressure? Respecting the elders. There are so many customs which we follow just because of what? Pressure of the public. Pressure of whom? They're also called as what morality? Positive morality. What morality? They are called as what? Customs without sanctions. Customs which are non-obligatory, and are observed due to the what? Pressure of the public opinion. What opinion? Customs without sanction. Obligatory, non-obligatory. Obligatory, not obligatory. They're also called as what morality? Positive morality. What morality? Then comes customs having sanction, which is important from the examination point of view. Customs having sanction, nothing but they are enforced by the state. Enforced by whom? It can be of how many types? There are two types. Legal customs, conventional customs. What are legal customs, sir? They are the binding rule of law. What rule of law? For example, we have Hindu law, which is based on our custom, how the marriage should happen, how the inheritance happens. That is called as what custom? Legal customs. What customs? Legal custom is a what? Binding rule of law, and they are identified and enforced by who? Court. It's a part of what system? Legal system of the land. What system of the land? Legal system of the land. Then we have these legal customs can be further classified into how many types? What are two types? Local custom, general customs. Bola, how many customs? If it is applicable to a particular locality or geographical area, it is called as what? Local customs. If it is applicable to the entire nation system, it is called as what? General custom. In England, precedents are called as what? General customs. What custom? Local customs means what? particular area or locality. Correct, right? In India, we have a different schools of Hindu law. Mitaxkara school of law as well as Dayavaga school of law, where the custom changes from what? Place to place. They are called as what customs? Geographical custom. But they are legal customs. What custom? And what customs? Legal customs. We're discussing customs, types of customs. There are two types of customs: without sanction, having sanction, two types: legal customs, conventional customs, legal customs, two types: local customs, general customs. Conventional customs are most important, most important. Concentrate everybody. They're also called as usages. Called as what? You find these word usages in the Sale of Goods Act. Which act? See, usages are nothing but the practices which are followed in a particular trade or a particular community, and they become part of a law, or they become applicable as a law only if it is known to both the parties. Known to what parties? Both the parties. And they would be enforceable only if there is a contract. Only if there is a what? Contract. They are called as what customs? Conventional customs. What customs? They're also called as what? Usages. If I am entering into a contract with you, there are few customs which are deemed to be part of it. They are called as what? Conventional customs. What customs? Are also called as usages. Binding due to an agreement between who? Between who? If you don't have an agreement, are conventional customs applicable or not applicable? Not applicable. In conditions to be satisfied, to incorporate what? Conventional customs in a contract. There are three conditions to be satisfied. How many conditions? There are three conditions. Convention is clearly established. Clearly what? That convention must be clearly established without any ambiguity, without any what? Ambiguity, and fully known to whom? Contracting parties. What parties? Contracting parties cannot alter the what rule of law? General law. Cannot go against the general law. For example, Sale of Goods Act. Sale of goods may we have expressed conditions. What condition? Along with that, we also have implied condition. What condition? Correct, right? Implied condition cannot go against what condition? Expressed condition. The general rule of law, it also should be what? Reasonable. Should be, what is the first condition? Clearly established, known to the parties. Second one, cannot alter the general law. Must be reasonable. Must be, only if these three conditions are satisfied, a conventional customs is deemed to be part of a contract and binding upon the parties. So can we say conventional customs are applicable only if there is a, only if there is one agreement? No agreement, no customs are not applicable. Clear with this? These are the concept with respect to what? Customs. Tell me, what is customs? A pattern or a behavior followed in a society or a certain situation. It's called as what? Customs. Customs can be of how many types? There are two types: customs without sanction, customs with sanction. Without sanctions are also called as what morality? Positive morality. Customs with sanction, how many types? What are the two types? Legal customs, conventional customs. Legal customs, how many types? What are the two types? Local customs, general customs. Bolo what customs? Local customs and general customs. Local customs, general customs. When we have conventional customs, binding due to the agreement, there are three conditions to be satisfied. What is the first one? Clearly established and known to the parties, should be reasonable, should not be opposite to the what? General. What law? I believe I have a strong sense that they may ask questions out of conventional customs. What customs? Conventional customs. Requisites for a valid custom. They also ask question based on this. What are the requisites for a valid custom? What custom? In the class, we have discussed in detail what are the requisites for a valid customs. Condition to be satisfied. We discussed various case laws as well. Correct, right? What is the first one? Should be immemorial, followed since many years. Correct, right? Second one, certainty. It should be clearly established. The rules of custom should be clearly established. Next one is what? Reasonable. Should not be against the laws or against the moralities. Next one, compulsory observance. What observance? If there is an alternate available, for example, this prohibition of slaughtering the cow was challenged by the Muslim community, but court held that it is not mandatory custom because there is an alternate available. Either we can sacrifice Five families can sacrifice one cow, or they can sacrifice a what? Goat, sheep. Correct, right? Because there is the alternative. It is not a what custom? Essential custom, or it is not a mandatory customs. Next one, uniformity with what? Law and public morality. What morality? There are so many customs which are banned now, prohibited now, because they're against the public morality. Unanimity of what? Opinion, peaceable enjoyment. What enjoyment? The custom should have been enjoyed peaceably, and there should be a consistency. There should be what? Consistency. It should be followed consistently over a period of time. So I have explained all these things in the class in detail while discussing in the normal classes. Correct, right? Next one, we have the precedents. What is the primary sources of law? First, primary sources of law, custom. Second one is what? Precedents. What are precedents? A set pattern. What pattern? Be followed by the subordinate court in what cases? Similar cases. What cases? Important type based on which they can ask question in the examination. The rules to be followed. What to be followed? Are a principle applied previously by a competent authority under the similar facts and circumstances. A decision of a superior court become a rule of law to be followed by which court? Subordinate court. What court? In a similar cases. What cases? That is called as what? Precedent. Called as what? It's a set pattern. What pattern? Guiding the what conduct? Future conduct. It is the important sources of law. What sources of law? Important sources of law. The principle of law expressed for the first time in the court decision become precedents to be followed as a law in the deciding the problem and cases identical with them in what? Future. Whatever the principle established by the court in a case becomes a rule of law to be followed in the similar cases. What cases? For example, Vishaka guidelines. What guidelines? Vishaka guidelines are principle of absolute liability. What liability? In the MC Mehta versus Union of India case. So where the court has discovered a new principle of law, that becomes the rule of law to be followed by which court? Other courts. In what cases? Similar cases. What cases? It is based on the principle called as stare decisis. What decide is? The principle or the doctrine which support the precedent is called as what? Stare decisis. Nothing but like cases. What cases? Should be decided how? Alike. What is that? Like cases should be decided how? Alike. The rule that co-decision becomes a precedent to be followed in what cases? Similar cases is known as what? Doctrine of what decisis? Stare decisis. Precedent creates a confidence in the minds of whom? Litigants. Confidence in the minds of whom? Litigants. Law becomes certain and known. This is important. They may ask, what is the advantage of precedent? Law becomes certain. What becomes certain? It creates confidence in the minds of whom? Litigants. Will not be any ambiguity. And the third condition or the third advantage is justice becomes equitable and fair. They may ask question in the examination. What is the advantage of precedent? Right? What is precedent? Then right, justice becomes equitable and what? Fair. Second condition. Second advantage is what? Law becomes certain and clear, and administration of it created confidence in the minds of whom? Litigants. Confidence in the minds of whom? Litigants. Are you guys clear with this? Yes or no? Next, we have types of precedent. Types of what? First of all, tell me what is precedent? Decision of a court, which becomes a rule of law, be followed by the subordinate courts. In what cases? Similar cases. Precedent is based on the principle of doctrine of stare decisis. Means like cases should be decided alike. We should have this point ready in the examination. Yes or no? You already thorough with the concept. Now it is the time to remember the points right in the what? Examination. अरे हाँ है ना, that is why I have condensed the 400 pages materials. ICSI 800 pages, class notes 400 pages, short notes 120 pages. Step by step. अरे हाँ है ना, concentrate. Types of precedent. What are types of precedent? What is the first one? Original precedent. बोलो. Simple says simple, name itself indicates it creates a new rule of law. What rule of law? New rule of law. Creates or establishes a original or a new rules of law. Which precedent creates a new rule of law? Original precedent. What precedent? Original precedent. Number of original precedents are what? Small in nature. A new law created and followed in the future is called as what precedent? Original precedent. See, UK system, most of the laws are based on precedents over there. So there are more number of original precedents in where? UK. But in India, we have most of the laws are codified laws, so there are less number of original precedent. What is an original precedent? A precedent which creates a what rule of law? New rule of law. It is called as what precedent? Original precedent. More in number or less in number? Less in number. What in number? Example, the tort. Best example is absolute liability. What liability? Vishaka guidelines. What guidelines? Vishaka guidelines. Till 2013, we did not had any guidelines with respect to prevention of sexual harassment of the women in what place? Workplace. So we were following the Vishaka guidelines till which year? 2013. So in 2013, the Parliament has incorporated those guidelines in the Companies Act itself, where now it is mandatory for a company to disclose in the board report disclose complaint received and complaints pending and complaint disposed in the old report with respect to sexual harassment of women at workplace. Clear with this? What precedent? Original precedent. Everybody, what precedent? Second one is what precedent? Declaratory precedent. Well, what precedent? It's just an application of what precedent? Existing precedent or existing rule of law. That is called as what precedent? Declaratory precedent. When the court declares an existing rule of law or existing precedent valid or invalid, it is called as what? Declaratory precedent. What precedent? It merely reiterate or apply an existing rule of law. It is called as what? Declaratory precedent. What precedent? Declaratory precedent. It merely follow the original precedent. What precedent? Original precedent. The number of declaratory precedents are what? More in numbers. More in what? Because every time a case goes to the court decide valid or invalid, that becomes a what? Declaratory precedent. What precedent? Less in number, more in number. Which precedent reiterate and just apply the existing rule of law? What precedent? Declaratory precedent. Example, application of absolute liability. What liability? In the later cases, it is called as what precedent? Declaratory precedent. Arey bolo, what precedent? What are types of precedent? What is the first one? Original. Second one, declaratory precedent. Concentrate, guys. Concentrate, concentrate. Next one is persuasive precedent. What precedent? Simple says simple. Court are not bound to follow, but court may consider it while deciding the case. That is called as what? Persuasive precedent. What precedent? Persuasive precedent. Courts are not bound to follow, though they may take them into consideration while giving their what? Decision. Giving their what? That is called as what precedent? Persuasive precedent. Only what character? Guiding character. What character? For example, decision of the Tamil Nadu High Court has a guiding character in which court? High Court of Karnataka. High Court of what? Mandatory to follow, not mandatory to follow, not mandatory. But however, court can take it as a reference. Clear with this? What precedent? Persuasive precedent. Have no legal force by itself. It is a historical sources of law. What sources of law? Historical sources of law. Does it has any legal force unless until the court applies it? No. Next one, judges are under no obligation to follow. Under no obligation to what? Follow which precedents? What precedents? Obligated to follow, not obligated to follow. Example, decision of which court? One high court. Has what value in other high court? Persuasive value. What value? Next comes absolutely authoritative. What authoritative? Means the court should follow it. The courts are bound to follow it, whether they like it or not. That is called as what precedent? Absolutely authoritative precedents. Give me an example. Which court decision becomes absolutely authoritative to be followed by the lower court? Decision of which court? Supreme Court. Subordinate court. Bound to follow, not bound to follow. Even if it is wrong, are they bound to follow? Yes. Even if you don't agree with that, even if you think it is not correct, you are supposed to follow it because it is what precedent? Absolutely authoritative precedent. Court must be followed by the judges. Absolutely authoritative precedent must be followed by whom? Judges, whether they approve it or not. Approve it or it comes from a court superior to the court concerned, must be followed by which court? Subordinate court. Every court in India absolutely bound by decision of which court? Superior court. Which court? Then comes conditionally authoritative. Bolo bolo. What is conditionally authoritative precedents? Generally, the courts are bound to follow, but however, court may disregard it. They may not follow it, provided they have a reasons to not to follow. For example, decision of a single bench. What bench? What is single bench or small bench? One judge, small bench, two judges, division bench, three or more judges, full bench. Decision of a single bench is conditionally authoritative before which bench? Division bench. Decision of a division bench is conditionally authoritative in which bench? Full bench. Full bench is supposed to follow decision given by the division bench. But however, if they think it is not correct, they may depart from it by following the reasons or giving the reasons, giving the what? Reason. That is called as what precedent? Conditionally authoritative. Are you what authoritative? Are the court bound to follow it? Yes. Can they depart from it? Yes. Provided they have a reasons to not to follow. What to follow? Reasons to follow. Though clearly binding. These are the precedents. You're supposed to add these words in the examination. In the short notes, those words are not there. Just to make it short. So conditionally authoritative precedent means the precedents, though ordinarily what? Binding on the court before which it is cited, may be disregarded, maybe what? In what circumstances? Certain circumstances. Court is entitled to disregard a decision if it is a wrong one. Which one? Wrong one. That is contrary to the law and the reason. Who can disregard it? Court. That is called as what precedent? Conditionally authoritative precedent. See the major difference between persuasive precedent and conditionally authoritative precedent is that in persuasive precedent, you must give a reasons why you are following it. And in conditionally authoritative precedent, you must give a reasons for not following it. What's the difference? In persuasive precedent, you're not bound to follow, but you may follow by providing the reasons for why you are following it. But whereas conditionally authoritative precedent, are you bound to follow? Are you bound to follow? Yes. But if you're not providing, if you're not following it, are you supposed to provide reasons for it? Yes. These are the various types of precedents. Everyone, tell me what are types of precedent. What is the first one? Original precedent, declaratory precedent, persuasive precedent, absolutely authoritative precedent, conditionally authoritative precedent. Can you write in the examination? Yes or no? Tell me which one create a new rule of law. Fast everybody, which one create a new rule of law? Which one is just a reiteration of an existing law? Declaratory. Which one is mandatory to follow? Which one is though mandatory, but it can be departed if there is a reasons for it? Conditionally authoritative. Very good. We have the doctrines now. Doctrines for the purpose of precedent. What is the first doctrine? Doctrine of what decisis? Stay decisis. What is stay decisis? It's a principle which provides that like cases should be decided alike. Correct, right? This is the doctrine which supports the concept of what? Precedent. Supports the concept of what? Precedent. To stand by decided cases or to uphold the what? Precedents. Adhere to the decision and do not unsettle the things which are already established. Like cases should be decided alike to bring about uncertainty and uniformity in the law. What is the law? Uniformity in the law. Correct, right. If there are precedents that brings certainty, justice becomes more equitable and certain. Because there is a rule which says that you have to follow the same thing. Then justice become more certain, right? Uniformity, right? That is the advantage of having what? Precedents. The doctrine which supports the precedent is called as what? Doctrine of what decisis? Stare decisis. Next one, ratio decidendi. What decidendi? Seen a judgment. There will be two parts. The main reason for which the court has given the judgment in certain way. That main part are the reasons based on which the court has given a judgment is called as what? Ratio decidendi. What decidendi? Yes. As per the principles of natural justice, one of the principle of fair hearing, what hearing? Fair hearing. Our natural justice is the judgment of an executive or a decision of an executive must provide the reasons for the decision. What's the decision? Reason for the decision. We also call it as reasoned decision. What decision? Reasoned decision. So the reason for which decision is given, the core part of the judgment based on which the court has come to a conclusion is called as what decidendi? Ratio decidendi. That is what becomes precedent. That's what becomes what? Precedent. So which part of the judgment becomes a precedent? Ratio decidendi. What decidendi? What is ratio decidendi? Reasons for the decision. Everybody reason for the what? Decision. The underlying principle of a judicial decision, which is only authoritative. The ratio decidendi has a binding authority. What authority? Binding authority. Then we have arbiter dicta. What dicta? What's arbiter dicta? Said by the delivering the judgment. The court may give some analysis, examples, comparisons. All those things are called as what? Arbiter dicta. What dicta? And what dicta? Arbiter dicta. Said by the way, they have persuasive value. What value? Persuasive value. Judicial utterances in the course of delivering a judgment, which taken by themselves were not strictly necessary for decision of the particular issue raised. Judges are not bound to follow them. Are they bound to follow? Not bound to follow them. Not bound to follow them, but they can take the advantage of them. What of them? Advantage of them. That is called as what? Arbiter dicta. What dicta? Correct, right? Same like persuasive precedent. What precedent? Are judges bound to follow them? Did they take advantage of them? These are the three doctrines. Can you write on the exam if they ask any question about doctrine? What is the first doctrine? Ratio decidendi. Sorry, stare decisis. Ratio decidendi. Arbiter dicta. Arbiter. Next one, the third source of law is what? Statutes are legislations. Statute is nothing but what? The laws made by whom? Legislatures. Laws made by whom? As per Constitution of India, Parliament has the power to make a law in India. Using that power, when the legislature makes the law, it is called as what? Statutes are legislation. It is also called as just scriptum. What scriptum? Just scriptum, non-just scriptum. What is just scriptum? Written law. What is non-just scriptum? Unwritten laws. Legislations can be classified into how many categories? Two categories. What are the two categories? Supreme legislation, subordinate legislation. The law made by the parliament is called as what legislation? Supreme legislation. When the parliament delegates the law-making power to the executives, and using this power, when the executives make the law, it is called as what? Delegated legislation or subordinate legislation. What legislation? Correct, right? Even court also have a power to make a law because we don't have an absolute separation. What separation? Absolute separation. In Constitution of India, there is a separation of power. We have legislature, executive, judiciary. They have a different powers. But however, in India, there is no absolute separation. What separation? In some cases, in exceptional cases, one organ performs the functions of which organ? Other organs. For example, executive performs the judiciary functions. We call them as quasi-judicial function. For example, NCLT. What is that? It is not a court. It's a part of executive, but delivering the work. Justice. This is the third important sources of law. What is the first one? What is the first one, everybody? Custom. Second one, precedents. Third one, statutes are legislation. Statutes can be of how many types? Supreme and subordinate legislation. Then we have personal laws. What laws? The laws which are applicable to a particular society or community is called as what? Personal laws. We have Hindu law, Muslims law. Hindu law is based on what? Manusmriti, Smriti as well as Shruti. What is Shruti? What is heard? There are so many sages who had a connection with the God based on the whatever the revelations they got it from the God. They wrote Vedas, Shrutis. They heard it from whom? God, Shruti, and whatever they remembered, Smritis, they taught to whom? Their disciples, Shishyas. Next one, commentaries and digests. There are so many people who have given the commentaries on the laws, these customs. Narada Muni digest, and we have Code of Manus, Yajnavalkya, and Narada. All these are the part of our Hindu law, personal laws. Next, we have what law? Mohammedan law. Muslims follow what law? Mohammedan law. Most of the laws are based on Quran. And who wrote Quran? Muhammad Prophet based on the revelations made by the goddess Gabriel. He wrote the Quran. There are hadiths, there are ijmas, there are qiyas. The actions are percept and sayings of the Prophet Muhammad is called as what? Hadiths. Then we have ijmas. Ijmas is nothing but the what? Opinion of the companions of Prophet. And the sayings of the Muhammad Prophet is called as what? Ijmas, called as what? Ijmas. Then we have Qiyas. What is Qiyas? Analogical deductions made from the sayings of the Prophet as well as the opinions of the companions of the Prophet is called as what? Qiyas. Called as what? Qiyas. Clear with this? Yes or no? Next, we have secondary sources of law. Nothing but justice, equity, good consent. Wherever there is an absence of written law, what law? What law? Written law. Or if there is no clearly established customs, in that situation, the court can decide the case based on the principle called as justice, equity, and good consent. In case of personal matters, what matters? Personal matters. If there is no clear established rules, the court can apply or decide the case based on what? Justice, equity, and good consent. In the absence of any rule of statutory law, keep this in mind. The question of secondary sources of law. Everybody, what source of law? Secondary sources of law come into picture only when there is no statutory law, only when there is no custom, only when there is no what? Custom. In that situation, Indian courts apply the decision of the case, what is known as what? Justice, equity, good consent. The ancient Hindu law had its own version of doctrine of justice, equity, and good conscience. In its modern version, justice, equity, and good conscience as a sources of law owes its origin to the beginning of the war, British administration of justice in India. In the absence of any rule of what law? Hindu law. Or what law? The court have the authority to decide the case based on the principle of what? Justice, equity, good conscience. Now let's see. Justice, equity, and good conscience. Clear with this? This is the secondary sources of law. Then we have sources of what law? English law. What law? Most of the laws are based on precedents over them, which is called as common law. What law? Common law is a just scriptum or just non-scriptum? Just non-scriptum. It is the unwritten law. What law? Tort in India is a just scriptum or just non-scriptum? Just non-scriptum. It's an unwritten law. What law? Unwritten law. Law merchant means what? Nothing but the customs followed in the merchants. The principles of equity, second sources of law. Next, statute law. What is statute law? The law made by who? Legislatures. Law made by who? Then we have mercantile laws in India. What laws in India? What is mercantile laws? Business laws. What is mercantile? Business laws in India. Our business laws are mainly based on what law? English mercantile law. What mercantile law? English mercantile law. Are the acts which are made by whom? Indian legislatures. We have Contract Act, Sale of Goods Act, Partnership Act, Negotiable Instrument Act. Then we have judicial decision. What decision? Precedents. Last one, customs and usages. Customs and what? Tell me, usages are also called as what customs? Conventional customs. What customs? Now everybody should answer my question now. Let us revise. Let's revise all the topics which we have discussed in today's class. Tell me, who gave the Jeremy Bentham belongs to what school of law? Austin, positivistic analytical school of. Who gave command theory of law? Austin. Kelson gave what theory of law? Hence Kelson gave what theory of law? Professor H.L.A. Hart also belongs to what school of law? Positivistic school of law. William Salmon gave who classifies the interest into three categories? Roscoe Pound. He belongs to what school of law? Customs can be of how many types? Customs how many types? What are the two types? Customs without sanction, customs having sanction. Having sanction how many types? What are the two types? Legal customs, conventional customs. Legal customs how many types? What are the two types? Local customs, general customs. Clear with this? Yes or no? Precedents. What are types of precedents? Original precedent, declaratory precedent, absolutely authoritative precedent, conditionally authoritative precedent. Statutes are legislation. How many types? Suprema, Supreme and what? Subordinate. What is the secondary sources of law? Justice, equity, and good consent. Clear with this? And with this, we are done with what? First chapter, sources of law. What of law? Sources of law. I want everyone to concentrate now. I will teach you guys how to write answers in the examination. See, everyone understands the concepts. When it comes to examination, you must remember the point to write in the examination. Yes or no? So, first step is to understand the concepts of law. Second step is to remember the provisions of the law and analyzing the provision. You should write the same thing in the examination. The given question. Let us see what are the type of questions or what are the questions they asked in the previous examination. What I have done, I have compiled a question bank of your study material as well as all the previous year questions topic wise. So we'll get an idea with respect to which topic, what type of questions may come in the examination. For example, Jeremy Bentham. So as per Jeremy Bentham, what is the first question? I want everyone to concentrate and read along with me. We are solving the Skinner's question in the class itself. So when you do second time revision, it becomes easy for you guys. Will be required 1 or 2 days of time for the revision of entire JIGL. Okay, concentrate. Jeremy Bentham claimed that nature has placed the man under the command of how many sovereigns? Two sovereigns. That is pleasure and pain. Pleasure and what? Pain. He also stated that every law may be considered in how many aspects? 8 different aspects. Elucidate these statements. Write a short notes on Bentham theory of law. What theory of law? Any of these questions, first what you will write? You'll write about Bentham, you write about what school of law he belongs to, and happiness theory, conflict of interest, and then you will write the 8 aspects. How many aspects? What are the 8 aspects we discussed in today's class? Source, subject, object, extent, aspects, core, remedial appendage, and expression. Simple says simple. Next comes the Austin. Austin belongs to what school of law? Positivistic school of law. According to Austin, the law is the command of who? That is backed by what? Because he gave 3 attributes of law. The 3 attributes of law: command, sovereign, and sanction. Can you write answer about Austin? He classified laws into how many categories? Another 2 categories: law properly so called, law improperly so called. Clear with this? Next comes John William Salmon. They may ask the question saying that write a short note on what? John Salmon's theory. He belongs to what school of law? What is the purpose of the law? Delivery of what? Justice. Can there be court? Can court deliver justice without a pre-existing laws? Based on what? Justice, equity, and good conscience. Yes or no? Next one, Roscoe Pound belongs to what school of law? Sociological school of law. Critically examine Roscoe Pound's theory of interest. How many theories? Sorry, how many interests are there? Three. Individual interest, public interest, social interest. And for a successful legal order, there are three requirements. What are three requirements? Identification of interest, definition of limitation, securing those interests. You know, right answers for this? Yes or no? Next one, Kelson. Who gave pure theory of law? Who gave pure theory of law? Kelson. Concentrate. According to Kelson, law is a what science? Is it a normative science or positive natural science? Because there is no cause and effect relationship. Discuss kiya tha. Next one, in India, a statute or a law is valid because it derives its legal authority from being duly passed by the parliament and receiving the assent of the president. The parliament and the presidents derive their authority from a norm, that is, constitution. Well, no. From where does the constitution derive its validity? It is presupposed. But however, constitution derives in authority from the people of India. What of India? People of India. Explain which theory of law is based on pyramidical structure of hierarchy. We use this word, right? Yeah. This pure theory of law is based on the what? Pyramidical structure of the norms. At the top level, what do we have? Grand norm. Under the grand norm, superior norm. Under the superior norm, subordinate norm. Are yes or no? Can you write about Kelson? Can you write about Kelson? With examples. Answers, you can follow the same answers. In examination, depending upon the weightage of the marks, either you have to reduce the points or increase the points. That is a skill again. Don't, it's not like there is a set answers for every question. You identify the question, see the weightage, then according to that you write the answers in the examination. Clear with this? Next one, sources of law. Write a short note on sources of law. Just have to classify types of sources of law. We have how many sources of law? There are two types. Primary sources. What are the sources of law? Primary sources, secondary sources. What are the primary sources of law? Customs, statutes, sorry, precedents, statutes, and personal laws. What laws? Personal law, justice, equity, and good conscience. Which one is the most ancient sources of law? Customs. What do you understand the term custom? Behavior or a pattern followed in a society over a period of time. Correct, right? A certain things which is followed again and again in a certain way becomes a what? Customs. You know, write about types of custom. What are types of customs? Without having sanction, how many types? What are two types? Legal customs, conventional customs, legal types, legal customs, how many types? Two types, local customs and general customs. Very good, very good. What are the essential requisite for a valid custom? Can you write? Immemorial, reasonable, certainty, compulsory observance, conformity with the law, public morality, unanimity of opinion, peaceable enjoyment, and consistency. Correct, right? Precedent questions. Listen. Explain the precedent as a source of law. You have to write what are precedents, why it is important, which doctrine supports the precedents, or discuss the various types of precedents. You know, right? Various types of precedents. What are types of precedents? Original precedents, declaratory precedent, persuasive precedent, absolutely authoritative, conditionally authoritative. Very good. Modern Indian law, as administered in the courts, it derived from the various sources, and these sources fall under two heads: primary sources, secondary sources. Judicial precedents are considered as what? A primary sources of Indian laws. Correct, sir? What do you mean by judicial precedents? A judgment of a court which becomes a rule of law to be followed in the similar cases, it is called as what? Precedents. Read the following statement, determine and explain what kind of precedent it is. First one is original precedent, second one is persuasive precedent. What precedent? Because decision of one high court has only what value? Persuasive value. What value? In which court? Other high court. Correct, right? Can you answer if they ask this kind of questions in the examination? Then we have doctrines. We have how many doctrines? Three doctrines. Very good. Awesome. The three doctrines. State decisis, arbiter, dicta. Which one is said by the way? Which one is the reason for the decision? Ratio decidency. Can you write a short note on these state decisis? Distinguish between ratio decidency and orbital dicta. See, whatever the concept which I have not covered in the short notes will come in what? Question bank. So we'll be covering all the questions or all the concepts, one or the other ways. Okay? Difference between ratio decision and what? Orbital dicta. Which one is the reason for the decision? Ratio decision. Which one is the uh, which one is the set by the way? Orbital dicta. Orbital dicta is a standard remark. May aid in comprehending the word circumstances. Purpose. The ratio is the judge decision on the what issue? Legal issues. Orbital dictums are the legal ideas or observations expressed by who? Judges. Expressed by who? Next one, enforceability. Tell me which one is legally binding and enforceable. Ratio decision. Which one is not legally enforceable? Orbital dicta. What dicta? Orbital dicta. Next one, rule. Ratio decision is a what? Norm of law that the judges openly and implicitly treat it as a what? Essential step in reaching the decision. Orbital dicta is a rule of law stands taken by a judge that was not explicitly or implicitly considered as required steps in obtaining is what? Judgment. Means you can take into consideration but not mandated to follow. They may ask this question in the examination. Statute or legislation. Can you guys distinguish? This question is wrong. I think I missed the question. You have to write about uh, legislation as a sources of law. What of law? Sources of laws. Secondary sources or primary sources. Primary source, which you write legislations, types of legislation, supreme legislation, as well as what legislation? Subordinate legislation. Can you write a short personal law? We have Hindu law as well as what law? Muslim law. Hindu law is based on what? Shruti, Smriti, Smriti nahi hai, Smriti. Smriti, Kasturi, what Kasturi? Uh, digest commentaries. Very good. Oil. Next one. Secondary sources. What sources? Secondary sources. What secondary sources of law? Justice, equity, good counsel. Can you write about this? And these are the questions which were asked in the previous examination. What examination? Previous examination. And we have covered all the concepts of your material. Chapter number 1 is done. Which chapter? Chapter number 1. Are you guys clear with this? Student find the first chapter difficult, but first chapter itself is easy to score in the examination. Yes or no? Clear with this now? Chapter number 1. Chapter number what? 1. Correct. Chapter number 2. Before I go to the chapter number 2, do you guys have any specific questions or doubt based on chapter number 1? Legal theories are important. Yes, please. Yes. Grand norm is not a custom. Custom is not a grand norm. In Kelson's theory of law, there is no place for the customs because he belongs to what school of law? Positivist school of law. Positivist school of law author does not take the customs into consideration. For them, huh? Social which there also he also considered that law is a what? Command of a superior person, but which is applied for what order? Social order or legal order. See, grand norm is decided based on the what? Based on the historical development as well as the other political aspects of the country. Okay, so at the highest level, grand norm. Under grand norm, superior norm. Under superior norm, subordinate. Yeah? Yes, please. Original precedents are also authoritative precedent. We can classify original precedent, declaratory precedent into what? Two categories or three categories. Persuasive precedent, or it can be absolutely authoritative, or it can be conditionally authoritative. One decision of a court that can be considered into what? Three categories. If it is mandated to follow, absolutely authoritative. If it is mandatory, but court may depart from it, recording the reasons for it, that is called as what? Conditionally authoritative. Where the court may follow it, may not follow it. That is called as what? Persuasive procedure. Okay? Yes. Chapter number 2, the Constitution of India. The Constitution of India provides the what? The basic structure of the political system of a country. So, under the Constitution of India, we have how many organs? What are three organs? Legislature, executive, judicial. What is the work of legislature? Make the executive enforce the law. Judiciary interprets the rules. First important concept in the Constitution of India is preamble. What is the preamble of Constitution of India? We the people of India solemnly resolve to constitute India into a sovereign, socialist, secular, democratic republic. Secure all its citizens. What? Justice, liberty, and equality, and promote what? Fraternity. Correct, right? So based on this, we may not expect any questions in the examination. So, but however, to be in a safer side, we should remember the ideas which are mentioned in the preamble of the Constitution of India. Preamble of Constitution of India sets out the word aims and aspirations of the people of India. What type of India we want? We want India to be what? Sovereign, socialist, secular, democratic, and republic. It declares India to be what? Sovereign, socialist, secular, and democratic republic, and to secure all its citizens justice, liberty, equality, and fraternity. Correct, right? And it also declares that Constitution has been given by whom? People. Because India is a democratic country. What is democracy? Demo means people. Cracy means what? Power. The people's power thereby affirms the republic character. What character? Republican character of the polity and also sovereignty of the people. What are the people? Sovereignty of the people. These are the ideas which are enshrined or embedded in the Constitution of India. That is in the preamble. Preamble is a part and parcel of Constitution of India and is the basic structure. What structure? Of the Constitution of India. Most important part based on which they ask question many a times in the examination is the structure of our Indian Constitution or our political system. See, in the Kesavananda Bharati versus state of Kerala, majority of the judges held that the structure of our Indian Constitution is what? Basically federal. Basically what? With certain what feature? Unitary feature. Tell me the example of a country which is purely federal. USA. Unitary. UK. Our Indian constitution is basically federal with what feature? Certain unitary feature. So now, what are the features of a federal system? What are the features of a federal system? Dual government. What government? Tell me, in India, do we have dual government? Center and state. First condition is what? Satisfied. Second one, distribution of what? Power. There is a clear distribution of power between whom? There is a clear distribution of power between home, center, and the state. Second one, supremacy of the constitution. In our Indian constitution, what is superior? Constitution is superior. Third condition also satisfied. Fourth condition, independent judiciary. We have a judicial system which is what? Independent from the legislature and executive. Fourth condition also satisfied. Fifth condition, do we have written constitution? Yes, one of the lengthiest written constitution we have in India. And the last one is a rigid procedure to be for the purpose of amendment of Constitution of India. Article 368, Article what? Provides the procedure to be followed for the purpose of amendment of Constitution of India. So our Indian Constitution or political system satisfy all the six features of a federal system. What system? That is why Indian constitution is basically what? Federal with certain what feature? Unitary features. We will discuss why it is called as quasi-federal or why it is called as basically federal but with certain what features? Unitary features. Are you guys clear with the federal features? What is the first one? Dual government. Second one, distribution of powers. Third one, supremacy of constitution. Fourth one, independence of judiciary. Fifth one, written constitution. Sixth one, rigid procedure. As per which article in written constitution of India? Article 368. Very good, awesome. Next one. The peculiar features of Indian federalism are we can why India is called as quasi federal. What federal? First one, our Indian constitution or the Indian political system differs from the US Federation or US political system based on how it is formed. How it is what? Formed. In the USA, the federation is formed by entering into a contract with the sovereign state. What state? There were independent and sovereign states. They all came together, made a contract, and agreed to surrender some of their power to whom? To the federation. That is how the US Federation is formed. But in India, our Canadian system, there were centralized units. Under the British Act, we had what? The provincial state were there, and there was a concept of what system? Unitary system as well. So all these states were combined together. What together? Combined together to form the what? Federation. There is no agreement as such. There is no what? Agreement as such. See, in the US Federation, if any state want to go after the federation, they have to wage a war against the government. They can declare a war. If they win the war, they can go out of the federation. But in Indian constitution, there is no concept of taking a state out of the federations. Even parliament cannot do it. There is no provision in the constitution of India to deal with a situation where a state can go out of the federation. Possible, not possible? Not possible. Parliament can divide a state. Parliament can change the boundaries of a state. But however, parliament cannot remove the state. But however, parliament can annex a state. Means they can add some other states to the Indian country, a territory of India. Clear with this? This is where we differ from what constitution or what federation? US Federation. Next one, position of the state in the what? Federation. They are independent. In the US Federations, the states are independent and they have a what? Separate right. What right? In India, even we have what? Central government. We have a separate government at the center as well as the state. But there is no concept of agreement. Concept of what? Agreement. Citizenship. US, there are dual citizenship. What citizenship? India, single citizenship throughout India. Correct, right? Last one, residuary powers. Means there is a clear distribution of powers in the Constitution of India. We have three lists. How many lists? Three lists. What are the three lists? Union list, state list, concurrent list. Any matter which is not covered in any of these three lists, who has the power to make law? Parliament has the power to make law. But in case of USA, who has the power to make law? State has the power to make law. This is where we differ from what constitution? US constitution. I hope you guys can write answers for any of the question they ask based on structure of Constitution of India. Tell me in which case majority of the judges held that India is basically what? Federal. With certain what features? Unitary features. Which case law? Case on the Bharati versus what? State of Kerala. Are you guys clear with the concept of structure of Indian Constitution? It's basically with certain what feature? Unitary features. We discussed preamble, we discussed the structure of Constitution of India. Concentrate. Next we have what rights? Fundamental rights. What rights? Are below what rights? In that, the first important concept is what? State. Article 12 defines the word what? State. What do you mean by state? State means government and parliament. Below, state means government and parliament of India, government and legislature of each state, and all local and other authorities within the territory of India are under the control of government of India, even if it is outside India. But if it is controlled by government of India, it is called as what? State. Clear with this? What is state? Government and parliament. Government and legislature of each state. All local and other authorities within the territory of India Government of India. There are various case studies in which the court has held several institutions as what? State. I had given the gist of the cases. What are the cases? Gist of the cases. What and all happened in the case? First one, local authorities means it includes what? Municipalities, district boards, panchayats, improvement trust, port trust, mining settlement boards. Clear with this? Second one, electricity authorities are considered as what? State. Electricity board, KPTCL, Westcom, and these corporations, all these are called as what? State. University is an authority. Other authority within the definition of the state, it comes under the definition of the state. Okay. Next one, president is also what? State. While making the order of proclamation of what? Emergency. Only when he is performing this executive function. What mention function? Executive function. State includes what department? Below what department? Income tax department. What department? Income tax department. Is it a state or not a state? State. Next one. Corporation acting as an instrumentality. Remember this, a company or a corporation is acting as an instrumentality or agency of the government. Is it also called as other authority? Yes, it will be considered as a state. Example, we have these ONGC, IDBI, Indian Council of Agricultural Research, Council of Scientific and Industrial Research, electricity boards, National Agricultural Cooperative Marketing Federation of India, Delhi Transport Corporations. All these are considered as what? Considered as what? State. And we have this case law called as Ajay Hasia versus Khalid Mujib case law. Court has given the 6 point test. How many point test? For what purpose? To decide whether authority is considered as state or not. What are the 5 point test? Entire share capital. If entire share capital is held by the government, that gives an indication that that authority may be a other authority. Second one, financial assistance to meet what expenditure? All the expenditure. If government is providing the financial assistance to meet all the expenditure of the corporation, it can be considered as instrumentality or agency of the government. Third one, monopoly status. If it is enjoying what status? Monopoly status. Next one, deep and pervasive control. Who has deep and pervasive control? Government. If a government is having a deep and pervasive control over the corporation or a company, it can be considered as instrumentality or agency of the government. If it's an instrumentality or agency of a government, it is called as other authority. If it is other authority, it comes under definition of what? State. Next one, functions are of what importance? Public importance are related to the government, and department of what is transferred? Government is transferred. If department of a government is transferred to the corporation or a company, it can be considered as instrumentality or agency of the government. Airport Authority of India. It is also what? Other authority. Authority? Clear with this? So which case law has given the 6 point test to decide? Ajay Asia versus Khalid Mujib case law. NCERT is not a state. ICSI is not a state. ICA is not a state. Stock exchanges. What exchanges? Are they state or not a state? Not a state. BCCI is also not a what? State. What is not a state? BCCI is not a state. Judiciary. Judicial functions, not a state. But however, if it is performing the non-judicial function like framing the rules, appointment of judges, these are called as what? State. Means our fundamental rights are available even against the what? Judiciary. If it is performing judicial functions, not a state. Non-judicial function, state. I have discussed many case studies for this. Aresha, no. These are the concept with respect to state. First of all, tell me what you will write if they ask question about state. What is state? Which article? 12. What is state? What is state? Government or Parliament of India, government or state, state legislatures, and all local and other authorities within the territory of India are under the control of government of India. Is electricity board is a state? ICI, ICSL, NCERT, university, electricity board. Panchayat, district board, all these are called as what? State. And if it is a state, it is a duty of the state to ensure what rights? Fundamental rights. What rights? Fundamental rights. Next, we have Article 13. Article what? 13. Important thing. Article 13 gives the teeth to the Constitution of India, or teeth to the fundamental rights. What rights? Fundamental rights. Justifiability of fundamental rights. Everyone concentrate. Article 13. Everybody, what article? Deals with what? Justifiability of what rights? Fundamental rights. What rights? Article 13.1, 13.2, 13.3, 13.4. Justifiability of fundamental rights. It gives the teeth to the fundamental rights. What to the fundamental rights? Teeth to the fundamental rights. Article 13 clause 1 deals with what laws? Existing laws. What laws? What laws? Which provides that any laws which were in existence before the commencement of the Constitution of India, to the extent they are inconsistent with the fundamental rights, valid or void? Right. And when we got Constitution of India? 26th of January 1950. Everybody, which date? 26th of January 1950. So, if that we have many laws, we have Contract Act 1872, Sale of Goods Act 1930. So, if there are any provision in this act which are inconsistent with the fundamental rights, valid or not valid? Not valid. Under which article? Article 13.1. Article 13 to deal with what laws? Future laws. What laws? Article 13 clause 2 provides that state shall not make, who shall not make? State shall not make any law which either takes away or abridges what right? Fundamental right. Any law which is inconsistent or which takes away or abridges the fundamental right to such extent, valid or void? Why? Valid or void? Which article? Article 13.2. Existing 13.1. Future 13.2. Which provided who should not make any law? State should not make any laws. Correct, right? Article 13 clause 3 defines the word what? Law. It includes ordinances, orders, bylaws, notification, rules, regulations, custom, and usages. Yes, then remember the Golaknath case, where the court held that the law includes even what act? Constitutional Amendment Act. Hence, the Parliament does not have a power to alter the fundamental rights. Right, right. To nullify the effect of Golaknath case, the Parliament brought an amendment to the Constitution of India, Article 13. By adding which article? Article 13.4. Article what? 13.4, which provides that nothing in this clause shall affect any amendment under which article? Article 368. Means Constitutional Amendment Act is not considered as what? Laws. And if a Constitutional Amendment Act take away the fundamental rights or abridges the fundamental right, is that law valid or not valid? Valid. A Constitutional Amendment Act. Constitutional amendment, that is what, right? See, law means any law, except which law? Constitutional Amendment Act. That is what Article 13.4 provides. What does Article 13.4 provides? Law means any law, except what law? Constitutional Amendment Act. What does it mean, sir? That means there can be a Constitutional Amendment Act which take away or abridges what rights? Fundamental right. Is that law valid or not valid? Valid. But however, that also challenged in the what? Supreme Court. So to balance between the powers of judiciary and the legislature, the court brought the concept of what? Basic structure. What structure? I follow what structure? So the parliament said, sorry, Supreme Court said, Parliament has the power to alter any part of the Constitution of India, including what rights? Fundamental right, except the what structure? Basic structure. What structure? You can alter any part of the Constitution of India, including the fundamental right, except what structure? Basic structure. So, can Parliament make a law to take away fundamental rights or to abridge the fundamental rights, except what structure? Basic structure. Clear with this? 13.1, 13.2, 13.3, 13.4. 13.1 is what laws? 13.2, 13.3, 13.4. Constitutional, no, that is exemptions from applicability of Article 13.3. Clear with this? Then we have two important doctrines based on which they ask question many times in the previous examination. They may ask They may not ask in the upcoming examinations. So important doctrine, severability, eclipse. What is severability? Simple, say simple. Whenever a law becomes inconsistent with the provisions of fundamental rights, only that part of the law which is inconsistent with the fundamental right is considered as what? Invalid. If that inconsistent part can be separated from the other part of the law, and the other part which is left can still serve the purpose of the law, then the law is what? Valid. It is not the entire law which is considered as what? Invalid. This principle is called as what? Doctrine of severability. Doctrine of what? Severability. A law is void. What is void? Everybody, what is void? A law is void only to the extent of the inconsistency or contravention with the relevant fundamental rights. What right? Relevant fundamental right. Invalid part of the law shall be severed and declared invalid if it is severed, means separable. That is, after separating the invalid part, the valid part is capable of giving the effect to the whose intent? Legislation's interest. There is an apple. In this apple, 95% is rotten. Only 5% is a good part. Is it possible to separate and eat the remaining part? Not possible. It will not serve the purpose, right? What if 50% is rotten, other part 50% is good? Can you cut and separate the rotten part and you can eat the remaining part? Yes, it is what called as what? Severability or separability. Clear with this? Next one. I think I have discussed this next case law. Doctrine of what? Eclipse. What is eclipse? This is applicable for pre-constitutional laws. What laws? Whenever a law is in existence, which were made before the commencement of Constitution of India, to the extent they become inconsistent with the fundamental right, they will what status? Dormant status. Whenever that inconsistency is removed by amendment of the fundamental rights, the dormant part is again revived and will be applicable. That is called as what? Doctrine of eclipse. Doctrine of what? Eclipse. An existing law inconsistent with the fundamental right become inoperative from the date of commencement of constitution, yet is not dead altogether. A law made before the commencement of constitution remains eclipsed or dormant to the extent it come under the shadow of the fundamental rights, become active and effective again if the prohibition brought about by the fundamental right is removed by the amendment to the what? Constitution of India. It means the dormant part of the law become active once again. It is called as what? Eclipse. Doctor Rabar, eclipse. It is not the law is not dead altogether. It is in a dormant position. Whenever that inconsistency is removed by amendment to the Constitution of India, the dormant law becomes what? Operative again. It is revived again. That is called as what? Doctrine of what? Eclipse. Next one is what? Can a person waive his fundamental rights? Earlier, there were judgments or interpretation that a person is the best person to judge his rights, so a person can waive his fundamental rights. But however, in the recent judgments, the court have held that a person cannot waive his what right? Fundamental right. He cannot give up his fundamental right. These are the provision with respect to what? Article 13. Article 13 deals with what? Justifiability of what right? What right? What are the three doctrines we have? We have Article 14. Article what? Article 14 deals with what? Right to equality. Right to simple, say simple. The state shall not deny two things: equality before the law, equal protection of the laws. Below, equality before the law, equal protection of law. Which one is positive? Protection of law. Which one is no? Correct. Equality before the law is what concept? Negative concept. Which one is derived from which constitution? UK and US. Equal protection of the law, US. Equality before the law, UK. Equality before the law is a negative approach which provides that all are equal irrespective of their status, creed, caste, or the social status. Correct, right? Next one. one of the basic feature. What feature? What is the basic feature of Constitution of India? Equality before the law, equal protection of the law. What protection of the law? Equality is a what concept? Comparative concept. You can say you are not treated equally only when you are treated different from the other person. Different from what? Other person. Supreme Court in number of cases has upheld the view that Article 14 does not rule out what? Classification for the purpose of what? Legislation. Remember, there can be a reasonable classification. What classification? Subject to how many conditions? What are the two conditions? The classification must be based on what? Intelligible reason. And there should be a rational nexus between the classification and the object sought to be achieved. I repeat, you have done a classification for a particular purpose. What purpose? Particular purpose. And there should be a connection between the classification made and the purpose to be achieved. Then the classification is valid, and we have discussed a situation where a single person, one person, can be considered as what? A separate class. What class? Separate class. Single person law. Charanjit Lal case. What case? Charanjit case. Remember Charanjit Lal case? Raisa, no. Even a single person can be considered as what class? Separate class. Are what class? Does Article 14 forbids the class legislation? Yes, but does not forbids for classification. Can there be a classification? Can there be a classification? For what purpose? That's what. If there can be a reasonable classification, for what purpose? To provide equality. Provide what? Equality. Permissible classification. Keep this in mind. Permissible classification must satisfy how many conditions? Two conditions. What are they? Must be founded on intelligible differentia, and differentia must have a relation to the what? Object sought to be achieved. इसको बोलते हैं rational nexus. What nexus? There is always a presumption in favor of what? Constitutionality of enactment. See, when you go to the court challenging that a particular law is against Article 14, then you have a burden of proof. You have to provide to the court that it is unconstitutional. Because court always presumes that laws are what? Constitutional. If you are saying it is unconstitutional because it violates Article 14, you must provide evidence to the court. Are you guys clear with this? Yes or no? Which article? Article, what is Article 14 provides? Equality before the law, equal protection of the, correct, right? Within the law. Is it available to every person? Only citizens or any person? Can there be a reasonable classification? Yes. Based on how many grounds? What are the two grounds? Intelligible differentia. What's nexus? Rational nexus. Clear with this, everybody? Yes or no? We discussed three articles. 12, 13. What is 12? 13, 14. Right to equality. 15, important. 15. What is 15? Prohibition of discrimination on the grounds of what? Religion. There are how many articles in this? Sub-articles, clauses? 6 clauses. 15.1 prohibits discrimination based on 6 grounds. 15.2 provides that there should not be any restrictions or disability or restrictions or condition with respect to access and also uses of few things. 15.3, 15.4, 15.5, 15.6 is exceptions. 15.3 special provisions for the advancement of women and children. 15.4 is for the advancement of socially and educationally backward classes, scheduled caste and scheduled tribes. 15.5, 15.6 is with respect to special provisions for these category of people with respect to admission to the educational institutions, including private education institution, but other than minority educational institution. Can you guys write answers if they ask question about Article 15? What is Article 15? Everybody concentrate. Article what? 15 what? Prohibition of what? Discrimination. On the grounds of what? Religion. This article prohibits the whom? State. From what? Discriminating. Against whom? Any citizen. On the grounds only of what? Religion, race, caste, sex, place of birth. How many grounds, sir? Six grounds or any of them. But what if there is any other grounds on which there is a discrimination? For example, allowing only male to work in the mining areas. Is it a discrimination? No, because there is some other criteria taken into consideration. Further, no citizen shall be subjected to any what? DRC, 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 C. What is D? Disability. C. R. Restriction, seal, condition with regard to what? Access to shop, public restaurants, hotel, and places of public entertainment. The use of wells, tanks, bathing arts, roads, and places of public resort maintained only or partially out of what funds? State funds dedicated to the use of the what? General public. What public? Tell me if there is a swimming pool which is open to the general public at large. Can you be restricted access to it just because you are a Hindu, just because you are a Muslim, just because you are a Christian? Can there be a restriction? No. There is a restaurant outside, and the restaurant has displayed a board saying that only Hindus are allowed. Is it a violation of Article 15.2 of the Constitution of India? Yes. Clear? Article 15.3 is what? Everybody, what is Article 15.3? Special provision for whom? Women and children. Women and what? Reservation in bus, free bus for women. Can you challenge it under Article 15.1 saying it is a discrimination based on gender? No, it's a special provision. What provision? Special provision. State can make special provision for the advancement of whom? Socially and educationally backward classes of citizens. What class of citizens? Socially and educationally backward classes of citizens. Scheduled caste, scheduled tribes. Clear? Next one, state can make special provision for the advancement of whom? Socially and educationally backward classes of citizen, scheduled caste, scheduled tribe, with respect to admission to where? Educational institutions, including what institution? Private educational institution, other than what? Minority educational institution. Can you think? Can there be a reservation in the minority educational institution? Christ College. What college? Jain College. Can there be reservation? Can government bring a reservation policy? No. Forget about reservation policy. It's a different, what is it? Article 15.4. The state can make special provision for the advancement of whom? Economically weaker section of citizen with respect to what? Admission to education institution in the world. Private education institutions where it is aided or unaided. Up to how much? 10%. But other than minority educational institutions. So we are discussing what rights? Fundamental rights. Article 12 is done, Article 13 is done, 14 is done, 15 is done. Next comes Article 16. Important. Article 16. Equality of opportunity. Equality of what? Opportunity in the matters of what employment? Public employment. Does it guarantees employment or opportunity for employment? Opportunity for employment. Every citizen of India shall be given in what opportunity? Equal opportunity in the matters with respect to what? Employment or appointment of office under the state in the government post. And further, Article 16 Clause 2 prohibits what? Discrimination. Will prohibits what? Against all citizens on the grounds of what? Religion, race, caste, sex, descent, place of birth, are the residents, or any one of these criteria. Tell me, if a person is denied a job in the government post based on his religion or based on his caste, is it a violation of Article 16.2 of the Constitution of India? Yes. However, there are exceptions in the Constitution of India. First one is what? This is important. Parliament can make a law prescribing the residence of a person within certain locality as an essential condition to be employed in a particular job. Example, for example, government can make a law saying that you should be a resident of Jammu and Kashmir to be employed in the job of government of Jammu and Kashmir. And only who can make this law? Parliament can make this law. Is that law valid or not valid? Valid. First exception. Who can make a law? Only who can make a law? Parliament can make a law. Parliament can make a law that in regard to the class or classes of employment or appointment to an office under the government of a state or union territory under any local or other authority within the state or union territory, residents within that state or union territory prior to such employment or appointment shall be what qualification? Essential qualification. What qualification? Second one, second exception, a provision can be made for the reservation of appointment or a post in favor of backward classes of society or citizens, which are, in the opinion of the state, are what? Not adequately represented. Remember Mandal Commission report. What report? Mandal Commission report. There was a commission called as Mandal Commission, which gave a report to the government stating that there are few community in the society which are not appointed in the what? Government jobs. Mostly at that time, most of the government jobs and most of the jobs in most of the government jobs, high caste communities were employed. So to remove that imbalance, they brought this provision called as what? There can be a reservation in favor of who? Backward classes. What classes? Valid or not valid? Valid. Next one. Next one. Next one. The state can make a law. Who can make law? For the reservation in the matters of what? Promotion with a consequential seniority, means without having regard to the what? Actual seniority in the post. For example, there are two parties. One, a job is reserved for particular category of person, SC or ST. There is one more person who belongs to general category. He has more experience than the scheduled caste or scheduled tribe person. But that promotion is reserved for SC category. Who gets the promotion? Person who belongs to that scheduled caste gets the promotions. Clear? Next one. The state may make a special provision for the reservation in the promotion with consequential seniority. What seniority? In favor of the scheduled caste or scheduled tribes, which in the opinion of the state are not adequately what? Represented in the service under the state. Then we have carry forward rule. What rule? What is carry forward rule? Any unfilled vacancies in a year shall be carried forward to be filled in the next year, and in that particular year, for the purpose of reservation, this carry forward vacancies shall be considered as what? Separate. Purpose of maximum 50% limit. What limit? See, Supreme Court has set a limit saying that the reservation should not go beyond how much? 50%. For that limit, we consider both classes what? Different class. What class? Different class. Next one. These two are two more exceptions. Tell me, is a law is invalid? Listen, is a law is invalid if it provides that any appointment to a religious denomination or any person to hold a post in the religious denomination should belong to a particular religion or a community. Is that law valid or invalid? Valid. It is a what? Oh, exception. It is a what? Exception. Correct, right? For example, appointment to the temples, religious denomination. He belongs to what community? He should be a Hindu. Is this law valid or invalid? Valid. It is saved by Article 16.5. Article what? 16.5. Clear? They may ask practical question in the examination based on these provisions. What is the provision says? A law, everybody, what is that? A law shall not be what? Invalid if it provides that incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belong to one denomination, particular denomination. The law is not invalid. Next one, recent one. The state can make what? Reservations for the appointment or post in favor of what section of society? Economically weaker section of citizens other than the what? Classes mentioned in the clause 4. In addition to the existing reservation, subject to how much? 10% post in each category. What category? Each category. Are you guys clear with Article 16? Everybody, what is Article 12? State 13. Justifiability of fundamental rights. How many clauses are there? Four clauses. 13.1, 13.2, 13.3, 13.4. 13.1 is what? 13.2. 13.3. Definition of law. 13.4. That amendment. 14. Equality before the law, equal protection of the law within the territory of India. 15. Prohibition of discrimination. How many clauses are there? Six clauses. 15.1. 15.1. How many grounds? Six grounds. 15.2. Access. 15.3, 15.4, 15.5, 15.6. Exception. And then we have 16. What is 16? Equality. Equal opportunity in the what employment? Public employment. 16.2. No discrimination. 16.3, 16.4, 16.5, 16.6 is what? Exceptions. Are the exception to Article 16. Article what? 16. 17. Prohibition of untouchability. 18. Abolition of title is not there in our syllabus. We will not discuss. Clear with this? Yes or no? So Article 19.1a. See, Article 19 deals with what? Freedom. And how many freedoms? Three. How many freedoms are there? Six freedoms. What are the six freedoms we have? Sa, M, R, P. What is that? Sa, M, R, P. What is S? Speech. What is A? Assembly. Peacefully. You supposed to, you can assemble peacefully without any arms. Then A, form an association. M, movement. R, recite. P, practice. Out of that, out of these six freedoms, the first freedom is what? Freedom of speech and expressions. Bolo? Freedom of speech and expression, one of the important freedom under Article 19 of the Constitution of India. This provides that every person has a right to express his what? One's convictions as well as the opinion. CRO. That is, convictions are opinions freely, either by what? Word of mouth. Word of what? Mouth, or by writing, painting, pictures, or any other mode. Correct, right? Article 19.1a. Which article? Article 19.1a provides that every person has the right to express one's convictions and opinion freely, either by way of word of what? Mouth, or by writing, painting, pictures, or any other mode. The right to speech and expression includes what? Right to make what speech? Good speech, as well as the bad speech. Right to speech also includes right to not to speak, a right to remain silent. If what you will write if they ask question about Article 19.1a, Article 19.1a provides a right to every citizen of India to express his convictions or opinions freely, either by word of mouth or by writing, painting, or pictures, any other mode. Any other what? Mode. The right to speech and expression includes right to make what speech? Good speech, as well as the what speech? Bad speech, and also not to make a speech or to not to speak. Correct, right? However, as we know, all freedoms are subject to what restriction? Reasonable restriction. What restriction? Important. What are the reasonable restrictions? The state can impose the reasonable restrictions under the following categories. What is the first one? Security of the state. What of state? See now, press as the freedom to report. Correct, right? The freedom of press is also considered as what? Freedom of speech and expression. But however, recently there is a guidelines issued by the Ministry of government, the Ministry of Defense, stating that the medias are restrained from reporting the few sensitive matters or information which are respect to the what? Army, correct, right? That is because of the what? Security of the state. What of the state? Security of the state. So, on the freedom of speech and expressions, there can be reasonable restriction. The first one is what? Security of the state. Second one is what? A friendly relationship with what government? Foreign states or government. Public order. What order? To maintain the public peace. Now there is in Mangalore, there is a what is going on? There is a riot, there is a communal conflict going on. So during that time, the state can restrict the person from making any what speeches to maintain what order? Public order. Correct, right? What is the first one? Security of the state. Second one, friendly relationship. What relationship? Third one is what order? Public order. Fourth one is what? Decency or morality. Well, decency or what? You can paint whatever you want. Doesn't mean you can paint obscene pictures. What pictures? Obscene pictures. Or you can make obscene movies. Correct, right? Next one. So in the decency or morality, there can be what restriction? Reasonable restriction. Next one, contempt of court. What of court? You cannot abuse the court process or you cannot defame the court. Next one, defamation. Next one is what? Remember what is defamation? Any imputation made by a person concerning the reputation of which person? Other person. If it lowers the reputation of other person in the eyes of the public, it is called as what? Defamation. Called as what? So defamation is one of the reason for which there can be what restriction? Reasonable restriction. Next one is what? Sovereignty and integrity of India. For the purpose of maintaining the sovereignty as well as what? Integrity of India. There can be what restriction? Reasonable restrictions. Clear with this? Article can? What is Article 19(1)(a) provides? The every person has a right to express his convictions and opinions. Convictions and what? Opinions. Freely. Either by word of what? Mouth, or by painting, or by pictures, or by signs, or any other mode. It includes right to make a good speech, bad speech, or right to not to make a speech at all. Correct, right? There are subject to what restriction? Reasonable restriction. What restriction? What are the reasonable restriction? Security of the state, friendly relationship with the foreign state, public order, decency or morality, contempt of court, defamation, sovereignty and integrity of India. Bolo bolo what of India? Sovereignty and integrity of India. There can be what restriction? Reasonable restriction. But however, a reasonable restrictions can be imposed only by enacting a law. Only by enacting a what? Law. That too by the parliament. But to by whom? Parliament. So there should be a law which provides the right to impose what? Reasonable restriction. What restriction? Can a reasonable restriction be imposed by executive orders? No. It should be by way of what? Law. Clear with this? Next one, case laws. Imposition of pre-censorship on the media was held to be violation of what? Article 19(1)(a). There was a law putting a restriction or requiring a pre-censorship of the what? Media reports. That was held to be what? Unconstitutional. Violation of which article? 19(1)(a). Next one, commercial speech. What speech? Is a part of what? Freedom of speech and expressions. That is giving advertisement in the newspapers or in the media. Next one, right to know. Right to what? RTA Act, Article 19(1)(a) provides that. See, you can make a speech or you can have a convictions or opinions about something. Only you have what? Knowledge about it. Correct, right? So, right to know. Right to what? Is a part of what? Right to speech. What you will speak if you don't know anything about a particular matter? So, right to obtain the information was held to be part of what? Right to speech. Right to what? Speech. Next one, right to remain silent. Right to remain what? Remember, have I discussed this case law? Bijoy Emmanuel versus State of Kerala. Remembers where the pupils were, they were dismissed because they were not singing national anthem, but court held that it is not mandatory to sing a what? National anthem, but you should not disrespect the national anthem. Correct, right? So, right to speech also includes what? Right to remain silent. Next one, rise to host a what? National flag. This is the basic or classic case because of which now every person has a right to host the what? National flag. That is why we celebrated Har Ghar Tiranga because of this concept. Till Naveen Jindal case, only The government buildings or offices were allowed to host the what? National flags. But after this case, the court held that it is the freedom of a person to express his feeling or affection towards the nation by hosting a what? National flag. That is why hosting a national flag is also considered as what? Freedom of speech and expressions. Are you guys clear with this? So can you write answers if there's question about freedom of speech and expressions? Everybody. Yes or no? Next one, freedom of what? Assembly. Article क्या है? 19(1). Everybody repeat. Article क्या है? Deals with what? Freedom of assembly. Freedom of. So this gives the right to citizens to whom? Assemble peacefully, and it's also what? Without any arms. Are you supposed to? Can you carry the arms and ammunitions? No. But however, Sikhs are allowed to carry what? Kirpans, because it is the essential religious practice. What practice? Essential religious practice. Kirpans are not considered as the arms. Correct, right? So you have a right to assemble peacefully and without any what? Arms. But state can impose what restriction? Reasonable restriction in the interest of what? Sovereignty and integrity of India. Correct, right? You're not supposed to assemble for the purpose of going against the war. Government, there can be reasonable restriction. Next one, public order. What order? What is public order? Public peace. Correct, right? So, for example, political rally or protest in what areas? Sensitive areas. They can put a reasonable restrictions. Now tell me, Article 19(1)(b) provides what? Freedom of peacefully and without arms. Subject to what restriction? Everybody must answer what restriction? What are the reasonable restriction? Sovereignty and integrity of India, public order. What order? Next one, freedom of what? Association. Every citizen of India have a right to form what? Associations or unions. Correct, right? This right includes right to not form association. Right to form what? Can somebody make you or somebody compel you to be part of any association? No, it is your freedom. You can be part of an association. You may not be a part of any what? Association. Do you have the freedom of association? Everybody. Yes or no? The freedom of association includes the freedom to hold the what? Meeting and take out the what? Procession without any what? Arms, without any what? So can we protest somewhere by assembling? Yes. Correct, right? That is nothing but forming an assembly as well as the association. It also includes right to form what? Unions and association, trade unions, trade associations. However, subject to what restriction? Three restrictions. What is the first one? Sovereignty and integrity of India. Same in case of assembly also. Second one is what? Public order. What order? Last one is what? Morality. For example, if the prostitute forms an association or if group of people form a WhatsApp group to do unlawful activities like running a prostitution, can they claim it is a fundamental right to form an association? No. Your fundamental right to form an association subject to what restriction? Reasonable restriction. What is the first one? Sovereignty and integrity of India. Second one, public order. Third one, morality. Are you guys clear with this? Article क्या 19(1)(c). Next one, freedom of what? Movement. Freedom of what? Every citizen of India has a right to move freely throughout the what? Territory of India. Throughout the what? But however, you cannot go to where? Abroad. As per this article, but however, right to life includes even right to travel abroad also. We'll discuss that later. Subject to what restriction? Reasonable restriction. What is the first one? General public. Interest of what public? Correct, right? You can move wherever you want. Doesn't mean you can move in the middle of the road. Correct, right? Or if for example, you are stopped in a signal, can you say it's a freedom of movement? I have a right to move. Why are you stopping me in the signal? No, because it is the interest of what? General public. What public? Making like if there is a law which mandates wearing a helmet compulsory for riding a bike, is it a violation of your right to move? No, it's a what restriction? Reasonable restriction for the protection of what tribe? Scheduled tribe. What tribe? If you're not allowed to Andaman or Nicobar because there are scheduled tribes, right? Is it a violation of your fundamental rights? No, it is an exception. It's a reasonable restriction. What restriction? What are the freedom we are discussed now? What is the first one? Freedom of what? Speech and expression. Second one, third one, association. Fourth one, freedom of movement. Next one, freedom of what? Residence. Freedom of what? Can you reside and settle in any part of India? I'm a Kannadiga. Can I go and settle in Tamil Nadu? Is it my freedom? Can they say, no, you are a Karnataka person, you're not supposed to stay in Tamil Nadu? No. Can Maharashtra person come and stay in Tamil Nadu? Sorry, Karnataka? Because you have a right to move freely throughout the territory of India, and you also have a right to settle and reside in any part of India. Arre bolo, what part of India? But however, subject to what restriction? Reasonable restriction. What is the first one? General public. What public? Can I say, can I stay on the footpath? Can I erect a temporary hut and stay in the footpath or any public areas? Why no? The police can remove a particular area because it's in the interest of what public? General public. What public? Next one for the protection of interest of what tribe? Scheduled tribe. What tribe? Now I am fed up with society. I want to go settle in the forest. Can I go and settle in forest? No. In the interest of what? Scheduled tribe. There can be what restriction? Reasonable restriction. What restriction? Are you guys clear with Article 19(1)(e)? Everybody? Or yes or no? Next one, last freedom. Article 19(1)(g). Everybody concentrate. Article 19(1)(g). Freedom to what? Trade and occupation. Trade and what? Tell me, every citizen of India have a right to carry what? Lawful trade, professions, or any occupations. Yes or no? Correct, right? Article 19(1)(g). But however, who can impose reasonable restriction? State. In the interest of what? General public. What public? Examples are during the COVID time. What time? There was a restrictions on freedom of carrying a lawful business or trade. All the shops were shut. Yes or no? Is it a reasonable restriction? Yes. In the interest of what public? General public. Now to become to carry the profession of CS, it should be what? CS should be what? So if there is a law which requires a professional qualification for the purpose of carrying any profession, is it a violation of fundamental right? Article 19(1)(g)? No. So there can be a requirement of what qualification? Technical qualification. What qualification? Any law which requires a technical qualification to practice a profession, it is not called as what? Violation of Article 19(1)(g). However, state can create a monopoly. Who can create monopoly? State. State can create a monopoly in the interest of what? Public at large. So any law which create monopoly, is it allowed or not allowed? Allowed. It is not a violation of Article 19(1)(g). Article 19(1)(g). Are you guys clear with this? So which articles deals with freedom of trade, occupation and profession? Article 19(1)(g). Everybody tell me there are how many freedoms? 6 freedoms. How many freedoms? What is the first one? Speech and expression. Second one, assembly. Third one, association. Fourth one, fifth one, reside and settle. Sixth one, practice any profession, trade or what? Occupation. Yes. Does right to speak also right to remain silent? Freedom of press. Come under which article? 19(1)(a). Which article? Article 20 is important. Article 20, everybody concentrate. Article 20, protection in respect of what? Conviction for offenses. Convictions for? Regular convictions for what? There are 3 protections. How many protection? 3 protection. What are 3 protections? Ex post facto laws. Second one, double jeopardy. Third one, self-incrimination. What incrimination? What is the first one? Ex post facto loss means no person can be convicted for an offense. No person can be convicted for an offense except for violation of an act, violation of a law, or the rules which was in force when that alleged act was committed, nor he be subjected to any penalty greater than that of which could have been inflicted on him at the time when what was committed, offense was committed. What was committed? Offense was committed. Correct, right? It is called as what? Protection against ex post facto loss. What loss? Example, no person shall be convicted of any except for the violation of law in force at the time of commission of the act agreed as charged as an offense, nor be subjected to a penalty greater than that which might have been what? Inflicted under the law in force at the time of commission of the what? Offense. Commission of the what? what was not an offense cannot be made an offense by a new law. Because laws will always have what effect? Prospective effect. What effect? Next one, even the penalty for the commission of an offense cannot be increased with what? Retrospective effect. What effect? Are you guys clear with this? This case law is important. CBI versus RR Kishore case law. I expect them to ask question based on this case study. Listen, everybody. Supreme Court in Satendra Kumar actually held that once a law is declared unconstitutional, what is declared as unconstitutional? Law. For example, let's say a law has been made. The law has given the power to the police officer to arrest. He has done the arrest, but later the law was challenged in the court. Court declared that law to be unconstitutional. If a law is declared as unconstitutional, tell me the arrest made. What made? Is it valid or not valid? Not valid. Because once a law is declared as unconstitutional, the law is dead from the inception stage itself. Means it is void ab initio. Void ab what? Initio. Any act done under the law which is declared as unconstitutional, is it valid or not valid? Not valid. That is what held in which case law? Satendra Kumar case law. Which case law? The court emphasized that if a law is found to be violative of which part? Which part? Part 3. Part 3 of the Constitution deals with what rights? Fundamental rights. It is deemed to be stillborn. What is stillborn? It is not born. It is not valid. Correct, right? Unenforceable and non-existent in accordance with which article? Article 13 clause 2. In line with Subramaniam Swamy case, the court declared that Section 6A of the TSP Act would be treated as what? Not in force. From its insertion date, it is as if the provision never existed, and thus any action taken, what taken? Under it is valid or legally invalid? Legally invalid. Legally what? Because once a law is declared unconstitutional, it is declared or deemed to be void from the what? Starting itself. What itself? Starting itself. Void and initio. Clear with this? Next one. Protection against what jeopardy? Double jeopardy. Arey bolo what jeopardy? Everybody must answer. Hello, what jeopardy? What is double jeopardy? A person cannot be convicted twice for the one offense, same offense. No person shall be prosecuted and punished. Remember these words: prosecuted and punished. How many times? For what offense? Same offense. Or what offense? Right, right. This is called as protection against what jeopardy? Double jeopardy. No person, everybody, future CS, no person can be prosecuted or punished for what offense? Same offense, more than what? Once. It is, however, to be noted that conjunction and is used. What if a person is prosecuted but not punished? Can he be prosecuted and punished one time? If a person was prosecuted because of lack of evidence, he was let go of. But what if the police officer finds the evidence again? Can he be prosecuted and punished? Yes. Why? Because this protection is available only when you were prosecuted and punished. Clear with this? Yes or no? Which article we're discussing now? Article 20. Article what? Next one. Protection against what incrimination? Self-incrimination. What incrimination? Concentrate, concentrate. No person accused of any offense shall be compelled to be a what? Witness against himself. Means nobody can be compelled to give a witness or evidence which goes against himself. Or nobody can be compelled to be a witness in his what case? Own case. This is the one more right available to whom? Person. This protection is available only when how many conditions are satisfied? Three conditions. How many conditions? First one is you should be accused of what? Offense. Vulnerable accused of what? What if a person is accused, not accused of an offense, and if he is supposed to give an evidence, is this article applicable or not applicable? Not applicable. Only when a person is accused of an offense. Second one, there should be a compulsion to be a witness. What to be a witness? Compulsion to be a witness. Such compulsion should result in giving a evidence against what? Himself. Evidence against what? If all these three conditions are satisfied, it amounts to what? Self-incrimination. What incrimination? In that situation, can a person claim Article 20, Clause 3? Yes or no? What is Article 20, Clause 3? Section against self-incrimination. So how many conditions? What are the three conditions? Accused of an offense, compulsion to be a witness, such compulsion should result in giving an evidence against himself. Arey sir, no. This point is important. This point is important. If the person was not accused when he had made a statement, or the statement was not made as a witness, or it was made by him without the compulsion, does not result as a statement against him, then the protection available under this provision does not extend to such person or to such statement. Clear with this? You are not accused of an offense, but you are compelled to be a witness. Is it a violation of Article 20, Clause 3? No. Only when all the three conditions are satisfied, this protection is available. Protection against what incrimination? Self incrimination. What incrimination? Are you guys clear with this, everybody? Yes or no? Next one is protection of life and personal liberty. Bolo. Life and what? Personal liberty. Alright, first of all, before you go to the next topic, tell me Article 12, state 13. Justifiability of what right? Fundamental right. What right? 14. Equality. 15. Discrimination. 16. Equality of opportunity. 17. Untouchability. 18. Titles. 19. Freedom. 19(1)(e). Speech and expression. 19(1)(b). Assembly. 19(1)(c). Association. 19(1)(d). 19(1)(e). 19(1)(g). Trade, profession, or business. 20. Protection against conviction for offenses. What is the first one? Ex post facto law. Second one, double jeopardy. Third one, based on this Article 20, they ask questions many times in the previous examinations, especially double jeopardy, self-incrimination, and also ex post facto laws. Can you write? See, writing, we are already thorough with the concepts. Correct, right? We have discussed many case studies in the class. And now the question is remembering and writing the provisions in the what? Examinations. Are ha, you know? Yes or no? Next one. Protection of life and what liberty? Personal liberty. Right to life. What is right to life? Right to live in the society peaceably. Correct, right? Right to life is a wider term. What term? Wider term. Right to life doesn't mean just to live. You have a right to live with human dignity. You have a right to good environment, a right to access to the water, access to the food, the basic living facilities. All these are deemed to be part of what? Right to life, right to sleep, right to choose a life partner, right to choose your gender. All these were held to be part of what? Right to life. Right to what? Life. You have a right to adopt. Right to what? Adopt. Subject to what restriction? Reasonable restriction. See, tell me, right to adopt. Is it a fundamental right? Is it a fundamental right? Yes. Right to life also includes what? Right to adopt. That makes your life meaningful. Yes or no? Do you have a right to choose your life partner? Yes or no? Do you have a right to decide your gender? You can select any gender you want. अरे हाँ ये ना that is as per what? Article 21. Right to life doesn't mean just right to live. It also has a right to live. Are beta, no discussions, only concepts. Listen, right to live also includes right to live with what dignity? Human dignity. It also includes right to privacy. Right to what? Right to what? So right to life includes everything that makes right life meaningful. What meaningful? Life meaningful. Right to sleep is a fundamental right. What right? What right? Fundamental right. But however, this is subject to what? Reasonable restriction. What restriction? Do you have a right to adopt? But can if you are a bachelor, if you are a what? Bachelor, can you adopt a gun child? That is a reasonable restriction. What restriction? Yes. Are you guys clear with this? Yes or no? So let's start. No person shall be deprived of his life or a personal liberty except according to the what? Procedure established by law. Everybody, what established by law? What do you mean by procedure established by law, sir? Listen, everybody. There has to be a law. Law must be valid, and the conditions which are given in the law must be strictly obeyed. Only when all the three conditions are satisfied, that is considered as a reasonable restriction, then it is allowed. Correct, right? For example, do I have a right to liberty? What is liberty? Freedom of movement. I cannot be subjected to any restrictions. I can move freely. And liberty doesn't mean not only a physical restraint, it can also be what? Even the emotional restraint as well. What restraint? Emotional restraint. For example, I made a contract with you saying that you should not go out of Bangalore. I will pay you 1 lakh rupees. Is this condition valid or not valid? Not valid. Why? Because it is a what? Violation of Article 21. Article what? 21. Personal liberty. What liberty? Personal liberty. But there can be a restriction. What restriction? Reasonable restrictions on the life and liberty of a person, provided it is as per the what? Procedure established by law. What do you mean by procedure established by law? There must be a law. There must be what? Which is justifying the interference with the person's life or personal liberty. The law is justifying the interference by the executives with the life or liberty of a person, and that law must be what? Constitutionally valid. How valid? And the thirdly, the procedure laid down by the law should have been strictly followed. Strictly what? Followed. Now tell me, a police officer arrested a woman after sunset. After what? Sunset. After what? Sunset. Even though it's a minor offense. Tell me, is this arrest a violation of fundamental right? Article 21? Yes. First of all, I have freedom of what? Right to liberty. Right to what? You are interfering with right to liberty. Is there any law, sir? Yes, there is a law which allows the interference with the personal liberty of a person. There is a BNS. What is that? Which allows the arrest of a person. But BNS says that women cannot be arrested after sunset. After what? You are violating the conditions of the BNS. Is this arrest valid or not valid? Because it is not as per the procedure established by law. Are you guys clear with this? Which article? Article what? 21. Right to life and personal liberty. No person can be deprived of his life or personal liberty except as per the what? Procedure established by law. Are below what established by law? Subject to reasonable restriction, that is as per the procedure established by law. How many conditions? Three. There has to be a law justifying the interference with what right? Fundamental right, liberty or life. Second one, the law should be constitutionally valid. Third one is what? Procedure laid on must be strictly followed, strictly followed. Case laws, listen everybody. Right to life. I want everyone to read with me. Right to life includes what? Those which makes it what? Life meaningful. Right to life includes what? With human dignity. Personal liberty is not limited to bodily restraint. It also includes what? Confinement or prison. It also includes even a emotional restraint as well. Next one. Right to travel is included within the expression personal liberty. What liberty? Personal liberty. So denial of passport amounts to violation of your fundamental right unless it is as per the procedure established by law. What established by law? Procedure established by law. Right to go to abroad. Right to go to where? It is also considered as right to liberty. Right to privacy is a part of right to life. Live telecast of court proceedings. Now, Supreme Court holds that any matters which are having a constitutional, all the constitutional matters which have an impact on the life of the persons should be live telecasted because that makes the life of the persons more meaningful. Correct, right? Based on this judgment, now there is a live telecast of what? Supreme Court and High Court proceedings if they are of constitutional importance. ठीक है? Next one, Article 21A. Article का क्या है? What is Article 21A? Right to education. Right to who shall provide the free and compulsory education? Who should provide the education? State. To whom? Children of the age of how many years? 6 to 14 years. 6 to in such a manner as the state may by law determine. Here it is a quality education. What education? Not having a qualified teachers in a school, it amounts to violation of what right? Article 21A. Quality education without any what? Discrimination. Right to have access to internet. It also considers part of right to education. Right to what? Then comes Article 22. Everybody, Article 22. Protection against what? Arrest and detention. Arrest and what? There are a few protections available to a person who has been arrested and the person who has been detained. Detained, house arrest, correct, right? In case of arrest, there are three rights. How many rights? What are three rights? Right to be informed, right to be produced before the magistrate, and right to have an access to the what? Advocate of his choice. What of his choice? Advocate is of his choice. Is it available to an alien enemy? This right, protection against arrest, is not available in case of what? Alien enemy. What enemy? Everybody. Does not apply to whom? What enemies? Alien enemies. Person arrested or detained under which law? Preventive detention laws. How many rights? What are the three rights? Right to be informed. Right to be. Every person should be informed the grounds of his arrest as soon as what is made. Arrest has been made. Next one. He has a right to consult. Right to what? And to be defended by what practitioner? Legal practitioner. What practitioner? Of his choice. He should be produced before whom? Within how many hours? Of what? Arrest. These are the three rights and protections available in case of arrest. Then comes detention. What detention? Preventive detention. First of all, what is preventive detention? It's a detention of a person before he commits a what? Offense. And without a trial, without any what? Trial. So here, you are not arresting a person because he has done an offense. You are arresting a person because to prevent him from what? Committing an arrest, committing an offense. Correct, right? Yes or no? Preventive detention means detention of a person without any what? Trial. The objective of preventive detention is not to punish a person, not to punish a what? For having done a something, but to prevent him from what? Doing it. Prevent him from what? Either in this case, no offense is proved and no charge is formulated, but still a person is detained, prevent him from committing a what? Prohibited act. Now, in this case, who has the law? Who has the power to make a law for preventive detention? Both Parliament and state has the power to make a law for what detention? Preventive detention. Parliament has the power to make a law for preventive detention for reasons with respect to what? Defense, foreign affairs, security of India. Hello? Defense, Foreign Affairs, Security of India. Parliament and state have a power to make a law for a preventive detention for reasons connected with the security of the state, maintenance of public order, maintenance of supplies and services essential to the what? Community. For example, Omar Abdullah was detained almost for a year, more than a year, during the abrogation of Article what? 370. Preventive detention. What is the detention? Preventive detention. Article 370, right? Yes or no? Next one. Safeguard in case of preventive detention. What detention? Preventive detention. For example, let's say there is a Arshita is planning to commit a she's trying to provocate the public go against the government. Go against the what? Government. Now what police has done? She has been detained now. Who has been detained? Arshita has been detained in the police custody. Is she detained because she has done an offense? Or is she detained because she is going to commit an offense? Can she be detained? Yes. But once she is detained, she can be detained only for how many months? 3 months. If the government want to detain her beyond the 3 months, they have to form a what committee? Advisory board. What board? Advisory board shall consist of what judges? Retired judges of the High Court are person qualified to be what court? Judge of the High Court. So she can be detained beyond 3 months only if the board, advisory board has opinion that it is required. Beyond how many months? 3 months. How many months? And who can set a maximum period for preventive detention? State. The parliament can state the maximum period. Authority ordering detention must inform who? Must inform who? Detainee. The one who has been detained should be informed the what? Reasons for detention. What for detention? Reason for detention. And the detainee should be given an opportunity to make a representation to whom? Court. As soon as possible. As soon as what? Possible. Yes or no? However, certain facts that may harm the public interest. What interest? What interest? May not be disclosed to the whom? Detainee. These are the protection available to a person who has been detained under the preventive detention laws. What laws? Preventive detention laws. Which article? 22. Bolo, how many protection? One is against the what? Arrest. One is for what? Detention. One is for what? Article 22 is clear. Everybody, yes or no? What time? Article 12. Fast. State. 13. Justifiability of what right? Fundamental rights. Good. 15, 14. Equality. 15. Discrimination. 16. Equality of opportunity in employment, public employment. 17. 18. Abolition of title. 19. Freedoms. 20. Convictions for offences. How many protections are there? Three. Double jeopardy, ex post facto loss, self incrimination. Very good. 21. Life and personal liberty. 22. 21A is right to education. 22. Protection against arrest and detention. Arrest and what? Next comes Article 32. Article what? Sorry, 23 and 24. 23 and what? What is 23? Prohibition of trafficking in what? Human beings and forced labor. What is trafficking in human beings? Selling the human beings like goods. That are not allowed. Not allowed. Forced labor or beggary system. That are not allowed. Not allowed. Sati system. What system? Sati system. Devadasi system. These are prohibited now. They're against the what? Article 23. Article what? 23. Tell me, can there be a child labor? What labor? Article 24 deals with what labor? Child labor. What labor? Can you be made to work against your wish with a salary? Can a person be forced to work against his wish with the salary? Allowed or not allowed? Not allowed. Can, because it is also amounts to what labor? Forced labor. What labor? Any labor without salary? Not allowed. Any labor with the salary against his wish also what? Prohibited. Under which article? Article what? 24. Article what? Sorry, Article 23. Article 24 deals with what? Prohibition of employment of children. 14 years, 24. No child shall be employed below how many years? Any child below age of 14 years shall be employed to work in any what? Factory or mine or engage in any other hazardous employment. Clear with this? Article 23 and 20. These are our fundamental rights. What rights? Boys, everybody, what rights are? Then we have Article 32. Right to what remedies? What remedies? If we remedium. What does it mean? Where there is a right, there is a remedy. There is a right what? There is a remedy. I repeat, where there is a right, there should be a remedy. That is the fundamental or cardinal principle of jurisprudence. What principles of jurisprudence? Cardinal principles of jurisprudence. Hi or no? Yes or no? So Article 32. Article 32 itself is a fundamental right. What right? It cannot be suspended. Article 32 cannot be suspended even except during the way of what? Emergency. Except during what? Emergency. Any person who is aggrieved by the violation of fundamental rights can approach his court, High Court, or the Supreme Court. High Court under which article? 226. Supreme Court under which article? Article 32. Article what? 32. Clear with this? Next, we have supplementary article 33, 34, 35. 33 deals with what? Parliament can restrict or abrogate the applicability of fundamental right to what forces? Armed forces. So that armed forces means the military personnel and navy personnel. Next one, Article 34, indemnity for the act done during what laws? Martial laws, military rule. Whenever a military rule is done, imposed. And during that, if any actions are done by those military personnel against their action, you cannot claim any compensations. Correct, right? In India, military rule never imposed. Okay? Next one, Article 35. Next one is what? What is Article 35? Parliament to make a law restricting what right? Fundamental. Any restrictions on fundamental rights can be imposed only by who? Parliament. Only by whom? And that too by way of law. Clear with this? Yes or no? Now tell me, can Parliament amend the fundamental rights? Do Parliament have a right to amend the fundamental rights? Yes or no? Yes or no? Do Parliament have a right to amend the fundamental rights? As per which article? Article 368 of the Constitution of India. Parliament can alter the fundamental rights. Correct, right? What rights? Fundamental rights. Remember the, the flow of the cases are the how we have arrived at a conclusion which provides that we can alter, Parliament can alter any part of the Constitution of India except what structure? Basic structure. What structure? Correct, right? See, we have a case law. What is the first case law? Sankari Prasad versus what? Union of India. In this case, the majority of the judges were have opinion that law means any law. Law means what laws? Any laws, except what law? Constitutional Amendment Act. So, in this case, the court held that Parliament has the power to alter any part of the Constitution of India, including fundamental right. Including what right? But however, this was overruled. The decision was changed. In which case law? Golaknath case. In this case, the majority of the judges were of the opinion that the parliament cannot alter which part? Fundamental right. Because the law includes even what law? Constitutional Amendment Act. Which act? Which act? Constitutional Amendment Act. This was held in which case law? Golaknath case law. To nullify the effect of Golaknath case, which held that Parliament cannot alter which part? Fundamental rights. What Parliament did? They brought amendment to the Article 13. Article what? 13. Adding Article 13(4), which state that nothing in this article shall apply to the amendment of what? Constitution. Under which article? 368. Again, this law was also challenged in the what? Supreme Court. So to settle this dispute, the court in the Keshavananda Bharati, which case law? Keshavananda Bharati versus state of what? Kerala. Held that Parliament has the power to alter any part of the Constitution of India. What part of Constitution of India? Including what? Part 3, except what structure? That was held in which case law? Keshavananda Bharati versus what? State of Kerala. Everybody, which case law? Keshavananda Bharati versus State of Kerala. Examples are illustrative list of basic structure. What is the first one? Supremacy of constitution. Second one, welfare state. Third one, principle of what? Equality. Next one, nature of the polity. What is our nature of the polity? We are a democratic state, republic character, and it's a social state. Next one, judicial review. What review? It's a part and parcel of what? Constitution of India. What of India? Correct, right? What happened? Indira Gandhi government got a law stating that the judicial review power of the Supreme Court does not extend to the political matters. What matters? There was a law passed in the parliament stating that court does not have the power to review the election procedures or election of MPs. This law was challenged in the Supreme Court, and Supreme Court held that judicial review is a basic structure of what of India? Constitution of India. Any law which takes away that, any law which takes away that what? Right. Valid or not valid? Valid. Because Parliament have the right to alter any part of the Constitution of India, not the what structure? Basic structure. What structure? Clear with this? Amendability of what? Constitution of India. Next, we have directive principles of what policy? What policy? Next, what principles of state policy? Directive principles of state policy. Now tell me, are they enforceable, justiciable, or justiciable? Justiciable, non-justiciable? Non-justiciable. Directive principles of state policy act as a what principles? Guiding principles. What principles? To whom? State. To formulate its policies. Formulate its what? Policies. It is the guidelines for the future connected to lead the what? Country. DPSPs shall not be enforceable by what order? Court order, and do not create any what right? Justiciable right. What right? It requires to be implemented by what? Legislations. Directives per se do not confer any right or take away any legislative power from the what legislature? Appropriate legislatures. Court cannot declare a law as what? Void. On the ground that it contravenes any of the what principles? Directive principles. What principles? The courts are not competent to compel the government to carry out what any directives or to make any law for that particular purpose. In case of conflict between the fundamental rights or DPSP, which one will prevail? Fundamental rights. What rights? Next one we have fundamental duties. What duties? Array what duties? Fundamental duties. What are the fundamental duties? Earlier, when the constitution was framed, there were no fundamental duties in the constitution of India. Later, it was added to the constitution of India. Based on which committee? Swaran Singh committee. What committee? Right, right. Article 51A deals with what duties? Fundamental duties. What duties? What is the first one? Abide by the constitution, respect the what? National flag, national anthem, cherish and follow the noble ideas inspired our national struggle for freedom, uphold and protect the sovereignty, unity and integrity of India, defend the country and render the national service when called upon to do so. If government says no, get ready for the war. Should be ready for the war. That is your fundamental duty. Next one, to promote the harmony and spirit of what? Common brotherhood amongst all the people of India, value and preserve the rich heritage of our what culture? Composite culture. Next one, protect and improve the natural environment, including the what? Forest, lakes, rivers, and wildlife, and to have a compassion for what creature? Living creature. What creature? To develop the what temper? Scientific temper, humanism, spirit of inquiry and what? Reform. Strive towards excellence. Striving for excellence is your fundamental duty. You're always trying to gain new knowledge, new information. You should try to learn new information. So striving for excellence is your fundamental duty. Exercise your fundamental duty. Fulfill your fundamental duty. Next one, provide opportunity for what? Education to his what? Child. See, a child has a right to education. As a parent, as a mother, or as a father, you would be having a duty to provide what? Education to the kid up to how many years of age? 14 years of age. Learn these fundamental duties. Are you guys clear with this? Which article deals with fundamental duties? Which article deals with fundamental duties? Article 51. A. Next we have ordinance making power. What making power? Board president and governor has the ordinance making power. There are questions based on this concept many times in the previous examination. Concentrate. Article 123 provides the power to whom? President to make what? Ordinances. When president can make ordinances? When both the houses of the parliament not in session. Who can promulgate ordinances? President. At the advice of whom? Council of Ministers. What of minister? Council of Ministers. This promulgation of ordinances, the ordinance made by the president has the same effect of what? Law. And this will be valid for how many weeks? 6 weeks. From the reassembly of the what? Parliament, both houses of the parliament, you will count from the date when both houses are in session. What in session? Both houses are in session. If it is not ratified or approved within how many weeks? 6 weeks. What will lapse? Law will lapse. Will lapse. Are you guys clear with this? Can the president promulgate the ordinance on its own? Should be at the advice of whom? Council of Ministers. One more question. Is it mandatory for the president to promulgate an ordinance if there is an advice by the Council of Ministers? No. It's a what power? Discretionary power. What power? Discretionary power. Same provisions are applicable even for what? Governor under which article? 213. When the state legislature not in session at the advice of the Council of Ministers, who can promulgate the ordinance? Governor. Who can promulgate ordinance? Governor. And this ordinance is valid for how many weeks? 6 weeks. How many weeks? From the what? Reassembly of the state legislature. What legislature? State legislature. While promulgating the ordinances, if There is a requirement of reservation of the bill to the president. The governor should reserve the bill to whom? President for his asset. Right, right. Next one. Next we have legislative power. What power? Important part of the constitution based on which they ask question many times in the previous examination. What power? Legislative power. Legislative power can be classified into two categories. How many categories? Everybody, how many categories? What are the two categories? Territorial distribution of powers, then subject matter distribution of power. Tell me, under the territorial distribution of power, to the entire India, who can make law? Parliament. To the state? Tell me, a law made by one state, can it have an effect in other state? Generally, no. But only when there is a territorial nexus. What nexus? Territorial what? Nexus. A law made by one state may have effect in what state? Other state. One provision, one provision. Tell me to the entire India who can make law? Can Parliament make a law which has effect even outside India? Yes or no? What if a law is having effect outside India? Is it valid or not valid? Valid. We have IT Act. Which act? We have BNS. BNS has the effect even where? Outside India. Just because a law is having an effect outside India, is it called as invalid? No. So Parliament has the power to make a law. Who has the power to make a law? The entire territory of India, and the law may also have an effect where even outside India. इसको क्या बोलता है? Extra territorial jurisdiction. बोलो what jurisdiction? Extra territorial jurisdiction. अरे yes or no? And who can make law for Union territories? Parliament can make law for what territories? Union territories. State legislature. For the state, who makes the law? State. Can it have a application in the other state? Generally, no. But however, it can have it only when there is what nexus? Territorial nexus. Now, there should be a real connection and it should be pertinent to the what? Liability. These conditions are given in which case law? State of Bombay versus RMDC. I discussed this case in detail in the class. Remember where the magazine was published in Karnataka, Mysore, but was circulated where in the Maharashtra. So Maharashtra government passed a law to impose a tax even though the magazines were made in what? Karnataka. Is that law valid or not valid? Valid. Why? Because there is a territorial nexus. What nexus? Territorial nexus. Clear with this? Next one, next one, next one, next one. What is the next one? Array below net the next one subject matter. Which article 246 deals with what? Territorial distribution of, sorry, 245 territorial. 246, which schedule? 46. Seven schedules provides a power to make a law for the subject matter. We have how many schedules? What are three schedules? Union list. Sorry, how many lists? Three lists. What are the three lists? Union list. State list. One. Tell me the matter which are of national importance and which require weight. The matters which requires national importance and which require the matters which are of national importance and which requires uniformity throughout the India comes under which list? Union list. What list? On the matters which are in the Union list, who can make law? Parliament can make law. Second one, the matters which are of local importance and requires the continuous observations for implementation comes under which list? State list. What list? On the matters which are mentioned in the state list, who can make law? State can make laws. Then we have concurrent list. What list? What is concurrent list? Where matters are of national importance, yet they requires the local control or local guidance. In those cases, they come under which list? Concurrent list. What list? On concurrent list matters, who can make law? Both state and union can make law. For example, stamp duty. What duty? Stamp duties. In what list? Concurrent list. Concurrent list. Correct, right? GST in what list? Concurrent list. Yes or no? Tell me if there is a contradiction between the law made by the state and law made by the parliament on the matters which are in the concurrent list. Which law will prevail? Union. Union law will prevail. However, if there is already a union law and if a state want to make a law, Then, in that situation, the state shall reserve the bill to whom? President. And if a president has given the assent, in that situation, the law made by the state will prevail over which law? Law made by the parliament. Law made by whom? Are you guys clear with this? This is with respect to subject matter distribution of power. What distribution of power? Union list, who can make law? State list, concurrent list, both can make the laws. Next, we have power of the parliament to make law on what list? State list. This is the ICSI favorite topic and favorite question. They ask question based on this many times in the previous examination. Tell me on the state list who can make law? Everybody. But however, there are few exceptional cases where even on the state matters, who can make law? Parliament can make laws. Who can make law? What is the first exceptional case? In the national interest. What interest? If there is a resolution passed by the Rajya Sabha, passed by whom? With the presence of three-fourths of the members of the Rajya Sabha, not three-fourths, third, 66.67%, right? So two-thirds of the members present and voting. If a resolution is passed by the two-thirds of the members present and voting, requiring that in the national interest, the law should be made by the parliament. Law should be made by whom? Parliament. In that situation, based on the resolution, who can make law? Parliament can make law. Who can make law? And the resolution passed remain valid for how many years? 1 year. And there can be a new resolution to extend the period of resolution. Period of what? Resolution. Once the resolution comes to an end, what is the validity of the resolution? 1 year. How many years? Once the resolution comes to an end, the law made under the resolution ceases to have an effect after how many months? 6 months. After how many months? Clear with this? Yes or no? What is the first exceptional case where Parliament can make a law on the state list? National interest. What interest? Second one. Proclamation of emergency. Proclamation of what? During emergency, who can make law on the matter which are in the state list? Parliament. Remember, during the declaration of emergency in case of Indira Gandhi period, there were many labor laws which were made by the Parliament. Even though labor law is a what subject? State subject. What subject? Clear with this? In case of what? Proclamation of emergency. Next one, breakdown of what? Constitutional machinery in the state. That is, when a president takes over the control of the government in case of breakdown of constitutional machinery on the report of the governor, on the report of who? Who can take the control? President. इसको बोलते हैं president rule. What rule? During the president rule, who can make a law on the state list matters? Parliament can make law. Who can make law? And the laws made by the parliament during the president rule will remain in force in the state until explicitly repealed or amended by what legislator? State legislature. And what legislator? See, first two cases, the law will be in force up to how many months after the proclamation ceases? 6 months. But in this case, during the breakdown of machinery, constitutional machinery, if law is made during the president rule, the law will have an effect. What will have an effect? Law will have an effect until in being force until it is what? Explicitly repealed. Clear? Fourth one. What is the fourth one? On the request of how many states? Two or more states. Two are. Who can make law? In two or more states, if they are willing to have a uniform law, what they can do by passing a resolution in the respective houses can make a joint request to whom? Parliament. Then who makes the law? Parliament makes the law. Once you surrender your power to make a law to the parliament, only who can make the law? Parliament. Only who can amend it? Parliament can amend it. Any other state can adopt the law by passing a what? Resolution. Passing a what? Next one. To enforce what agreements? International agreements. Follow what agreements? Constitution authorizes the parliament to make a law on what matter? State matters for enforcement of what? Any treaty, agreement, convention with what country? Other countries, or any decision made at any international conference, association, or other body corporate. What corporate? Body corporate. Are you guys clear with this? Yes or no? Next one, we have interpretation of what list? Legislative list. Now tell me what are the five exceptional cases in which Parliament can make law on the state list matter. What is the first one? National interest. Second one, emergency. Third one, breakthrough of constitutional machinery in the state. Fourth one, request of two or more state. Fifth one, for the enforcement of what agreement? International agreement. Can you answer if they ask question about this in the examination under Article 245? Article 245 deals with what? Territorial distribution of powers. Article 246 deals with what? Subject matter distribution of powers. And what distribution of powers? Subject matter distribution of powers. Are you guys clear with this, everybody? Yes or no? Artha aita? Next one. Interpretation of legislative list. The items mentioned in the legislative list. We have how many lists? What are three lists? Union list, state list, concurrent. While understanding or interpreting those lists in the constitution, there are a few doctrines to be followed. What is the first one? Doctrine of plenary powers. What powers? What's plenary powers? Widest scope. What scope? While interpreting any of the items in the any of the list, you have to give a widest meaning to the particular list or particular item without making the other item negatory or invalid or ineffective. So I should give a widest meaning or widest scope, possible scope, unless there is any other intention expressly specified. See, when you are trying to understand the legislative matters specified in the legislative list, you have to give a what scope? Widest scope or widest meaning without making what other matter in the other list or in the same list negatory or invalid. That is called as what power? Plenary powers. And wherever there is a power to make a law, it also includes power to amend it, power to make it retrospective, power to make it prospectus, power to establish tribunals. It includes, it has a wide amplitude, it has a wide applications. Correct, right? That is called as what power? Plenary powers. What powers? Everybody, what parts? Plenary parts. Important, they may ask question based on this. Concentrate. Legislative parts. Everybody, what part? What part is granted over a what subject? What subject? Particular subject by the Constitution, unless specifically limited. That power should be interpreted to have the what scope? Widest scope. What scope? Widest scope. Legislature has the authority to legislate on the all the aspects of the subject, even those that might not be explicitly mentioned, but are reasonably what? Reasonably related to it or connected to it. In general term is used in a constitutional entry, it should be understood to what extent, not just to the direct subject, but also to what matter? Subsidiary or ancillary matter. You have to interpret the list or the item to include even what matters? Ancillary matters. What matter? That is called as what interpretation? Plenary. What parts? Will you give the widest possible scope possible or limited scope? That is called as what power? Plenary powers. What power? Next comes harmonious construction. What construction? Yes. What is harmonious construction, sir? While interpreting the items in the same list or in the different list, you should try to avoid the conflict between the items. Correct, right? And for the purpose of giving effect to both the item, the scope of one item can be curtailed to give an effect to which item? Other item. That is called as what construction? Harmonious construction. What construction? Balancing the both. Different entries in the different list. What list? Interpreted in a such a way that conflict between them is what? Avoided. And each of them is given what? Effect. Each of them is given what? Effect. When there appears to be a conflict between the two entries, interpretation should be made in a way that gives effect to what entries? Both the entries. And what entries? This can be done by restricting the scope of one entry and the other can still be what? Upheld. Whenever there is a conflict between the two entries, that is, two entries means two subject matter. You have to do the interpretation in such a way that effect is given to what? Both. That is called as what interpretation? Harmonious interpretation or harmonious construction. Remember हमने discuss किया था gas and gas works and manufacturing industry. See, the word manufacturing industries includes what? even the gas and gas works. But if you say manufacturing includes gas and gas work industries, this becomes invalid, right? So what court has done? Court has done a harmonious construction. What construction? Where the court has done. Industries means all industry except gas and gas works. That come under a different list. What list? Different list. This is called as what interpretation? Harmonious interpretation. Next one. This is also important. Remember, I discussed this broadcasting, health, health and sanitation, broadcasting, wireless telephones. Rajasthan case law. They asked this question in the previous examination as well. Fifth and substance rule. See, where the substance of the subject matter of a statute falls within the legislative competence. What competence? अरे बोलो what competence? Legislative competence of the legislature. But however, it incidentally or accidentally touches upon the any matters in the other list. The law cannot be declared as void just because it touches incidentally in what list? Other list. See, you have planted a tree within your compound, but certain part of the tree is in the compound or the property of other person. Can he claim the property as his own? No. Why? Because the crux or the substance of that tree is within your powers or within your boundaries. In the same way, if a law is within the legislative competence of the legislature, but however, accidentally or incidentally, it touches the matter which is in the other list, that law is still valid. What we should take into consideration when deciding whether a law is valid or not valid is the substance of the law, or the crux of the law, or the main fundamental principle of the law. For example, there was a law made by the Rajasthan state legislature prohibiting the usage of loudspeakers after certain time. This law was challenged, stating that regulating the wireless broadcast is the power of whom? Parliament, not of whom? State. But court held that here the intention of the legislation was to what? To prevent the harms caused to the health of the public, not to regulate the wireless broadcasting or telephones. Hence, the law was within the competence of whom? State legislator. What legislature? So the pith and substance, pith and what? Is what? Health and sanitation, not the regulation of what? Broadcasting. Reza, no. We have discussed this case law, right? Rajasthan case law. Now tell me, if the pith and substance of a law is within the legislative competence of the legislature, but however, it incidentally or accidentally touches upon the matter which is in the other list, is that law valid or not valid? Valid or not valid? Why it is valid? Because the pith and substance within whose competence? Legislator's competence. Are you guys clear with this? Yes or no? We are discussing the what? Doctrines of interpretation or rules for interpretation of legislative list. What is the first one? Plenary part. Second one, harmonious construction. Tell me if there is a conflict between the two matters. How do you do the interpretation? You should do the interpretation in such a way that conflict is avoided and effect is given to what? Both the provision. And for this purpose, for giving effect to both the provision, what provision? Both the provision. What provision? The scope of one article or one item may be restricted to give effect to which article? Other article. Clear with this? Yes or no? Next one is what? Colorable legislation. What legislation? What is colorable legislation? It is based upon the principle that a person cannot be allowed to do something indirectly, which he can't do what? Directly. If you don't have a power to make a law, you cannot make a law. Making it look like you have a power to make a law. इसको बोलते हैं transgression of power. What of power? Transgression of powers. So if a legislature does not have a power to make a law, but if he makes a law, making it to look like he has the power, or it's within these powers. Such laws cannot be considered as what? Valid. It is called as what legislation? Colorable legislation. Remember, I've discussed a concept where whenever there is a law confiscate a property, parliament or a state can confiscate a property for public purposes only by way of compensation and not to by way of law. But there was a case where parliament made a law or a state made a law confiscate a property of a person, saying that they are paying the compensation by returning the rent which was due from a third party to the owner. So they were not paying the compensation; they were just returning the which money which was due to who? Owners. Correct, right? So they are trying to make the law look like it is within the legislative competence, even though it is not. It is called as what legislation? Colorable legislation. Allowed or not allowed? Not. Because you cannot transgress the powers. Transgress the what? Powers. Constitution does not allow the transgression of powers by any legislature, either directly or what? Indirect. Directly or what? Indirect. Article 301 to 307 deals with what? Freedom of trade, commerce, and intercourse. Tell me that trade, commerce, and intercourse throughout the territory of India should be what? Free. This is to maintain the economic unity of India. But however, subject to what restriction? Reasonable restriction. Who can impose a reasonable restriction? Parliament as well as the state. What is the first one? Parliament can impose a what? Reasonable restriction. In whose interest? Public interest. Remember during COVID there were restrictions. Correct, right? Are not allowed. Allowed. Third one, Parliament to make what? Preference or discrimination. Generally, Parliament should not make discrimination or give a preference to one state over the other state when it makes the when it puts the reasonable restrictions. But however, Parliament to deal with the scarcity of goods in any part of territory of India, it can give one preference to one state over which state? Other state. I repeat, while putting the reasonable restriction under Article 302, this Parliament should not give any preference or discriminate between the states. But however, to deal with scarcity of goods in any part of India, there can be what restriction? And who can give a preference? Parliament can give a preference. For example, in one state there is a scarcity of rice. Parliament can supply more rice to what? One state. Correct, right? Next one. Power of what legislature? State legislature. State legislature can impose a tax of same rate for importing goods from which state? Other state. If that goods is subject to tax in the state as correct, right? If you're importing goods from Rajasthan, if you're bringing goods from Rajasthan with the same goods taxed in Karnataka, you can tax it at the what rate? Same rate. What rate? Otherwise, what people will do now? People go to Goa to buy alcohol because the alcohol tax is less over there. So when you bring it to the Karnataka, are you supposed to pay duty? Are you supposed to pay duty on that? Are you supposed to pay tax on that? Yes, the difference tax rate will be paid in Karnataka. At the border, there will be customs, there will be authorities over there, right? Yes or no? See, we have a practical example. Shashank is for the first time with so much of energy is saying, yes, sir, yes, sir. Because he has experienced that situation, would have come up with that situation. Have you been to Goa, Shashank? Yes, see, he has been to Goa. And while bringing, I think the police would have caught you check post. You know, and when did I? Beta, it is always that is why we have interpretation of statutes. Did I say you consume alcohol? No. What did I say? I asked a question. Have you been to Goa? The answer is yes. You've been to Goa. Did you buy any alcohol over there to bring it to Karnataka? Yes. Not. Again, you're doing a wrong interpretation. There may be somebody in your relative, somebody in home who consumes the alcohol, right? Consumption of alcohol is not a even I don't. consume the alcohol. Doesn't mean we'll not learn the provisions of the law. Doesn't mean we'll not bring the alcohol. The moment you say I'm going to Goa, or if you say I'm going to abroad, I'm coming from abroad, what they say? Get something. Right, right. So now, while bringing the alcohol, did they stop you at the check post to check it? How many bottles you were carrying? Five bottles. Did they charge any tax on that? Yes, because any excess more than I think one are allowed, I guess. Only if it is consumed, part of it they allow it. More than that, they will charge the what? Cash, collect the amount, right? The airport, there is a custom that is different. If you are bringing it from other country, they will there is a different provisions. State to state. One state you uh-huh. Only certain limit, one or two bottles. Huh? Other than that, you're not supposed to carry because there is a restrictions. Next one, state monopoly. What monopoly? Can state create monopoly in its own favor for the purpose of interest of public? Yes. Laws which create state monopoly in any trade are saved from the attack under Article 30. But not Article 30, Article 300. When law is passed, law, sorry, 301. When a law is passed, what is passed? That relates to state monopoly, courts are expected to scrutinize the law to determine whether the provisions are essential and necessary. For the creation of what? Monopoly. If it is essential and necessary to create monopoly in the interest of public, that law which create monopoly, it is what? Valid. It is not a violation of Article 301 as well as Article 91 JIGL Constitution of India. So who can create monopoly? 301, 301. Next one. Are you guys clear with this? Yes or no? Freedom of what? Trade, commerce, and intercourse should be what? Free. Should be what? Free. Next one. Last few concept of Constitution of India. Concentrate everybody. Right jurisdiction. What jurisdiction? So where there is a right, there is a what? Remedy. Our fundamental rights are justiciable or justiciable? Everybody justiciable or justiciable? Can you file writ petition for enforcement of your fundamental right? Article 226 gives the power to file a writ petition in which court? High Court. High Court has writ jurisdiction under Article 226. Supreme Court? Article 32. Yes or no? This case law is important. New case law. This case law is important. PHR, Invent Education Society versus UCO Bank. See, generally, High Court will not entertain a writ petition if there is an alternate remedy available in the normal course of law. If you can file a civil case, what case? You can go for a civil case. Correct, right? So generally, what is not allowed? Writ petition to High Court is not allowed if there is a alternate remedy available in the due process of law. Correct, right? That is what held in this case law. However, there are exceptional cases where a writ petition is allowed even if there is an alternate remedy. What remedy? Alternate remedy. What is the exceptional cases, sir? First one, if there is a non-compliance, the court or the authority has not complied with what provision? Statutory provision. What provision? Second one, disobedience of what? Fundamental judicial principles. What principles? Fair hearing, fair hearing. Then this one, bias. If a person is having bias and is deciding a matter, can you go against that to the High Court by filing a writ petition? Yes, because it is a violation of what principles? Fundamental judicial principle. What principle? Fundamental judicial principles. Third one, invoking what provision? Repealed provision. If a judge has given a judgment, invoking a provision is already repealed, removed. Next one, violation of what principles of justice? Natural principles of justice. What principles of justice? In all these cases, what cases? Arey bolo, what cases? Of these cases, can we file writ petition even though there is what remedy? Alternate remedy. Are you guys clear with this, everybody? Yes or no? Next one, types of writs. Important. What are the types of writs we have? What is the first one? Habeas corpus. What corpus? Concentrate. Key points. Key points. Concentrate. What is the first one? What is habeas corpus? Have the body. First point. First point. If they ask question about habeas corpus means what? To have the what? A writ of habeas corpus in the nature of order of whom? Calling upon the person who has detained another to produce the later before a what? Court. And also to let the court know on what grounds he has been confined. I repeat, whenever a person has been wrongfully confined or detained by any authority, the court may issue an order, produce that person before the court, and answer the court on what grounds he has been detained. That is called as what? Habeas corpus. What corpus? Who can make application for habeas corpus? A person who has been detained, or his next friend, or any family. What members? Family members. What is habeas corpus? To have the body. Can you write in the exam if they ask question about habeas corpus? It is an order. It will be in the form of order of a court. Directing a person who has detained a person wrongfully to produce him before the court and to answer the court on what grounds he has been detained. Clear? Next one is what? Mandamus. What is mandamus? Command. Everybody, what is mandamus? Command. It's a command issued by which court? Or the High Court to any person, corporation, inferior court, or the government. Keep this in mind. It is issued against two person, corporation, inferior court, or governments. Who has to perform what duty? Statutory duty. Keep this in mind. Mandamus can be issued only if a person has what duty? Statutory duty. What duty? Writ of mandamus cannot be issued against what? Private person. What person? President and the governor of the state. Correct? Right? You cannot issue a writ of mandamus to force the governor or a president to do their actions. For example, let's say a law has been made, passed in the parliament, but it is not yet notified, means not yet implemented. Law is passed in both houses of the parliament. And law will come into a picture only when it is notified in what case? The official place. It's been almost 2 years. How many years? Since which Parliament has not notified it, government has not notified it. Can you file a writ of mandamus seeking the court to direct the government to notify that law? No, because government does not have a obligation to implement the law or to make the laws. It is their discretionary power. Law making power is with whom? Legislature itself. Correct, right? Yes or no? So mandamus can be issued only when a person has what duty? Statutory duty. What duty? Statutory duty to command a person to do something. Command a person to what? Do something. Clear with this? Next one is what? Prohibition. What is prohibition? Prohibit. So inferior court or the tribunal from doing something which it is about to do or which is not authorized to do. It is based on the principle that prevention is better than what? Cure. If an inferior court exceeding its jurisdiction, exceeding the what? Exceeding the what? Jurisdiction or going beyond its jurisdiction, who can prevent it? High Court or the Supreme Court by issuing writ of what? Prohibition. Writ of what? Prohibition. While mandamus commands activity, prohibition commands what? Inactivity. Then we have certiorari. What do we have? What is certiorari? To be certified or to be more fully informed of. See, if a court, a lower court, or a tribunal, or a government authority passed any orders or a judgment exceeding their jurisdiction or without jurisdiction, or by considering the irrelevant facts, in that situation, who can quash those decisions? High Court or Supreme Court? Under which jurisdiction? Writ jurisdiction. Under the which writ? Writ of certiorari. Writ of what? Certiorari. Mandamus, command an activity. Prohibition, command an inactivity, not to do something. Certiorari, to cancel or nullify decision or an act which is already done by what authorities? Public authorities. Okay, important है. To be certified, issued by which court? Issued by what court? Supreme Court or High Court. To which court? Inferior court or any authority, whenever any authority or the court has an abuse of what? Jurisdiction, has acted without any what? Authority, has violated the principle of what? Justice, natural justice, or has committed a prima facie error on the what? Report or decision, or it has violated the what? Rights, but then there can be writ of what? Search. Writ of what? I'll ask questions at the end. Quo warranto. What warranto? What is quo warranto? What is your authority? This is issued whenever a person is claiming a right to a public office. What office? Public office. This writ prevents a person from returning in the what office? Public office. Or what office? Who has wrongfully usurped the office, means claimed the office or taken the position of that office. It calls for the holder of the public office in question. What in question? Public office in question. If a person could not prove his lawful right to that office, what court will do? Court will remove him from his what? Position. He has to vacate that position. For this, we have a classic case where Indira Gandhi was disqualified because there was a corruption in her election. Under which writ? Quo warranto. What warranto? Quo warranto is also judicial review, right? What review? Judicial review. This writ may be issued in respect of what? Office of Prime Minister, Judge of High Court, Speaker of Parliament, University officials. However, it can't be issued against what? Private person. What person? Which writ cannot be issued against private person? Quo warranto. What warranto? Tell me, we have how many types of writs? What are the five types of writs? Habeas corpus, mandamus, prohibition, subsidiary, quo warranto. A person is wrong detained. Which writ? Court is exceeding its jurisdiction and you want to prevent it. A court has passed an order exercising a wrongful jurisdiction. Subsidiary. A person is elected to the government office by bribing the officers. What warranto? Job warranto. Very good. Clear with this? Then we have delegated legislation. What legislation? Last few concepts, guys. What concepts? Delegated legislation. What is delegated legislation? Now tell me, as per the Constitution of India, who has the power to make law? Legislature. Can they delegate their power to the executive? So when the executive is using the powers delegated to them makes the law, it is called as what legislation? Delegated legislation. What legislation? Classification of subordinate legislation. It can be classified into what categories? Following category. What is the first one? Executive legislation. When the executives makes the law, it is called as what legislation? Executive legislation. Next one. Can court make laws? Court frame their rules for the service of summons or the operation of their court activities. That is called as what legislation? Judicial legislation. Next one. Municipal corporations make the law. It is called as what legislation? Municipal legislation. Next one. Autonomous institutions, autonomous legislation. Last one is what? Colonial legislation. We had British colonies, but now there are no British colonies anymore. Correct, right? Next one, principles applicable for delegated legislations. Legislature cannot delegate what function? Primary legislative function. Now, Parliament cannot say you only make entire law. Is it possible? Not possible. Not possible. Primary legislative function is with whom? Legislature. They can only delegate some of the powers. They cannot say you only make entire Companies Act. You make a Companies Act and give a power to the MCA to make the what? Rules within the Companies Act. Correct, right? So what cannot be delegated? Primary and essential legislative functions cannot be delegated. A law delegating the power is not valid if it does not lay down the what? Principles and standards of guidance to what body? What body? Rule making body. What body? There has to be a guidance. There has to be a guidelines, and there should be a what? Limitations of powers. Correct, right? See, in the Companies Act, there is a delegation of power to specify the number of members or partners in a partnership firm. But is there any limit? Yes. What is the limit? 100. As of now, it is 50, but who can increase this? Government up to how many? 100. At the same time, small company. What company? Small company. Paid up capital is as of now it is 4 crores. Can government increase this? Yes, there is a delegation of power to the government up to how much? 10 crores. How much? 10 crores. There is a limit, right? अरे हाँ ये ना. So there has to be a control. There has to be a principle and standards. Delegation made. What made? अरे बोलो what made? Without integrating the intelligible limits of authority is constitutionally what? Incompetent. Constitutionally what? Incompetent. Next one, separation of power. Is there any separation of powers in the Constitution of India? Yes. Powers of in the Constitution is distributed between legislatures, executive, and judiciary. But however, there is no absolute separation of powers in India. Correct, right? There are few cases where Parliament exercises, sorry, the power of making the law is exercised by who? Executive as well as judiciary. There are cases where executive performs what functions? Judiciary functions. So there is no what separation? Absolute separation. Then we have legislative function. What functions? Well, what functions? What is legislative function? To make the laws. Who makes the law? Legislature is the supreme body authorized to make the laws as per the Constitution of India. What of India? Arey, what of India? What is bill? A draft legislature is called as what? Bill. What is act? When a bill passed in the parliament, assented by president, becomes what? Act. Becomes a law. Types of bill. What is the first bill? What is ordinary bill? A bill other than money bill, finance bill, ordinance replacing bill, or constitutional amendment bill. It is called as what bill? Ordinary bill. What is money bill? A bill which exclusively deals with money matters. What matters? It is called as what bill? Money bill. What is finance bill or finance bill? It, along with money matters, it also deals with any other matters. For example, amendment to the Companies Act. It is called as what bill? Finance bill. What bill? Next one, ordinance replacing bill. Who passes the ordinance in India? President and the governor. And it's valid for how many weeks? How many weeks? Within 6 weeks, the parliament should take a law to replace that ordinance. Right, right? It is called as what bill? Ordinance replacing bill. Next one is what bill? Constitutional Amendment Bill. Under which article? 368. For passing the Constitutional Amendment Bill, there are three requirements, three different way of passing a resolution based on its important. First one is simple majority, means more than 50% of the votes are required in the parliament, the houses. Next one is what? Special majority, means the number of members who are present in that house should be majority in number of that house. If house has 500 members, 251 must be present. Plus, out of the 251, how many should vote in favor? Two-thirds of the majority and voting. You know, majority and what? Voting. What is this? Majority numbers of that house. Plus, out of that, whoever present in the meeting in that house, minimum how many should approve? Two-thirds should approve by voting. Two-thirds. Next one, special majority plus what? Ratification. Any matters which affect the federal structure. What structure? Should be approved by a resolution supported by majority of numbers of that house plus two-thirds of the votes, valid vote casted in the house, and that should be ratified by what state? Major half of the states. What states? Half of the states. We have how many states in India? And out of 28 states, how many should ratify? How many should ratify? Half of the states. Half of the states. How many states we have in India? What is half of 28? 14 should ratify it. Half of the state, half of the should ratify it. Clear? First to pass a resolution in the meeting. So both the houses, then it goes to the state's approval, a state's assent. Next one, law making process. How the laws are made in India. What is the first step? What reading? In the first reading, bill is introduced where? In the house. Which house? Lok Sabha, Parliament, lower house. Next one, publication in the Gazette for the public comment. Next one, reference of the bill to what committee? Which is a permanent committee of the Parliament. Next one, second reading, there will be what discussion? General discussion. Third reading will be what? Move the bill to be passed. Then send the bill to which house? Other house. If there is no approval by the other house, or if they reject the bill, then the president can call what? Joint sitting. What sitting? If it is disagreed by which house? Other house. Or if there is no response within how many months? 60. The president call for what sitting? Joint sitting. And it should be assent of who? President. Assent of who? Next one, parliamentary committees. What committees? What are types of parliamentary committee? Standing committee, ad hoc committee, other committees. Permanent one, standing committee. Particular purpose, other than the above two is called as what committees? Other committees. And this is our Constitution of India rapid revision. What revision? Rapid revision. Now let's see how effectively we have revised all the provisions. How much we could retain. Listen, I will ask question. You guys should answer now. Tell me, India is federal or unitary? Which case law? Sure, now it is a state of state of. Okay. Can Parliament alter any part of Constitution of India? Fundamental rights, basic structure. Which articles deals with right to equality? Article. Tell me if there is a conflict between the two item of the two different list or the same list. How you do the interpretation? Harmoniously to avoid what? Conflict and give effect to what? Both. This is called as what interpretation? Harmonious interpretation. What interpretation? If a person is wrongfully detained, habeas corpus. Which corpus? Habeas corpus. Can president make an ordinance? When? Not in session. Valid for how many weeks? 6 weeks. How many weeks? Can governor make an ordinance? Can parliament make a law on the state list? Generally, no. But are there any exception? How many exception? How many exception? The state includes president only when he is passing the what? Executive orders. What orders? Is judiciary is a state? Non-judicial function. What function? Non-judicial functions. Are yes. See, we could retain the information now. We can answer. It's the subconscious memory. You can revise it now. We are thorough with the concepts and we remember that concept. Only thing is writing practice. What practice? Writing practice. Let's see. Let's see. We'll spend 15 minutes of time. How much time? For previous year question. What question? We'll see all the questions and there may be few strange questions for which we'll try to find the answers as well. I want everyone to concentrate, absolute silence. Let's answer the question. Let's see whether we could answer those questions or not. Let's talk. Chapter number क्या है? Chapter number Constitution of India. With respect to structure of Constitution of India, first question. Listen. On the basis of structure of Constitution of India, following type of questions may come in the examination. What is the first one? Constitution of India, federal in character, but with what feature? Unitary feature. Examine how far the essential of federal polity is incorporated in Indian Constitution. Third one, Constitution of India establishes a federation with strong centralizing tendency. Discuss. To what extent does Indian Constitution differ from the federal system of our Constitution? दोनों point इतना ही है. You just need to explain these points in the examination on your own words. But content should be there. At least if you have this much points in your head, you can elaborate an answer in the examinations. Clear with this? Next question. Can you explain the test to determine whether a corporation is an agency or instrumentality of the state? Ajay Hasya versus what case law? Khalid Mujib case law. Article 12, definition of state. Everybody, it's or no? Next one. Keep observing. You will find the answers for every question which were asked in the previous examinations. Just keep observing. Next one. Doctrine of what? Severability. Have I discussed the concept of severability? Yes or no? If it is possible to separate, that part is what? White. Other part is what? Reality. Correct? Right? Next one. Eclipse. It discuss the doctrine of eclipse under the what? Constitution of India. Next one. Right to equality. Right to what? I want everyone to read it. Read based on right to equality. There were four questions. How many questions? Four questions. Let's start. What is the first question? The state shall not deny to any person equality before the law. You ask question in any way you want. If you ask direct question, I'll write all the points which I remember. Article 14 provides the state shall not deny any person right equality before the law, equal protection of the law within the territory of India. There can be classification, legislative classifications, two conditions, all those things we have discussed in detail. Correct, right? I know. Same point is supposed to write in the answers also. Correct, right? Same points हमने discuss किया था ना. Two conditions for permissible classification. What are they? Intelligible differencia and what next is rational between the object to be achieved and the classification made. Prohibition of discrimination. Prohibition of what? Discrimination. Let's read. Differential treatment to certain person belonging to the backward class in the form of reservation in education and job. Under Article 15.4 and 16.4 of Constitution of India is a means of ensuring the equality enshrined in the preamble of Constitution of India. Evaluate the what? Statement. We should write Article 15.4 provides the power to the state to make what provision? Special provision. The advancement of what? Social and educationally backward classes, scheduled caste and scheduled tribes. With respect to admission to the educational institutions, including in one institution, private institutions, except minority education institution. 16 provides what? Reservation in the jobs and post in favor of who? Backward classes. What classes? Correct, right? Yes or no? Yes. It is also called as what discrimination? Protective discrimination. In case of positive discrimination in favor of women and children. Women and what? Children. Equality of opportunity in the public employment. Article 16 of Indian Constitution guarantees what opportunity to all citizens of India. Can you explain this? 16.1, 16.2, 16.3, 16.4, 16.5, and 16.6. You should write all the articles. Clear with this, everybody? Next one. Freedom of speech and expression. Question number one. Let's take question number one. Zed wrote a book, the content of which led to a major unrest in the war society. Government banned this book from the further circulation. Further what? Circulation. Further what? Circulation. Further circulation. He, after a lapse, after a what? Lapse of how many years? 10 years. Wrote another book. What book? Government directed the publishers to not to publish his book without what approval? Prior approval. What approval? Is this valid or not valid? Not valid because you are restricting him from, you are imposing a word. Free censorship of the book. Allowed or not allowed? Not allowed. Violation of which article? Violation of which article? 19.1a. Freedom of what? Speech and expression. Correct, right? And you'll easily get to know what is the answer. Why? Because I have classified the question based on what? Topics. And it becomes easy for your brain to remember those questions. Why? Because it is organized topic wise. Ah, yeah, na? Next question. Next question. Concentrate. Next question. Last one, Darshan. Next question. Question number one. We know that I'll take some rest. In organization of some person belonging to particular community sat on the. And I think we have discussed this case already. Do you have the freedom of assembly peaceably without arms? Now, if you are peaceably and without harms, you are sitting there doing protest. Can a police come and arrest you? No. The only reason for which they can arrest you is if it is interfering with the public peace, or you're disturbing or blocking the routes. So if they violate this right, can you file a case against them for recovery of compensation as well as violation of fundamental right? Yes. Freedom of association. You write about freedom of association. To form of association, not to form the association. Trade and occupation. Freedom of trade and occupation. What is the reasonable restriction in the interest of public and professional qualifications? Huh? Professional qualifications. Can you guys read this? Vijay, an accused, committed an offense of dacoity. No, tell me, I think I missed one part. Tell me, if a person forced to undergo narco analysis test without his permission, is it a violation of Article 20? Article 20, Clause 3. Which clause? Self incrimination. What incrimination? Because you are accused of an offense and you are forced to give a witness to against yourself. It is a violation of which article? Article 20, Clause 3. The Supreme Court held that narco analysis test imposed upon a person without his permission, not valid. It's a violation of Article 20, Clause self incrimination. What incrimination? Self incrimination. Clear with this? Question number one. Can you guys read this question number one? Vijay accused committed an offense of dacoity in 2015. What is the imprisonment? 10 years. 2016, during his trial, a law passed which made dacoity punishable with imprisonment. So, what is the punishment for him? 10 years or life imprisonment? Ex post facto loss. Double jeopardy. Can you write answers for double jeopardy? Can you guys answer this question, please? Mahindra, this question. Clear? But how to write answers for this? Can you guys read the answers as well? A person present the answer in the point forms only, like this only. See, as I said, follow the question bank answer, but depending upon the weightage of the question, you tailor the answer in the examinations. Okay, you may increase the points with explanations, or you may reduce the number of points if it is for less number of less mark. Okay, but you should write all the essentials points. What happened in this case? An accused of an offense cannot be compelled to be a witness against himself. In other words, an accused cannot be compelled to state anything which goes against him. Conditions: he must be accused of an offense. There must be compulsion to be a witness. Such compulsion should result is giving evidence against himself. Point. The right against self-incrimination protects a person who have been formally accused as well as those who are examined as what? Suspects in criminal cases. It also extends to cover the witnesses who apprehends that their answers could expose them to criminal charges in the ongoing investigation or in the cases other than the one being investigation. In the given question, what question? The investigating authorities wanted to conduct narco-analysis tests without whose consent, Mahindra's consent, to obtain evidence against himself. This is a violation of fundamental right, Article 20, Clause 3, which has the protections against self-incrimination. Therefore, the use of narco-analysis test on Mahindra without his consent would constitute a violation of his fundamental right. Hence, it is well or not allowed? Not allowed. Clear with this? Life and personal liberty of a person. Can we read this? In this case, is this question is important. Article 21, especially this question, it is recently added in your material. They may ask Article 21 and the right to pay. Right to what? Pay. This case study is important. Satendra Kumar Antil versus CBI. In these, the court has given some few guidelines for the purpose of preventing the abuse of arrest procedure. What procedure? Arrest procedure. Where the court has held that bail should be granted. What should be granted? Bail should be granted. This question is one of the important questions which you should look into before you go to the examination. Next, right to education. Right to education is what? 21A. Can you answer the question? Can you write answers for preventive detention? Okay. Fundamental right against exploitation, 23 and what? 24. DPSP, differences DPSP. Next one, ordinance making power of the president. Under which article? 123. Distribution of what matter? Subject matter. When parliament can make a law on what list? State list. Can you write? National interest, second one. Everybody, second one. Emergency, third one. Fourth one, on the request of two or more state, and the fifth one is to what? International agreements. Interpretation of legislative list. Plenary powers is not there, but pith and substance. What substance? Have I discussed this case law? Rajasthan legislature case law. Pith and substance was that to regulate the sanitation and health. But it was incidentally touching the matter of broadcasting, which is within the competence of parliament. Is this law valid or not valid? Valid. Correct, right? Next one, harmonious construction. Different interpretations possible. You go for the interpretation which is to avoid the conflict and give effect to what? Both the provisions. Honorable legislation. Explain the various principles behind the interpretation of what list? Legislative list. You have to explain in brief all the different rules of interpretations. Four are there. Plenary powers, harmonious construction, with and substance, colorable legislation. Freedom of trade, commerce, and intercourse. Correct, right? Judicial structure of India. This question is important. This question is important. Newly added in your ICS material. Judicial structure of India is well equipped to deal with what? Every kind of cases. You should explain about High Court, Supreme Court, subordinate court, civil court. Writ jurisdiction. Which jurisdiction of Supreme Court and which court? High Court. 32, 226. Habeas corpus. You have the what? Body. Mandamus, short note on mandamus. Prohibition, short note. Certiorari, short note on the wall. Certiorari. Quo warranto, short note on the what? Quo warranto. Then we have what? Delegated legislation. Types and the principles. Legislative function. What is bill? Types of bill. Short note on the what? Finance bill. This is important. Say important. They may ask question on short note on finance bill. I expect this question to come in the upcoming examination. They can ask the question based on explain the finance bill. What bill? Finance bill. Next, parliamentary committees. What committees? Clear? These are the questions which were asked in the previous examinations and also the question which are there in your ICS material. At the end, you have ICS material question, right? I've covered even those questions. Clear? Revision notes with this question and the answers ready for the exams. Clear with this? So with these, we're done with what? Constitution of India. What of India? So we shall start with which chapter now? Chapter number 3. So chapter number 3, interpretation of what? Statutes. What is interpretation of statutes? What is interpretation? Understanding, The meaning of the words used in the statutes from the point of view in which they were expressed by the legislatures. Expressed by whom? Legislatures. So, what is interpretation? Interpretation means it is the process by which who seeks to ascertain, court seeks to ascertain the meaning of the word. Legislatures. Meaning of what? To the medium of authoritative forms in which it is expressed. Expressed by the legislatures. Types of statutes, interpretation of statutes, right? Understanding the statutes, right? When you understand what is interpretation, what is interpretation? Understanding, a correct understanding of the statutes. Now, what is statutes? What are the types of statutes? Statute is nothing but a bill of legislature. Bill of what? The law made by the parliament is called as what? Statutes. Correct, right? So the statutes can be classified into what? Following types. What is the first one? And what is the first one? Codifying statutes. When they codify the unwritten law, what law? And the particular subject matter it is called as what statute? Codifying statute. What statute? Next one is what? Declaratory statutes. See, declaratory statutes will not create a right nor take away right. They just declare or explain the existing law. For example, General Clauses Act. Which act? General Clauses Act 1897 only provides what? The rules of interpretation. Rules of what? It is neither creating a right nor taking away a right. It only provides the principles of interpretation. Next one, remedial. What is remedial? When they alter the common law or what law? Judge-made law. It is called as what? Remedial. Next one, amending. What is amending? To amend the existing law. What law? For example, we have Companies Amendment Act. Which act? Companies Amendment Act. Next one, what is consolidating? To bring together the various provisions which deals with the subject matter. For example, we have IBC, Insolvency and Bankruptcy Code, which consolidate all the provisions dealing with the insolvency of corporations, individual as well as the partnership. Next one is what? Enabling statute. What statute? So when a law removes the restriction or disability, it is called as what statute? Enabling statutes. What is disabling statutes? When they restrain the alienation of what? Property, transfer of property, or it restrict a person from doing something. That is called as what statutes? Disabling statute. Next one is what? Penal. What is penal statutes? Impose the what? Penalty or forfeiture. These are the various type of statutes. What is statutes first of all? The will of the legislation or a law made by the legislatures. Correct, right? What is interpretation? Understand the true meaning or the correct meaning of the statute. What are types of statutes? Codifying, amending, declaratory, remedial, consolidating, enabling, disabling, or penal. If they ask question about this, we can answer in the examination. Next one, need for interpretation. They ask the question based on this concept as well. Why do we need interpretation? What is the requirement of doing the interpretation of statutes? Why? Because find out the what? Everybody to find out the what? Intention of legislature. Bolo bolo intention of what? In case of ambiguity in the words used. What is ambiguity? Confusion. Where more than one meaning is possible. You need to do interpretation of statutes. That's right. Third one, change in what? Environment. Over a period of time, the words used in a statute undergoes a change. For example, the word carriage had a different meaning 50 60 years back, but the word carriage is a different meaning now. At that time, carriage means what? A carriage moved by the animals, but now it is what? Vehicles, electric vehicles also there. So because the words undergo a change over a period of time, what is required? Interpretation is required. Next one, because of what? Complexity of the statutes. Complexity of what? Statutes. The complex, for example, GST. Interpretation of GST requires what? It has to be interpreted, right? Because it is a complex statute, correct? Now, income tax, it is a bit complex. So because of that complexities, what is required? Interpretation is required. Next one, does not cover what area? Specific area. In case of drafting errors, what errors? Any errors in the when drafting the statutes. And the last one in case of what? Incomplete rules. What rules? You need to write these points along with the explanations in one or two lines. Clear with this? These are the reasons for which what is required? Interpretation is required. Tell me what is the first reason? Intention of who? Legislature, ambiguity, change in environment, Complexity of statutes. When legislature does not cover what area? Drafting error, incomplete rules. What rules? Then comes the casus omissus rule. What rule? Have you heard this rule? Casus omissus rule. What is casus omissus rule? See, when a legislature omitted to include certain subject matter or subject certain provisions which he has intended to include. Accidental, it is called as what? Causes omissus rules. I repeat, where the legislator fails to include certain provisions or cover certain areas which he intended to cover. It is called as what? Causes omissus rule. In that situation, the court can make it intelligible. The court can interpret the provision by reading in certain words or by omitting certain words to make the provision more intelligible, reasonable, and workable. To make it what? More intelligible, workable, as well as what? Reasonable. So this is called as what rule? Casus omissus rule. See, I wanted to include something. I omitted it by inadvertent mistake. Now, when you are reading this particular provision, you have to interpret it either by adding a word or by removing a word to make this provision what? More intelligible, workable, or reasonable. It is called as what rule? Casus omissus rule. What rule? It's a situation where legislature has left a specific issue. Underline what issue? Specific issue or a circumstance unaddressed in a statute. The principle gives the court. In such a cases, courts are often guided by what law? Common law to fill the gap. The principle gives the court the discretion to interpret a statute by reading in or removing the words when necessary to make the provision what? Intelligible, reasonable, workable. Who can do that? Courts, either by adding in the words or removing the words to make it more what? Intelligible, reasonable, and also what? Workable. Also what? Workable. Next one. This should only be done when the statute literal reading leads to what? Absurdity. Leads to what? Absurdity, confusion, or inconsistency. Are you guys clear with this? Can you write a short note on causes omissus rule? What is causes omissus rule? It's a situation where the legislature fails to address a specific issue or circumstance. In that case, what court can do? They are governed by the common law to fill the what? Gap. How they can fill the gap? By reading in or removing the words which are necessary to make it more workable, intelligible, and also what? Reasonable. That is called as what? Casus omissus rule. What rule? Next, we have rules of interpretation. What of interpretation? The rules of interpretation. What of interpretation? The rules of interpretations can be classified into how many categories? Two categories. What are two categories? Primary rules, secondary rules. What rule? What is the first rule of interpretation? Literal construction. What construction? Tell me in general, what is literal construction? You will understand the meaning of the words, or you will assign the meaning to the words according to its literal meaning. What meaning? This is the fundamental rule of interpretation, or golden rule of interpretation, or basic rule of interpretation. Every word in a statute should be understood according to their what meaning? Natural, ordinary, grammatical, popular, and grammatical meaning. You have to assign for every word used in a statutes. What meaning? Natural, ordinary, popular, and grammatic meaning, unless such interpretation leads to absurdity or ambiguity. Only when it leads to absurdity or ambiguity, you'll go for other rules of interpretation. Otherwise, in general, you always go for what interpretation? What interpretation? Literal interpretation or literal construction. What construction? Literal construction. It is also called as what rule of interpretation? Golden rule of interpretation. Or what rule of interpretation? And there is a principles. Every word should be given meaning in a statute. We cannot ignore any words in a statute. Why? Because no words are loosely used. And second one is that one should not presume any word. Omission, if a word is there, and you cannot read any word if it is not there. This is called as what rule of interpretation? Literal. What rule? Literal construction of words is a primary rule or secondary rule? Primary rule. Second one, mischief rule. One of the oldest rule of interpretation. Listen, everybody. The moment you find the word called as mischief rule or Aiden's case, you should think that the one word should come to your mind is that object. You are trying to interpret the meaning of the word based on the object of the law or the object for which the law has been made. First, you find out the reason for which the law has been made. According to the reason of the law, you try to find out the meaning of the word. It is called as what rule? Mischief rule or Eden's case. I repeat, the Eden's case is applied only when you could not understand the meaning of the words based on what rule? Literal construction. Basic rule of interpretation is what construction? Literal construction. Or what construction? When literal construction leads to absurdity or ambiguity, then comes the question of what interpretation? Hayden's case. What case? Or mischief rule. In the mischief rule, what you trying to find out? Object of the legislature. Object of the what? Legislature or object of the law. Once you find out the object of the law, according to the or in the lens of object of the law, you try to interpret the meaning of the word. For example, let's say what happened? There was a law which was made. There were a group of prostitutes who used to stand on the road and solicit the customers, causing an inconvenience to the customers and the public. Ban that what government did, government passed a law stating that no prostitutes should stand on the roads to solicit the customers. So what they have done, the women were started standing on the balconies and shouting and doing a lot of noises and to solicit the what? Customers. Police arrested them. Case went to the court. There was an argument saying that, sir, what does the law says? What law says? Standing on the roads and soliciting the customers. We were not standing on the road. We were on the balcony. Balcony. If you go for the literal interpretation, road is different. Balcony is different. Balcony is not a road, right? And yes or no? But however, this will defeat the purpose of the law. What court has done? Court has taken into consideration the purpose for which the law has been made. What has been made? What is the purpose? What is the mischief to solve for which the law has been made? The mischief was there was a public inconvenience. What inconvenience? There was inconvenience caused to the public. To avoid that inconvenience, this law has been made. Correct, right? So, taking into consideration object of the law, court held that. Who held that? Court held that here the object of the law was to avoid or to prevent the inconvenience to the public. Hence, even soliciting the customer standing on the balcony was also held to be what? Punishable. What offense? Punishable offense. इसको बोलता है what construction? Objective interpretation or mischief rule. What rule? अरे what rule? The courts, while applying the principle, trying to find out what intention behind the enactment, real intention. Intention. And for finding out the object of the enactment, you need to answer four questions. How many questions? Arey bolo, how many questions? What are the four questions? What is the first question? What was the common law before making the act? Second one, what was the mischief and defect for which the common law did not provide? Third one, what remedy Parliament has resolved and appointed to the disease of the Commonwealth and the true reasons for the remedy. What for the remedy? Arey bolo, what for the remedy? True reasons for the remedy. What is the first one? What was the common law before making the act? Second one, what was the mischief and defect for which the common law did not provide? What was the old law? What mischief it did not provide for? Third one, what remedy Parliament gave? And the fourth one, the true reasons for the remedy. By answering these four questions, you try to find out the what? Object of the law. What of the law? Next one. Rule of what construction? Everybody, what construction? Don't say what construction. What is reasonable construction? It is also called as atres magis valet quam paret. Means A thing may have an effect rather than it may what? Fail. I'll give it two situations. Listen, there is a provision. Under that provision, there are two interpretations possible. One makes it more sensible and effective, other one which makes it more, which is ineffective or meaningless. Which one you should prefer? The interpretation which makes it what? Or meaning should be preferred over an interpretation which makes it invalid or ineffective. This is called as what interpretation? Reasonable construction. What construction? Reasonable constructions. Are you guys clear with this? Rule of what construction? And what construction? Reasonable construction. The construction of a statute should be such that laws provisions are given effect and make sense rather than being interpreted in a way that leads to absurdity or renders the provisions meaningless. If an interpretation leads to meaningless or absurdity, you should not prefer that interpretation. Rather, you should go for what? Interpretation that makes the provision more sensible or what? Sensible. It is the duty of a court. You know what of a court? Duty of a court in construing a statute to give an effect to the what? Intention of legislature. Intention of what? At the same time, if there is a provision or interpretation which can suppress the mischief, what is suppress the mischief? Solve the problem, avoid the problem, and advance a remedy. Advance a what? You should go for that interpretation rather than for an interpretation which makes the provision meaningless or ineffective. It is called as what interpretation? Reasonable construction. What construction? Rebel what construction? Then comes ICSI favorite question, harmonious construction. What construction? Well, what construction? I will give few points which you guys should remember. Concentrate. When you read a law, you have to read the law as a whole. Means you should take into consideration entire statutes. One provision of a statute should be read having reference to which statute? Other provisions of the same statutes. I repeat, a statute should be read as whole and one provision should be read having reference to which provision? Other provision. Wherever there is a conflict between the two provisions, the interpretation should be made in such a way that the conflict is avoided and the effect is given to what provisions? Both the provisions. What provision? It is called as what construction? Harmonious construction. They may ask this question in the examination. What interpretation? What interpretation? Harmonious interpretations. Clear with this, everybody? And this was applied in interpreting the Article 25, Article 26. See, Article 25 provides the what? Freedom. Provides the what? Freedom. To manage the religious affairs by the religious denominations. State cannot interfere. But however, Article 26 provides that state can make what? Provisions with respect to bring a social change. What change? What change? Social change. Are throwing all the religious institutions, Hindu religious institutions to all Hindus. One says religious denominations can manage the religious affairs without any interference from whom? State. Article 26 states state can make a provision with respect to what? Social changes. What changes? Social changes. So interpreting the both the provisions the Supreme Court held us, it is true that religious denominations can manage their affairs as per their own convenience. State cannot interfere except in how many scenarios? Two scenarios. Because if you say Article 25 is correct, 26 becomes invalid. And if you say 26 is correct, which one becomes invalid? 25. Because there is the conflict now. So what they have done? They had given the effect to what article? Both the article. इसको बोलते हैं harmonious construction. What construction? अरे बोलो what construction? Are you guys clear with the next comes agestum generis? Important, important, important. What is agestum generis? Have you heard the word agestum generis? कुछ तो कुछ ऐड है Do you remember anything about agestem generis? I have discussed this in the class. अरे पागल लोग listen. Agestem generis मतलब क्या होता है sir? Agestem generis. What generis? Agestem generis. Simple say simple. Where there is a enumeration of specific words. बोलो, which is followed by the general words. What word? There is a enumeration of specific words which are followed by a general word. The general word should be interpreted or understood having reference to which word? Specific words. What words? इसको बोलते हैं एजिस्टम जनरस. What generis? Egistem generis. It is also called as of same kind or species. What species? Same kind or species. When this word is applicable? When there is a enumeration of what words? Specific words. That is followed by which word? General word. The general word should be interpreted or understood having reference to which word? Specific words. Example, cat, dog, cow, and other animals. Enumeration of specific words, which are different species of a certain genus. Like it's a general category, one category, but different species. And it is followed by which word? General word. Now, this general word should be understood having reference to which word? Specific word. Now, this other animals means what animal? Domestic animal. What animal? This is called as what? Agestem generis. What generis? But what generis? Agestem generis. Of what kind? Same kind. Or what species? Same species. Or Agestem generis. Of what kind? Same kind, same species. To apply the rule, the following conditions must exist. What is the first condition? Statute contains a what? Enumeration by specific words. The members of enumeration constitute a class. Class is not exhausted by what? Enumeration. It is not stopped. It is a general word following that word. General terms follow the what? Enumeration. There is a distinct genus which comprises more than one species. One species. There's one category with more species. Last one, there is no clearly manifested intent. The general term be given a what? Broader meaning that the doctrine requires. That is called as what? Agestem generis. What generis? Tell me what are the primary rules of interpretation? What is the first one? Literal construction. Second one, mischief rule. Third one, reasonable construction. Fourth one, fifth one, agestem generis. Agestem what? Clear with this? Secondary rules of interpretation are other rules of interpretation. First one, I will give an example. You guys should tell me it is what rule. For example, at the outside, in the second floor, third floor, it is clearly mentioned that girls. That means what? Boys allowed or not allowed? Because express mentioning of one thing excludes the what? Other thing. इसको बोलते हैं expressive unist exclusive what? Altruist means express mentioning of one thing excludes the what? Other thing. Yes or no? Express mention of one thing implies the exclusion of which thing? Another thing. It is also known as what rule? Negative implication rule. The maxim ought not to be applied when its application leads to what? Inconsistency or injustice. Inconsistency or if it leads to inconsistency or injustice, will you apply this express mentioning of one thing excludes the other thing? No. If a benefit is given to fire and sanitation employees, can other public employees also claim the benefit? No. It is clearly mentioned that only what employees? Sanitation employees and fire employees. Fire extinguishing employees. Clear? So express mentioning of one thing excludes which thing? What thing? Other thing. Next one, contemporanea exposito est optima est fortissima in what? Lege. It means what? Interpretation according to time of what? Enactment. When you are interpreting an old statute, what statute? You have to interpret the words used in the statutes according to the time in which the law was made. For example, I give this example, like carriage example. When you are interpreting the contract type, which contract was made in which year? 1850, 1872. Which year? 1872. At that time, carriage means what? Only horse-drawn carriages. Correct, right. So when you interpret the words according to the time at which the law was made, it is called as what? Contemporanea, expositor, est optima, est fortissima, licem. Correct, right? Old statutes should be interpreted as they would have been at the date when they were passed. What was passed? The law was passed. Next one, important one, very important one. Listen, law sister associate. What associates? Known by its associates. Known by its what? Yes, existent generis, same kind or species. What is law sister associates? Known by its associate. You can derive the meaning of one words based on the accompanying word. You can understand one person based upon who is our friend. Right, right. They say, right, show me your friend, I'll tell you who you are. So, correct, right? Yes or no? In the same way, we can understand the meaning of one word based on which word? Accompanying word is called as what? No sister associate. No sister. No sister Allah. No sister associates. It is known by its what? Associates. Known by its what? A word should be known from its accompanying or associating words, meaning doubtful words. What words? May be ascertained by reference to the meaning of the words associated with. The above rule cannot be applied where the general words are deliberately used to broaden their what? Scope. Correct, right? So you can ascertain the meaning of one word having reference to the accompanying word. If the meaning of the word is what? Doubtful. It is called as what? Non-sister associates, known by its associate. For example, let's say the word entertainment has a different meaning when I use the word called as hotel and entertainment. Hotel and entertainment is different. Park and entertainment is different. Amusement park and entertainment is different. Cinema and the entertainment is different. The word entertainment has a different meaning and has a different context. What context? Based on the accompanying word. What word? Accompanying word. The rule is not applicable in the following cases. What is the first case? When the context excludes it, if for sufficient reason can be assigned, that is, it's proper to construe a word in one part of an act different from the word, other part of the act, where it would cause what? Injustice, where different circumstances are dealt in both the scenarios. You not go for non-sister associates, where the words are used in what context? Different context. Next one, strict construction and what construction? Liberal construction. See, simple. When you understand or interpret the words based on the literal meaning. What meaning? It is called as what? Strict construction. What construction? What construction? Interpret the statute in a way that fulfill the underlying purpose. When you interpret the words, fulfill the underlying purpose, a remedy of the law. It is called as what construction? Liberal construction. What construction? ಅರ್ಥ ಆಯ್ತಾ? Strict construction and what construction? Liberal constructions. Next we have presumption. Next we have what? Important. They may ask you to write any 5 or 6 presumption in the examination while doing the interpretations. When you do the interpretation of a statute, you must make the following presumptions. What is the first presumption? The words in a statutes are used what? Precisely and not loosely. They are precisely used and not loosely. Vested rights. What rights? You know what is vested right? Which is already there. Vested interest cannot be taken away by what words? Other than by express words. If there is express words, you can taken away. Without an express mention, you cannot take away what right? Vested right. Mens rea is required for what act? Criminal act. Next one, state is not affected by a statute unless expressly mentioned. To make state liable, you have to mention it expressly. Next one, not to be inconsistent with the principle of what law? International law. Legislature knows the what? State of the law. Legislature does not make any alteration in the existing law. Unless by what enactment? Express enactment. Legislature knows the practice of what? Executive and judiciary. Executive and what? Judiciary. Legislature confers the power necessary to carry out the what? Duties imposed by it. And the law compels no man to do what is futile or fruitless, means useless things. Law will not compel any person to do what is useless. For example, let's say I have made a will and I also transferred. I made a will. Before my death, I transferred all the property to someone else. Tell me, is there any requirement of going to the court to the validity of the will? I have given a will in favor of you. Good. Before my death, I sold all property to someone else. Is the will is valid or not valid? Not valid. Now we want to go to court to prove that the will is valid. Is it possible or not? It's proved it is waste. When I already sold the property to someone else, the will is automatically what? Revoked. Correct, right? These are the presumptions you should make with respect to what? Interpretation of statutes. What are statutes? Array, what are statutes? Interpretation of statutes. Clear with this? Can you write at least 5 to 6 points in the examination? Everybody, what we are discussing now, interpretation of what? What is interpretation? And what is statutes? Law. What are types of statutes? Codifying, declaratory, amending, penal, remedial, consolidating. What are the primary rules of interpretation? Literal construction, harmonious construction, Aiden's rule, then mischief rule, and reasonable constructions and existent juries. What are the other rules of interpretation? Express mentioning of one thing excludes one thing, other thing. Next one, contemporaneous expositor, and the third one, consistent, associates, strict and liberal construction. Strict and what? For the purpose of interpretation, we can take the various helps. When you take the help or seek the help within that statute which you are interpreting, it is called as what? Internal aids of interpretation. What aids of interpretation? What are the internal aids of interpretation? What is the first one? Long title. Second one, preamble. You know what is the preamble, right? Preface to the act. Preamble can be taken or read to understand the purpose of the law. What of the law? Purpose. Remember, I gave the Hindu law example. Marriage can be solemnized only between how many Hindus? Two Hindus. So if there is a marriage between the one Hindu and other religion person, it will not come under the Hindu law. It come under which law? Special marriage. Okay. Next one, heading and what? Title to the chapters. Marginal notes means what? The notes which are written in the margins. Marginal notes cannot be used as a rote aids of interpretation, but only for interpretation of constitution. Interpretation of what? They can be taken as a source of or aids of interpretation. Next one, definition section or interpretation what? Clause. It can be of how many types? Four types. What are type four types of definition? What is restricted definition? Means such and such. It only means only that. You cannot add anything to the definition. What is extensive definition? Includes such and such. For example, the word body corporate includes various things. Company, LLP, foreign company. But company means what? Company which is incorporated under this act or any previous company law. Next one, ambiguous definition. When definition itself is confusing, it is called as what? Ambiguous definition. For example, definition of contract. What is contract? Agreement enforceable by law. Now, what are the conditions of enforceability? It's only ambiguous, right? It is called as ambiguous definition. Next one, subject to the context, contrary to the context. If the definition is opposed to the context, opposed to the what? Context, it is called as what? Subject to the contrary. For example, the word person includes body corporate, individual, association of persons, then HAF, all those things. But however, when it comes to the person as per Companies Act, it only means what person? Natural person and artificial person. Clear with this? Yes or no? These are the internals of interpretation. Then you'll find interpretation illustrations. What do you find? Illustration. Then you have provisions. You know what is provisions? Provisions are the clauses which are added to exclude something or to put a some condition. It is called as what? Provisions. Provisions will be in the form of what? Provided that, provided further that, provided also that. Correct, right? Yes or no? For example, private company. What is private company? It's a company which has minimum paid up capital as prescribed and by its articles, restrict the transferability of its shares, limits the number of members to, except in 1% company, limit the number of members to 200, provided that, and a condition, provided further that, to add one more condition, provided also that, to add one more condition. They are called as provisions. Called as what? Provisions. Are you guys clear with this? Next, we have schedules. What do we have? We have how many schedules in the companies are? Seven schedules. How many schedules? You can take the help of the schedule for the purpose of interpretation of the statutes. These are the internal needs of interpretation. What needs of interpretation? Internal needs of interpretation. Then we have external needs of interpretation. What is the first one? They can take into consideration how the bill has traveled in the parliament. The purpose of understanding the provisions of it. For interpretation of constitutional provision, we refer to debates in the parliament. Debates in the what? Parliament. Correct, right? Next one, reports of the various committee, standing committee, other committees. Next one, reference to the other strategy. See, while reading the SEBI and Securities Contract Act, we can refer to which are companies are because both are analogous statutes. What's analogous statutes? Deals with what matter? Same matter. What matter? Have you heard the word pari-materia? Same matter. What matter? Same matter. Because both the laws are dealing with the same matter, you can refer to both the statutes for the purpose of understanding the provision. Next one. What is the next one? Dictionaries, law dictionaries definitions. And the last one, foreign decision. What decision? Even you can refer to the foreign decision. Next one. Huh. Next one. Prospective and what operation? Retrospective operation. Now tell me, out of substantive law, procedural law, which law can have retrospective effect? Procedural. What law? But substantive law always has what effect? Prospective effect. They cannot have what effect? Retrospective effect. Which laws cannot have retrospective effect? Substantive law. But who can have retrospective effect? Procedural laws. What laws? To make a substantive law effective retrospectively, it has to be clearly mentioned there in the law itself. Clear? Next one. Interpretation of certain terms. You guys tell me what does may indicates. May indicates directory nature. What is nature? And what is shall? Shall conveys the what? Mandatory nature. What nature? May conveys what? Permissive or discretionary nature. Shall conveys what? Mandatory nature. The provision using the word may is enabling provision. What provision? And permissive in nature. But however, we have exceptional rule of construction where may is read as what? Shall and shall is read as what? May. इसको बोलते हैं exceptional rule of construction. What rule of construction? Shall is used even if the nature of the provision is permissive or discretionary, and may is used when the nature of the provision is what? Mandatory. The rule where may is read as shall and shall as may, it is called as what rule of interpretation? Exceptional rules of interpretation. They may ask this question in the examination. What is exceptional rule of interpretation? Possible A. May is often read as shall or must when there is something in the nature of thing to be done which makes it duty of the person on whom the power is conferred to exercise the means if the word may is used with a duty to do something, then the word may should be understood as what? Shall. For example, Section 3 of the Companies Act provides that company may be incorporated. It can be incorporated company. Means only for what purpose? Lawful purpose. Here, may means what? Shall. May means what? Shall. Next one, use of and or. What does and indicates? And indicates what? Conjunctive in nature. What in nature? What is or? Disjunctive in nature. What is and? And indicates what? Conjunctive or indicates what? Disjunctive. Correct, right? Interpretation of provisions. Have I discussed provisions? What are provisions? To add what? Condition to a provision or to exclude something out of a provision. Use the word called as what? Provisions. Clause making some condition or stipulation. Carves out an exception to what provision? Main provision. Have you heard about deeming provision? What are deeming provision? Deemed to be. It's a legal fiction. What fiction? For example, a public company, not public company, private company, subsidiary of what company? Public company is deemed to be what company? Public company. It's a legal fiction. Deemed provision. What provision? Deemed. Clear with this? Next one. Next one. Repugnancy of what statutes? Other statutes. Important, 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 important. To ascertain the meaning of a section, it is not permissible to omit any part of it. The whole section must be what? Read together, and attempt should be made to what? Reconcile all the parts of it. See, in one part, there are two section numbers dealing with two different matters. Both are contradictory, means you should read both and should give effect to what? Both. However, when reconciliation is not possible, if both provisions are there and reconciliation is not possible, which one you will prefer or which one is valid? The latest one. The later one will be what? Valid. When reconciliation is not possible, it has to be determined as to which is the leading provision and which must give way to what? Other. If two sections are repugnant, contradictory, what is the which one will prevail? The last one must prevail. Or which one will prevail? The last one. The recent one will prevail. Next one, conflict between the general provision and what provision? Special provision. Tell me if there is a conflict between the general provision and special provision. Which one will prevail? Special provision. What provision? Example, Companies Act and Insurance Act. Both deals with company. Which company? Insurance company. Now, which one you will follow? Insurance company. Which act? Insurance act. General rule will give a way to which rule? Specific rule. Generally, a specialibus non-derogate means what? General provision do not override which provision? Specific one. This is the core principle of what interpretation? Statutory interpretation. Then we have socially beneficial legislation. Repeat, keep this in mind. When you are interpreting a legislation which is providing benefit to the society, you have to do liberal interpretation. What interpretation? Liberal interpretation. If there are two interpretations possible, one which gives less benefit, one gives more benefit, which one you should prefer? The one which gives what benefit? More benefits. If it is what legislation? Social legislation. You know what legislation? Next one, conflict between the statutes, rules, regulations. Tell me if there is a conflict between the statutes, rules, regulation. Which one shall prevail? Statutes. Which one shall prevail? Statutes. Next one, doctrines. What do we have? Doctrines. What is the first one? Doctrine of substantial count. Simple say simple. See, simple as that. If a good faith good faith attempt is made to fulfill a legal obligation of a law or a contract, and substantial part of the contract or the obligation is performed, but not fully performed, it is deemed to have been what? Fully performed. It is called as what compliance? Substantial compliance. What compliance? Compliance with substantial or essential requirement of something that satisfies its purpose or objective, even though formal requirements are not strictly followed. It is called as what compliance? Substantial compliance. It refers to a rule that if a good faith attempt is made to perform does not precisely meet the terms of an agreement or statutory requirement, the performance is still considered as what? Complete, as long as the essential purpose of the law or a statute or a contract have been fulfilled. You have made an attempt, good faith attempt to fulfill the obligation. You could not fulfill the entire obligation, but you have fulfilled the core purpose of the law or the essential purpose of the law. It is still considered as what compliance? Substantial compliance. What compliance? Substantial compliance. Next one is what? Doctrine of what? Possibility, impossibility of performance. See, impossible, nulla obligatio est means what? Anything which is impossible to perform. Law will not compel any person to do something which is what? Impossible to perform. Correct, right? Yes or no? In contract law, which law? Impossibility of perform is not a excuse. But however, there can be a force majeure. What majeure? Which excludes the promiser from performing the promise in case of impossibility. For example, natural calamities, act of God, all these things. But however, in case of obligations imposed by law, obligations imposed by what? Law. What is the excuse? Impossibility is an excuse. What is an excuse? Impossibility is an excuse. Next one, strict construction and should always go for liberal construction, sorry, strict construction of penal statute as per the literal interpretation. On interpretation, literal interpretation. These are the rules of interpretation. Interpretation of statutes. What are statutes? Then we have General Clauses Act. Which act? Which year? Do you know what is repealment? Repeal means what? Removing the provisions. Removing the what? Provisions are of a loss. For example, there is a X law. This law has been removed. Remove a law also need to make a what? One more law. इसको बोलते हैं repealing statute. What statute? Repealing statute. To remove a provision unto law. Correct, right? As whatever is done under this law, whatever punishment imposed under this law, or whatever investigation going on under this law, which has been repealed, will not be effective. It will continue unless until there is an express provision. For example, recently IPC has been repealed or replaced by which law? BNS. But whatever the investigations were going on under the IPC, whatever the punishment imposed under the IPC, are they affected? No. It is the effect of repeal. Effect of what? Repeal. Section number क्या है? 6. Any repealment of a statute will not revive anything, will not affect the previous actions or event that took place under the what law? Repeal law. Affect any rights, privileges, obligations, liabilities that were acquired or occurred under the what law? Repeal law. Affect any penalties, forfeitures, punishment imposed for the offences committed under the repeal law, or affect any what? Ongoing or future inquiries, legal cases, or remedies. Correct, right? So a repealment of a statute will not affect any of these things. Next one, section number 6A, repealment of an act making what amendment? Textual amendment in the act or regulations. Listen, everybody. Now, for example, let's say there is a definition in Companies Act. Definition in which act? Companies Act 2013. To amend this definition, I made a law called as Companies Amendment Act 2015. Amendment has been made. Later, I removed this amending act. Now tell me, because I removed the amending statute, what statute? Whatever the amendment has been made under that amending statute is also removed or not removed? Not removed. Are you guys getting the provision here? See, a law has been made to amend the provisions of a law. Later, this amendment act is removed. Now, whatever the amendment has been made under that amending statute, will it survive or get affected? Sir, clear? Read. If a central act or regulation repeal the law that had previously changed the text of another central act or regulation, the repeal does not undo these changes as long as the changes were still in effect at the time of repeal, unless the new law clearly states the otherwise. Next one, revival of what enactment? Repeal enact. See, simple. Listen. X law has been repealed by Y law. Later, Z law repeals which law? Y law. Does it mean X law comes into picture again? No. Repealment of repealing act does not revive the repealed act. She has been replaced by her. She has been replaced by her. She was removed by her. Now she has been removed by her. Does it mean she'll come back again? No. To revive the repealed enactment, there has to be a express mentioning of a provision in the statutes. Next one, construction of what? Reference to the repealed enactment means what? See in the Income Tax Act. Which act? Which act? Income Tax Act 1961. Which act? Income Tax Act 1961. It provides that book profit means book profit as per the Companies Act 1956. However, we don't have Companies Act what now? 1956. But Income Tax Act, it still remains the same. Book profit as per which act? Companies Act 1956. So while reading the Companies Act, now book profit means as per which act? Companies Act 2013. Companies Act 2013. Clear? Next one. Computation of what? Right. Computation of what? See, if anything to be done on a particular day, on that day the court is closed. When you can do it? Whenever the court opens. And while calculating the time, starting of the date should be excluded and the ending of the date should be included. However, if the word is clear days, what is? In that situation, what you will do? Both days. Exclude the starting date as well as the ending date. Starting date as well as the what date? Ending date. Next one, gender and number. Gender and what? Number. Words importing masculine gender. What gender? Shall taken to include what gender? Females. And the singular shall include what? Plural and vice versa, unless it leads to contradiction or defeat the purpose of the use. Masculine includes what? Feminine. Singular includes what? Plural. See, if a person is allowed to be a company secretary of subsidiary company, if a person is in full-time employment, what employment? Full-time employment, he cannot be employed in any other company except a subsidiary company. What company? Now the question is, what if the company has more than one subsidiary? Can he be appointed as a CS of more than one subsidiary? Yes. Why? Because singular includes what? Plural. Previous year includes previous years. Understood? Interpretation. Next one. Power to issue include power to add, amend, vary, resign, notifications, orders, rules, as well as the what? Bylaws. As well as what? If I have a right to make a rule, I have a right to amend it, a right to change it, right to modify it. Clear? Yes or no? If MC has the right to make a rule, it also has the right to what? Modify the rules, amend the rules. Clear? Next one. Provision as to offense punishable under how many enactments? Two or more enactment. If a person is punishable under two or more enactment, is he punishable under both the enactment? Yes. But however, he can't be punished twice. For what offense? Same offense. What offense? Same offense. I repeat, where an act or omission constitutes an offense under two or more enactment, then the offender shall be liable to be prosecuted and punished under what? Either or any of those enactments, but shall not be punished how many times? Twice for the same. Clear? Last one, meaning of service by post. Service by what? A service of notice or a document by post is deemed to have been properly done. Moment that is sent by properly addressing, prepaying a stamp duty, and posting by what post? Registered post. Even if it is lost during delivery, it is deemed to have been served on the other person. If it is what? Properly addressed, prepaid by what post? Registered. What post? These are the principles of interpretation of statutes. What are statutes? Now I will ask question. Now you guys should answer. Listen everyone. What is causes omissus rule? What is causes omissus rule? It's a situation or it refers to situation which particular subject matter is left unaddressed by the legislature. In that situation, guided by common law, the court can fill the gap either by reading in or omitting a word to make it more workable, intelligible, or meaningful or reasonable. What is what is so? What next one? Singular includes what? Masculine gender includes what? Feminine gender, unless it is expressly mentioned. For example, if the word bullock is mentioned, there only masculine, not feminine gender. Correct, right? And tell me, uh, if a person is accused of an offense under two or more enactment, can he be tried and punished under both the enactment? But can he be punished twice for the same offense? Different offense? Yes. What is non-sister associates known by its associate? Where there is a confusion or ambiguity of the words used in the statutes, the meaning can be ascertained having reference to which word? Accompanying word. What word? Accompanying word. That is called as what? Non-sister associate. Clear? Tell me, literal construction or golden rule of construction. What do you mean by golden rule of literal construction? The word should be understood as per their word. Natural, ordinary, popular, grammatical meaning, unless it leads to absurdity or what? Ambiguity. Absurdity or what? Ambiguity. Clear with this? Yes or no? With these, we're done with the interpretation of statutes. We'll quickly go to the questions. Everybody concentrate. First question. What is? Can you answer this question? Covered in the short notes. Yes or no? Codifying, declaratory, everybody. Discuss the need and object of what? iOS. Why do we need and what is the object of it? Casus omissus rule. Explain the rule of what construction? Literal construction. Benefits of literal construction. Extra point. Correct, right? You always give the intention of legislature. Avoid judicial overreach. Overreach means court may overreach. They may abuse their powers, right? By going for interpretation. So you should always go for what construction? Literal construction. Whatever is mentioned by the legislature. Next one, mischief rule. How many questions? Four questions. What was the law? What was the mischief? And what is the remedy? And what is the reason for the remedy? Reasonable construction. Reasonable construction. Two interpretations possible. One which makes it more meaningful. Suppress the mischief. Go for that, not the other. Correct, right? Harmonious construction, treat the statute as a whole, having one reference to the other provisions, avoid the conflict, give effect to what? Both the provisions. Next one, ejustem generis. What is ejustem generis? Same species or same kind. Enumeration of specific word and followed by what word? General word. General word understood having reference to which word? Specific words. Are yes or no? Next one, express means exclusive what? Conscious means what? Express mentioning of one thing excludes the what thing, other things. Next one, contemporanea exposito est optima et fortissima lige means express mentioning of one thing excludes the what? Other thing. This is contemporanea. This one is expression in exclusio altrius. Time of interpretation. Non-sister associates, known by its associates. Very good. Strict and what construction? Liberal construction. इसको भी डिस्कस किया था. Penal statute, at literal meaning strict construction, objective or purpose to take into consideration liberal construction, presumptions vested rights cannot be taken away, mens rea is required. Reza, no. Next one, internal rights of interpretation. Can you answer this question? Interpretation of certain terms, exceptional construction. Exceptional construction, where we you read may as shall and shall as what? May. Deeming provision, legal fiction. Conflict between what provision? General provision, special provision. Which one will give weight to which one? Special provision. General provision will give weight to which provision? Special provision. Beneficial construction, which legislations are to be interpreted giving more benefits? Social legislation. What legislation? Doctrine of what compliance? Substantial compliance. Good faith attempt to comply the provisions of the law. Substantially complied, but not entirely complied. It is deemed to have been complied. Correct, right? Next one, impossibility of performance. Excuse only in case obligation imposed by the law, not in the contract, unless there is a force majeure. What majeure? Notwithstanding, meaning of these words, notwithstanding, subject to, nothing in this section shall apply. These are the reading methodology of Companies Act. Which act? You come across with these words while reading the Companies Act. I have explained all these words in detail in the class while discussing the IOS, interpretation of statutes. What do you mean by notwithstanding? It gives an overriding effect. What effect? That provision is superior. What is subject to? While reading this provision, you have to comply with some other provision as well. Next one, nothing contained in the section shall apply. Means, for example, small company. What company? Is the definition of small company applicable to holding and a subsidiary company? No. That is why the word star. Nothing contained in this clause shall apply to holding and subsidiary company, section 8 company. Har ha hai na? Next one, without prejudice means without affecting the other provisions. Last one, that is to state, that is to clarify. For example, one person company, you can form 1% company by having how many person? 1%. That is to say a private company. Use the word that is to say to what? Clarify the meaning. Next one is what? For the purpose of this section, provision or definition. Next one, as the case may be means what? Applicable to both the provisions. General Clauses Act discuss the effect of what? Repeal. Effect of what? Just now we discussed effect of repeal. Computation of what? Time. Exclude the starting date, include the what date? Ending date. Unless clear is what is mentioned. Gender and number. Masculine, feminine, feminine, masculine, singular, plural, plural, singular. Next one. Under the Harmony Acts, two or more enactments. Clear? But he cannot be punished twice for the same offense. Meaning by service of what? Service by post. How it is deemed to have been served? Properly addressed, prepaid, and registered. So with these, we are done with what? Chapter number 3, lesson 3, interpretation of statute. Interpretation of what? See, if you observe all the previous question based on the short note doesn't mean skipping the topics. It means covering everything so that you can answer any of the questions asked in the previous examinations. Even though I have condensed the topics, I have condensed the paper, number of pages to 100, 120 pages. You read that, the short notes. You can still answer all the possible questions after the previous exam. Getting it? And you are answering. Like, was there any strange question for which you guys were finding it difficult to answer? No. Now you at least remember a few points and you can answer those questions as well. One more times of revision, you will have the provisions and examinations becomes easy. And JIGL is the first paper. What paper? First paper. First paper goes well, other papers also go. That boosts your moral confidence. Correct, right? Yes or no? So we have discussed the three important chapters which students find it more difficult. Correct, right? Because the syllabus is vast. the number of registers are moved. Correct, right? So we're done with sources of law, Constitution of India, as well as what? Interpretation of statute. Before getting for a break, lunch break, I will ask questions to you guys. You guys should answer from all the three chapters. Okay? Now tell me, Jeremy Bentham belongs to which school of law? Who gave or who classified the interest into three categories? Rose What are the three types of interest? Very good. What interest? Individual interest, public interest, social interest. Who has classified the laws into properly so-called, improperly so-called? Swami. What Austin? Correct, right? He has given how many attributes of law? What are the attributes? Man, sovereign, sanction. What are types of president? Original president, declaratory president, persuasive president, absolutely authoritative, conditionally authoritative presidents. The types of custom without sanction, having sanction, legal customs, conventional custom, local customs, which articles provides prohibition of discrimination. Article 15. And there are so many clauses in the Article 15, six clauses. How many clauses? Can Parliament make a law on the state list? In how many cases? Five cases. Can President, can President promulgate an ordinance valid for how many weeks? 8 weeks. India is federal or unitary? Second, unitary future. Can Parliament amend any part of the Constitution of India? Yes or no? Tell me, what are the types of parliamentary committees we have in India? Standing committee, other committees, correct, right? Under which article Supreme Court of India has the writ jurisdiction? Article 35. Article 1. Can a children below 14 be employed in hazardous industry? Which article? 24. Can a person be punished twice for the same offense? Which article? 20 clause. Double jeopardy. What jeopardy? Double jeopardy. Can a person be detained for more than 3 months? Only by a recommendation of what board? Advisory board. Correct, right? Which writ provides or which writ is issued to command the what? Mandamus. If a situation is omitted to be covered, which was intended by the legislature, in that situation you apply what rule? Causes omissions rule. What rule? If you have a doubtful in the meaning of a word and it has an accompanying word, no sister associates, where there is a specific enumeration of words followed by general words. Stem generation. Stem. To find out the intention of the legislature, you apply which rule? Aiden's case. What case? Aiden's case. What is the golden rule of interpretation? Literal construction. What construction? Tell me. Singular includes what? Plural includes what? Masculine includes what? Feminine includes what? Masculine. Correct, right? Yes or no? Is preamble is a basic structure of Constitution of India? Can there be a classification? Can there be a class legislation? There can be what classification? A reasonable classification. Can a single person be considered as a separate class? Yes or no? Clear with this? See, we have spent around 7 hours of time in the class and we make use of this time and you are answering all the questions I ask randomly. See, our brain is capable of so many things. Even though I'm shifting from one chapter to other chapter, one chapter to another chapter, you guys are able to answer. You do one more time of revision. One more time what? Revision. Things becomes what? Easy. Even though Mike got exhausted, CSR is not exhausted. I don't need a break, but this mic need a break. ಇದಕ್ಕೆ ಬ್ಯಾಟ್ರಿ ಚೇಂಜ್ ಮಾಡಬೇಕು. ಮೈಕ್ ಬ್ಯಾಟ್ರಿ ಡೌನ್ ಆಗಿದೆ. CSR battery down ಆಗಿಲ್ಲ. Correct, right. Resa, no. So we'll take a lunch break and we'll start at, oh, it's already 3 o'clock. Oh my God. 3, I didn't even realize it. Huh? We'll take a lunch break. See, beta, a simple say simple. Take a break. Come back at 3:30. Exact 3:30, everyone. Take a break. Okay, welcome back. The marathon revision of jurisprudence, interpretation, and general laws. So let's start with chapter number 4, lesson 4. Which law? Administrative law. Make some noise, guys. Which law? Administrative law. Now, what is administrative law, sir? Administrative law is that part of law which deals with the executives. Deals with what? That deals with what? Executive. This is the law which is concerning or which deals with the powers, duties, and functions of who? Executives. Functions of who? As per the Constitution of India, there are how many organs in the Constitution of India? 3 organs. What are the 3 organs of Constitution of India? Legislature, executive, judiciary. What are they? Legislature, executive, judiciary. What is the work of legislature? To make the law. What is the work of executive? Enforce the law. What is the work of judiciary? Interpret the laws. But however, it is not possible to maintain the separate or absolute separation. There are few situations or cases where the executives make the laws or perform the judicial functions. What functions? Judicial functions. So administrative law deals with that branch concerning with the what? Rights, duties, powers, functions of what? Executives. Let's start. Definition of administrative law. What do you mean by administrative law, sir? Is that branch of law? What branch of law? That branch of law that deals with what? Powers, functions, and responsibilities of various organs of the state. What organs of the state? Various organs of the state. Administrative law determines the organization, powers, and duties of what authorities? Administrative authorities. What authorities? Administrative authorities. Why do we need administrative law? What is the need for having a what law? Administrative law. What law? Administrative law. What is the first reason? The first reason is changing in the role of what? Law or the state. Earlier, state means the government, the executives only used to perform the executive functions. But in the modern days, government functions the various activities like welfare activities for the purpose of public. We have a EPF, Employees Provident Fund Organization, EPFO is there, ESIC is there. So because government is playing more and more role in the society, there is a requirement of law to oversee and balance the rights of the individual and also the rights of whom? Government. So because of change in the role of the state, earlier we had a laissez-faire means what? Less intervention of the government, but now there are more interventions by the government in various departments. For that reason, we need what? Law. We need what? Law. Second one is what? Increased what functions? Administrative functions. What functions are? There are many administrative functions nowadays. Administrative authorities functions performs what function? Legislative functions as well as the judicial functions as well as what function? So because the executive or administrative authorities are performing the various functions, there is a requirement of what? Administrative law. Third one, to ensure the balance between what? Government and individual rights. Whose rights? Nothing but individual interest as well as the government interest. Correct, right? Next one, instrument of control and what powers? Administrative power. We have the judicial review, right? What review? Where the court reviews the administrative actions of the government, and if they are found to be or found to be in violation of fundamental right, the court will declare them as what? Invalid. Correct, right? So these are the 3 reasons why or because of which we need what law? Administrative law. What is the first one? Change in the role of the state. Second one, increasing administrative function. Third one, to ensure the balance between the government and individual rights. And the last one is it's an instrument of control on the administrative parts. What parts? Clear with this? They may ask question in the examination. What is the need for what law? Administrative law. Next one, we have sources of administrative law. Tell me what are the important sources of administrative law? Constitution of India. Constitution of India does not advocate the absolute separation. In the Constitution of India itself, there are provisions which authorizes the executives to make the law. Nothing but president can promulgate the ordinances. Correct, right? President is part of what? Executives, and he can also make the laws. Yes or no? And we also have various tribunals, and we also have the various commissions. For example, we have UPSC commission. What commission? UPSCs. So, Constitution of India is the major sources of what law? Administrative law. What law? Then we have what? Act or statutes. The act or the statutes enacted by the parliament can delegate the power to the executives to make the laws, or they can constitute a administrative tribunals. What tribunals? Administrative tribunals. That is the one sources of what law? Administrative law. Next one, ordinances, administrative directions, notifications, and circulars issued by whom? President. Issued by whom? Ordinances. Who makes ordinances? Presidents. Uh, President. Ordinances, notifications, and directions and circulars can also delegate some of the power to the executives. And when the executives using these powers makes the law, it is called as what? Administrative law. Last one, judicial decision. What decision? Even the judgments of the court can confer the powers on the executives to make the laws. So administrative law deals with what part? The functions of the executives. What are the executive? Functions of the executive. These are the four major sources of administrative law. Tell me what are the four major sources of administrative law? Constitution of India, acts or the statutes, ordinances, judicial decision. What decision? Tell me, in India, what is superior? Who is superior? Constitution of India, President, Governor, CSR. Who is superior? अरे पागल लोग. Constitution of India is superior. What is superior? Constitution of India. Because rule of law. What of law? Rule of law. Everybody is bound by the what? Law. Who is superior? What is superior? Law is superior. Rule of law was developed by which jurist? British jurist called as what? A.V. Dicey. A.V. what? It states that government should be governed by the rule of what? Law. The government should follow the rule of law. What of law? Not by the whims and fancies of what? Individuals. The government should be governed by what? Rule of law. What of law? Not by what? Individuals' law. What law? Individuals' law. Each country should follow what? Legality of law. What of law? As per the Dicey, as per the A.V. Dicey, a rule of law will have three major components. What are they? Supremacy of law. What of law? Next one, equality before the law. Third one, predominance of what spirit? Legal spirit. Tell me from Indian context, do we satisfy all these three conditions? Do we have supremacy of law? Yes or no? Constitution of India is the supreme law which all other organs are supposed to follow. Second one, do we have equality before the law? Which article? Article 1, 14. Next one, predominance of what spirit? Legal spirit. What spirit? The legal spirit following the rule of law in its works as well as the spirit is a requirement. Correct, right? Everybody is bound by the legal spirit of the what? Laws. Justice, equity, and the good conscience. All these three are there in which constitution? Indian constitution or the Indian legal system. They may ask question based on rule of law. I will tell you guys how the questions will come based on rule of law. Listen, everybody. Based on rule of law. Based on what? Rule of law. They may ask this question. They may ask this question. Mark it important, 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 most important. What is the or where does the rule of law embedded under the Constitution of India? I see it's to us to question based on this in the upcoming examinations. So the rule of law is embedded in the Constitution under the multiple parts. Important aspects are as under follows. What is the first one? Preamble. What is the first one? Correct, right? It upholds the what structure of constitution? Basic structure of the constitution because it talks about what? Justice, equality, liberty, dignity to whom all citizens or all individuals. Part 3, fundamental rights. What rights? And part 4 is what? DPH, means Director Principles of what policy? State policy. These are the 4 parts in the Constitution of India where what is embedded or what is invaded? What of law? And who gave rule of law? AV Dicey. AV what? Dicey. Have you seen this question anywhere? Have you heard this question anywhere? This question is there in your ICSI material. What material? ICSI material. And most of the questions will come in what material? ICSI material itself. Some or the other ways. This question was never asked before in the examinations. If it never asked, there are more chances that this question may come in the what? Examination. See, with respect to AV Dicey, with respect to what? AV Dicey, there is already a question in the last exam. Last attempt, they asked a question about what? Rule of law by A.V. Dicey. Now that part is done now. So what is the remaining part? Rule of law embedded in the what? Constitution of India. Our question bank and short notes cover both to be in a safer side. What side? Safer side. Yes or no? CSR, CSR. Next one. Administrative discretion. What discretion? Arey bolo, what discretion? It's discretion. Darshan, what is discretion, Darshan? Which gives the power to a person to choose among the various alternatives available using his brain. Using his what? Rule of reasons. Using his what? Rule of reasons and justice. That is called as what discretion? Administrative discretion. Arey bolo, what discretion? It means the freedom of an administrative authority. What of an authority? Freedom of an administrative authority to choose from the amongst the various alternatives, but with reference to the what? Rule of reason and justice. Bolo bolo, rule of reason and what? Justice. Not according to the personal whims and fancies. So you have to decide. Discretion means authority given to the administrative agencies to choose among the various alternatives available based on the rule of reason and justice. Rule of reason and what? Justice, not according to the personal whims and fancies. Whims and what? Fancies. Need for administrative law. What law? Are not administrative law. Administrative discretion. What's administrative discretion first of all? Freedom to choose among the various alternatives available based on the what? Rule of reason and justice. Rule of reason and justice. Why do we need administrative discretion? One more important part based on which there can be exact questions in the what? Examination. Why? Because government cannot function without exercise of what? Some discretion by its officials. Why? Because we cannot have a written law, a ready-made law for every situation, every given scenarios. Is it possible? Not possible. Not possible. There may be new situation, new scenarios which are not already dealt with. So in those situations or in those scenarios, tackle those situations. What is required? Administrative discretion is required. It is difficult for the government to function without any what? Administrative discretion. Second one, it is necessary because it is humanly impossible. Possible, impossible. Humanly impossible to lay down the rule for every conceivable eventuality. Correct, right? Is it possible to provide for every conceivable eventuality? No. That is why to deal with unexpected event or circumstances, what is required? Administrative discretion is required, where a person will choose the best alternative based on the rule of reason and the justice. Rule of reason and what? Next one. Administration has become highly what? Complicated. Highly what? Needing a good deal of flexibility apart from technical knowledge, expertise, and know-how. And the last one is certain rule is found to be unsuitable in what? Practice. The administration can change, amend, or abrogate without what delay? Much delay. Correct, right? For example, these rules. Rules can be modified by just notification in what gazette? Official gazette. Government can make rule today, then they can change tomorrow. But is it possible to do the same thing with an act? Act requires a what? Bill to be passed where? Parliament. Yes or no? So for all these reasons, what is required? Administrative discretion is required. First of all, tell me, what is administrative discretion? Freedom to choose among the various alternatives based on rule of reason and justice. Rule of reason and what? Clear with this? Now, administrative discretion are always tend to abuse. There has to be some control. There has to be some check over the discretionary power given to whom? Executives. Given to whom? Are given to executive. The biggest check and the administrative discretion is judicial review. What review? Now you guys tell me, is judicial review what review? Are bolo what review? Is it the basic structure of Constitution of India? Yes or no? The judicial review can be classified into three categories. How many categories? What are three categories? Constitutional, statutory, ordinary, or equitable. Everybody, what is the first one? Second one. Third one, ordinary or equitable. First one, constitutional. Constitution of India, judicial review can be classified into two categories. What are the two categories? At the stage of delegation of power, at the stage of exercise of delegation. Exercise of what? I repeat. First of all, you should know what is administrative discretion. What discretion? Need for administrative discretion. Judicial review of administrative discretion. How many types are there? Three types. Judicial review as per the constitution, judicial review as per the statutes, and third one is what? Ordinary or equitable. Ordinary or judicial review as per the constitution can be classified into two categories. One at the stage of delegation of power, one at the stage of what? Exercise of delegation. Exercise of what? First one, judicial review. Bolo, what review? What is the judicial review? It is authority of the court. Bolo, authority of who? Declare what? Void. The acts of what? Legislature. And if they are found to be in violation of what? Provisions of constitution. Simple say simple. Judicial review of the judicial review, executive action at the stage of declaring delegation of discretion is that check the law which is delegating the discretionary power is constitutionally valid or void. If it is against the fundamental right, it is considered as what? Invalid. And who will declare them as invalid? Court. Under which article? Article 13 of the Constitution of India. What are Constitution of India? Article 13. Yes or no? Which law gives the judicial review power to the court? As per which law, Supreme Court and High Court have a judicial review power? Constitution of India. What of India? As per the Constitution of India, there can be judicial review of whose discretionary function? Administrative authorities, administrative discretions. The judicial review of the administrative discretion can be done at how many stages? Two stages. Well, how many stages? What is the first one? Delegation of administrative discretion. Second one, exercise of administrative discretion. Exercise of what discretion? Administrative discretion. What is the first one? Administrative discretion and article what? 14. Article what? What is Article 14, ladies and gentlemen? Right to equality. It prevents what? Arbitrary discretion. Remember, arbitrariness and Article 14 both are what? Enemies. Born enemies. Wherever there is an arbitrariness, there is no equality. Wherever there is an equality, there is no arbitrariness. Yes or no? Yes or no? So if there is a law which gives an arbitrary power or arbitrary discretion, what is arbitrary? Arbitrary means random discretion. What discretion? Now what if I say, Darshan, you can come to class whenever you want and you can go home whenever you want. What he will do? He will abuse the discretion for sure because it is random. There is no control. There is no boundary for this. Yes or no? Yes or no? So any arbitrary power, what power? Arbitrary power. Any law which grants arbitrary discretion. What discretion? What is arbitrary? Random. Is it a lawful or unlawful? Is it a violation of Article 14? If a law is in violation of Article 14, right to equality, can that law be declared as void by the High Court or Supreme Court? Yes. Under which article? 13 of the Constitution of India. What of Constitution of India? 13. Everybody concentrate. Are you guys listening to me? Yes or no? Administrative discretion and Article 14. Which article? Article 14. It prevents the arbitrary discretion, right to equality. Well, right to what? Offers a protection not only against discretionary laws passed by the legislature, but also prevents arbitrary discretion being vested in the what? Executive. First of all, Parliament cannot make a arbitrary laws. What laws? Not only that, even if there is a law which delegate arbitrary discretion. Can that law be challenged under which article? 14. And judiciary can review it and declare that law as void. Next one, administrative discretion and Article 19. Article what? Arey bolo, Article what? What is Article 19 deals with? Freedom. Bolo, Article 19 deals with what? Freedom. Right to freedom. Right to what? Correct, right? We have a freedom of speech, freedom of assembly, freedom of association, freedom of movement, freedom of residence, and freedom of practicing any profession. Yes or no? But however, are they subject to reasonable restriction? Yes or no? Yes. But however, what if there is a law? What if there is a what? Law which is giving a discretionary power to the executives to interfere with your freedom? And that discretionary power is uncontrolled, unguided, unprincipled. Is that discretion valid or not valid? Not valid. It means it is unreasonable. Any restrictions on our fundamental rights must be reasonable. Agree with this? But what if there is a you are giving a there is a law and giving a authority to the executives to interfere with the fundamental rights, but it is uncontrolled, unguided. Is that discretion valid or not valid? Not valid. Under which article? 19. Clear? Let's read. The reasonableness of the restriction is open to what review? Judicial review. Unguided, bolo, unrestricted, unlimited discretion in respect of interfering with these fundamental freedom is deemed to impose what restriction? Unreasonable restriction on those freedoms. What freedoms? On those freedoms. Are you guys clear with this? Judicial review. Bolo, what review? At the stage of what? Delegation of discretion. Delegation of what? Discretion. Delegation of what? Under which article it can be reviewed? Article 14 and Article 19. What is Article 14? Right to equality. Article 19, freedom. Can it be reviewed by the judiciary? Array concentrate, yes or no? Can it be declared as void? Who? Judicial. Next one. Judicial review at the stage of what? Exercise of discretion. Exercise of what? Discretion. Guys, I have a strong feeling that they may ask question based on this also. Like what are the judicial review at the stage of delegation of discretion? Delegation of what? Discretion. Next one, judicial review. What review? Array bolo, what review? At the stage of what? Exercise of jurisdiction, discretion. What is the first one? Abuse of discretion. If an executive exercise the discretion, which is abuse of his discretion, the court will review it and declare that action as what? Invalid. Action as what? Invalid. Correct, right? What are the reasons or what are the situations in which the court can review and can declare the action of an executive is invalid if it is an abuse of discretion? When can we say there is an abuse of discretion? Abuse of what? Discretion. What is the first situation? Exercise of discretion in what manner? Qualified manner. What is qualified manner? Bad faith. What faith? Bad faith. Next one, irrelevant consideration. What consideration? You take into consideration irrelevant facts. What facts? Irrelevant facts while taking the decision or exercising the discretion. In that situation, who can declare that action as invalid? Judiciary. Correct, right? Next one, laying out what? So not laying out, leaving out what? Relevant consideration. Relevant what? See, for dismissal of an employee, you should take into consideration what is the conduct. Correct, right? But you're taking into consideration its political connection or political beliefs. Is it abuse of discretion? Just because you support Congress, I dismiss you from your employment, not because of your conduct in the business employment. Is it a abuse of discretion? Yes, because I have taken irrelevant consideration. What consideration? Next one, arbitrary orders. What orders? What is arbitrary? Lack of application of mind. It's a random orders. Is also considered as abuse of discretion. Next one, improper purpose. What purpose? Arey bolo, what purpose? What is improper purpose? Authority is given for one purpose, but you are using it for what purpose? Some other purpose. In that situation, it amounts to what? It amounts to what? Abuse of discretion. Remember, I given the Pakistani example. There was a law which has given a power to an executive to rehabilitate anyone who comes to India because of minority harassment to the minority. There was a law in the law made by the executive government or rules made by the law made by the parliament giving the power to an executive accommodate or rehabilitate anyone who comes to India because of religious persecution. Correct, right? But however, a person had come to India for medical treatment. What treatment? What treatment? Medical treatment. What treatment? Medical treatment. And that person has been rehabilitated under in India under the same provision. What provision? Same. Tell me, is it a rightful exercise of discretion or wrongful exercise of discretion or abuse of discretion? Abuse of what? Discretion. Can that be reviewed by the court? Can it be declared as invalid? At the what stage? Exercise of discretion. Next one, non-compliant colorable exercise. What exercise? Don't have a power to do that, but you make it look like you have a power to do that. It is called as what? Tolerable exercise of power. It is also considered as abuse of discretion. Non-compliance with what requirement? Procedural requirement and principles of what justice? Natural justice. Are what justice? That also amounts to what? Abuse of discretion. Last one, exceeding jurisdiction. Exceeding what? All these are called as abuse of discretion. In this situation, who can review? Court can review and declare such actions as what? Valid or invalid? Invalid, 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 invalid. Are you guys clear with this? So we are discussing judicial review. What review? Judicial review. What review? At the stage of what? Exercise of discretion. Follow what of discretion? Exercise of discretion. Next, we have non-application of mind. What application of mind? Non-application of mind, which you guys do most of the times in most of the classes. Correct, right? Huh. And the message has reached to the one which for whom it was intended to. So non-application of mind. What application of mind? Non-application of mind. What is the first one? Acting under dictation. I have given a power to take decision, applying your own mind based on the rule of reason and justice. But you're just following the orders of the executives. Orders of what? What of executive? Orders of executive. There is a classic case based on which I feel they may ask question in the examination while solving the Q and A's. I'll discuss that situation. If you have not used your discretion, even though you have a discretionary power, you are just acting as per the order of a superior person. What person? It is also and that can be reviewed by the court and declared as invalid. Next one, self-restriction. What restriction? You only put your own rules or modus operandi to decide the cases for every situation. If that is the case, then why legislature will give a discretion to you? They're only from the rules. We are giving discretion to you so that you apply your mind to a given situation and decide it according to the requirement. Every case is different, right? Now, what if you say this is the procedure, this is the rules, I will take decisions in this way? Valid or not valid? Not valid. Remember, I have discussed a situation where a person has given a prototype or model of Victoria carriage, taken approval. He has given a restriction saying that anyone who comes to him for the purpose of permission. They have to come with a specific model or specific design. It's nothing but what restriction? Self restriction. You're acting what? Putting a restrictions to your own self. Correct, right. Next one, acting mechanically and without what care? Due care. What care? Every situation you're deciding in the same way without considering the what? Facts of the each case. Facts of the what case? Each case. What case? Each cases are different. That is why we have given you the administrative discretion and you have to decide those cases applying your mind according to the rule of reason and justice. That is why we have the concept of discretion, right? When you don't do that, It means you're defied if you are defeating the entire purpose of what? Discretion. Entire purpose of what? Discretion. Are you guys clear with this? We're discussing which law? Administrative law. What law? First, we discuss the definition of administrative law, then we discuss the need for administrative law, then we discuss the sources of administrative law. Most important, we discuss the rule of law. What of law? Rule of law. How it is embedded in the Constitution of India. Fundamental rights, preamble, directive principles of what policy, state policy, administrative discretion, need for administrative discretion. What discretion? Administrative discretion and judicial review. What review? Judicial review. At what stage? At the stage of delegation of discretion. Second one, at the stage of exercise of the judicial discretion as per the Constitution of India. Not of India, Constitution of India. The stage of delegation of discretion. There are two articles, Article 14, Article 19. Arbitrary, Article 14, violation, void. Article 19, unguided, uncontrolled, limited interference with the fundamental rights, it is considered as unreasonable, it is void. At the stage of exercise of discretion, we can classify into two categories. First one, abuse of discretion. Second one, non-application of mind. Bolo, bolo, non-application of mind, non-application of mind. Right. Under the abuse of discretion. What is the first one? Malified, irrelevant consideration, relevant consideration. Third one, improper purpose, tolerable exercise of power, exceeding the jurisdiction, arbitrary orders. Non-application of mind. What is the first one? Acting under what? Dictation, self-restriction, acting mechanically and without what care? Due care. What care? Clear with this. Next, we have statutory. What is statutory, sir? We have a statutory appeals. What appeals? Regular what appeal? What appeals? See, there is a law. The law itself gives appeal provision to go against the orders passed by the executive. For example, Tashildar court. You know what is Tashildar court? Tashildar also hear the dispute. Against Tashildar, you can go to the AC court. You know what is AC court? Assistant Commissioner court. Against AC, you can go to a DC. So, law itself is providing an appellate provision to have a check on the discretionary powers of the executive. This is the one more judicial review as per the what? Statutory provision. What provision? Statutory provision. Or what provision? Next one, reference to which court? High court or statement of case. Remember, a lower court. What court? Lower court. Better in the same way. Listen. NCLT is a discretion. NCLT is executive or judiciary? Executive. Against NCLT orders, you can go to where? NCLT as per the Companies Act itself. So Companies Act itself provides the provision for judicial review of action of whom? Executives. Against NCLT, where you can go? Supreme Court. Next one, there is a concept called as reference of case to the High Court. Lower court can refer the case to which court? Which court? High Court. To seek any opinion on the question of what of law? And the opinions given by the court is what? Binding. उसको बोलते हैं reference. क्या बोलता है? Reference. Which court can refer the case to which court? Lower court can refer the case to which court? Higher court for its opinion. Its opinion, High Court's opinion. Clear with this? This is the one more judicial review. Next we have ordinary or what? Equitable. Then we have what is ordinary or equitable? It's a preventive remedy. What remedy? We have injunction. If an executive is doing something which is violative of your rights, you can get an injunction from the court. What from the court? Injunction. Keep this in mind. Wherever the word equity comes, it's a discretionary power. What power? Court may grant it, may not grant it. Who may grant it? Court may grant it, may not grant it. Correct, right? That is why it is called as what? Discretionary power. What power? There are various types of injunction. What are types of injunction? Prohibitory injunction, mandatory injunction. What is prohibitory? Prevent a person from doing something negative in nature. What is mandatory? Command a person to do something. Correct, right? Prohibitory injunction can be of how many types? Two types. Temporary injunction, perpetual injunction. What is temporary? For the time being, interim orders. Correct, right? What is perpetual injunctions? After disposal of the case, which runs for a perpetuity or a fixed period of time. What period of time? This is the one more control over the administrative discretion. Next one, declaratory action. What action? You are confused with the right. For example, let's say there is a property. Government is also claiming it, you are also claiming it. Go to the court. Court will decide the property belongs to whom and gives a declaratory decree. What decree? Which declares the rights of the parties. This is the one more remedy for what? Administrative discretion. Last one, action for what? Damages. Bolo bolo, action for what? What is damages? Compensation. These are the judicial review or control over administrative discretion. First one as per constitution, second one as per what? Statutory, third one as per what? Action for damages. What for damages? Action for the damages. Below action for what? Damages. Are you guys clear with these, ladies and gentlemen? Yes or no? Next आएगा अपना टाइम आएगा प्रिंसिपल ऑफ व्हाट जस्टिस नेचुरल जस्टिस मेक सम नॉइज गाइस प्रिंसिपल्स ऑफ व्हाट जस्टिस one more time what justice important say important hai there are two principles natural justice means sahaj dharma means it is a part and parcel of justice if these principles are not followed there is no justice if there is no principles of natural justice are not followed if the principles of natural justice are not followed they can directly approach to high court under what petition? Writ petition. Correct, right? So, what are the principles of natural justice? Vignesh, there are two principles of natural justice. One is what? Rule against bias. What against bias? Not bhaiya. Rule against bhaiya nahi hai. Rule against bias. And next one is what? Rule of fair hearing. What hearing? Are bolo, what hearing? Fair hearing. What is rule against bias? Huh? Very good. No one can be a. In what case? Why? Why? Why no one can be a judge in his own case? Because he have a prejudicial mind. What mind? He will make a decision before hearing the case itself. For example, if there is a dispute which involves my son and some other person's son, obviously I will decide the case as per whose son. Correct, right? My son, because my son is my son. Other person is some other person's son. Correct, right? I have a prejudicial mind. What mind? Prejudicial mind towards relatives. Correct, right? So I should not act as a judge in that particular case. What case? Particular case. Correct, right? So we have rule against fire, bias and rule of fair hearing. What hearing? Rule against bias means nemo judex in causa sua. Hello? Nemo judex in causa sua. What does it mean? No one can be a judge in one's case. What case? One more time. No one can be a judge in his own case. And the bias can be classified into how many categories? Three categories. What is the first one? Pecuniary bias. Are what bias? If you have any voluntary interest either in the parties or in the subject matter or in the outcome, you should not act as a what? Deciding authority. What authority? Deciding authority. What authority? Deciding authority. For example, there is a committee to decide which book should be selected for the exhibition. There is one book which is written by me, and I'm also in the committee the selection of the book for the exhibition. Should I act in that committee? Why no? Because I have a bias. What bias? Pecuniary bias. What bias? What if there is a cooperative society in which I have done some investment? That cooperative society has a dispute with some other person. Both of them come before me to decide the matter. Tell me, should I act as a deciding person? Should not act as a deciding person. Why should I not act as a deciding person? Because I have what bias? Pecuniary bias. अरे बोलो what bias? Peculiar bias नहीं है. Peculiary bias. What bias? Peculiar. Peculiar नहीं है. Pecuniary bias. What bias? Pecuniary bias. Darshan, next one, Darshan. Personal bias. What bias? What is personal bias? If a person, deciding authority, is having any personal relationship with the parties to the dispute, he should not act as a deciding authority. Correct, right? It can be a friend, he can be a relative, or he can be an enemy. Even if you have a relationship of, even if you have an enmity with any one of the parties to the dispute, can you act as a deciding authority? No. Next one, subject matter bias. What bias? The subject matter, if you have any biases. For example, I'm a hardcore supporter of Hindutva, and now there is a dispute with respect to what? With respect to the Ram Janmabhoomi. In that case, should I act as a judge? No. Now, what if there is a dispute with respect to RCB? I'm a hardcore fan of RCB. Now, I want to decide that case. Should I act as a judge or deciding authority? No, because I have a bias. What bias? Subject matter bias. What bias? How many types of bias? Three types. Pecuniary bias, personal bias, subject matter bias. Are you guys clear with these, everybody? Yes or no? Next one, rule of fair hearing. What hearing? What is fair hearing? The part. Follow? The purpose of this revision, right? By the end of each chapter, you should be in a position to remember the points and write in the examinations. Correct, right? I will be asking questions individually as well at the end of each chapter. Okay, concentrate. Rule of what hearing? Fair hearing. What hearing? What is fair hearing? Both the parties should be heard before arriving at a decision. Audi alterum partem. Bolo. Audi alterum partem. Means here the which side? Here the other side or both the sides. So there are following ingredients of what hearing? Fair hearing. What are the ingredients of fair hearing? What hearing? Fair hearing. What is the first one? It is the first or the first important element of fair hearing. Other party should be given the notice of accusation and intimating him the grounds on which the accusation is preferred by the other party and within the time limit to defend his suit. Defend his what? Suit or the case or accusations. Second one, right to present the what? Case and evidence. Case and what? Who should be given the opportunity to present his evidence and the case? Opposite party. What party? Either by orally or documentary, either by himself or to the legal counsel. Right to rebut the what? Adverse evidence. What is rebut? Deny the evidence of whom? Opposite party. That is why we have the concept of what examination? Cross examination. You do examination, we do cross examination just to disapprove it or just to make it prove it wrong. Prove it what? Wrong. And right to what representation? Legal representation. Means I can represent it, I can be represented by whom? By a legal practitioner. What practitioner? Next one is what? Disclosure of evidence to whom? Party. Follow disclosure of evidence to whom? Party. Ah, yeah. Next one. Speaking order. What order? What do you mean by speaking orders? What does it mean? Tell your own story. What does it mean? The judgment given by the judgment given by the judgment given by the deciding authority should be such that it should speak for itself. Means you should provide the reasons for your decision. What for decision? Reason for decision. इसको बोलते हैं रेश डिसिडेंटी. What डिसिडेंटी? रेशियो डिसिडेंटी. ఏమండి? Ratio decidendi. What is ratio decidendi? Reasons for the decision. What for the decision? Reason for the decision. Yes or no? Adi. Reason for the what? Decision. Correct, right? Why it is important to provide reason for a decision? Why? Because it becomes easy for the other party, easy for the one who is aggrieved prefer the appeal because he'll know the reasons for which decision has been granted in such a way, and it becomes easier for the higher court to what? Hear the appeals, right, right. It will impose us an obligation upon the deciding authority to apply his mind. If he is not required to assign the reasons, he will decide randomly. Correct, right? But what if he is bound to give a reason? What he will do? He will apply his mind. Yes or no? These are the reasons for which the orders or the judgments given by the executive should be based on the reasons. Based on what? Reason. These are the ingredients of what justice, principles of what justice. You know what justice? But however, there are exceptions to these principles of natural justice. Are ingredients of what justice? Natural justice. What is the first one? Statutory exclusion. Simple saying simple. See, if there is no provision in the statutory law, you need to follow natural principles of justice. What if law itself excludes application of principles of natural justice? For example, petty crimes. What crimes? The court says there is no requirement of following the what principles of justice? Natural principles of justice. In that situation, there is no requirement of following the what principles of justice? Natural principles of justice. Next one, emergency. Next one is what? Arey bolo what? Emergency. The building is collapsing. Will you first give a notice to the owner? Hear the his case, then you will destroy the building? No. Straight away what? Destroy the building. Yes or no? Because it is emergency. Next one, interim disciplinary action. Suspending the student, suspending the employee for the temporary purpose, temporary time till the investigation is completed. For this kind of actions, there is no requirement of following what principles of justice? Natural principles of justice. Next one, academic evaluation. When they give your marks or when they give the grades, will they give a notice? Will they hear you before giving any gradings? No. Last one, impracticability. Let's say there are thousands people involved in the same offense. Is it possible to give a notice to everybody, hear them, then give a decision? Possible or not possible? Not possible. It is highly impracticable. If it is highly impracticable, there is no requirement of what? Following what principles of justice to steal? Natural principles of justice. Natural principles of what? Justice. Yes or no? Whoever watches this marathon video, there is no need to increase the speed. Generally, what students does now, they always watch it in the what? 2x speed, 3x speed, 4x speed. Mera video too, it is not required. I'm already in what x speed? 5x speed. Um, Are you guys clear with exception to the principles of natural justice? Principles of what justice? Natural justice. That is the power of CSR. Exception to what principles of justice? Natural principles of justice. Are you guys clear with this? What are the natural principles of justice? Rule against bias. Rules ordering, fairing. What are the rules against bias? Nemo, judex, Nemo, judex, Nemo, judex, in causa sua means no one can be a judge in his own case. There are how many bias? What are three bias? Peculiarity bias, personal bias, subject matter bias. What are the rules of fair hearing? Right. Ingredients of fair hearing, audio from partner. Here the both the sides. Notice, reason to provide, present the case and evidence, rebut the adverse evidence, disclosure of evidence to the party, speaking orders, reason decision. What are the exceptions to the principles of natural justice? Statutory exclusions, emergency, interim disciplinary action, academic evaluation, impracticability. You write in the exam, yes or no. If you want to read specifically, concentrate more on this speaking orders. What order? Speaking orders. Then comes liability of the state or government in a contract. Liability of whom? State or a government in a contract. Important, 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 saying important. Important, say the important. I expect, I have a strong belief that based on point number 6, point number 7, there will be one or the other questions out of this chapter. If they ask questions, there are three main topics based on which they may ask question in the upcoming examination. Either rule of law or based on this liability of the state or government. And the third one is what liability? Tortious liability of the state. Listen, everybody. Listen, listen, listen. Tell me, can government enter into a contract? Yes or no? Government has the power to enter into a contract. Enter into what? Contract. As per which article? Article 299. Which article? Which article? Which article? Article 299 of what? Constitution of India gives the power to whom? Executives to enter into what? Contract. Which government can make contract? Both central as well as the state government. But contract with the government of our union, government of the union or state will be valid only if the following conditions are followed. Important, important. How many conditions? Three conditions. You know how many conditions? What are they? What is the first one? The contract must be made in the name of the president or the governor. Or the what? I repeat, the contract with the government must be made in the name of the president or the governor. Correct, right? Even the shares in the company will be held in whose name? President or the governor. And any person who is representing the president or a governor will not be counted for the purpose of what? Counted for the purpose of what? Quorum. As per section number 112 of the Companies Act 2013. Yes or no? Next one, next one. The contract must be executed on behalf of whom? President or the governor. Bolo bolo, president or the governor. One more time. President or the what? Governor. Person duly authorized by the president or the governor of the state, as the case may be, must execute the what? Contract. Or a simple say is simple. Which article provides the power to the parliament government to make a contract? Article 299. Article what? How many conditions? Three conditions. What is the first one? Name of the president or the governor. Second one, on behalf of the president or the governor. Third one, a person duly authorized by the president or the governor of the state, as the case may be, must execute the contract. Execute the what? As soon as a contract is executed with the government in accordance with 299, the whole law of the contract contained in the Indian Contract Act comes into what? Is government is government responsible, not responsible? Responsible. Correct, right? Responsible, not responsible. Correct, right? Can you sue the government for compensation? Yes or no? If there is a what contract? Next one, section number 17. Array, section number 70 deals with what? Quasi contract. Contract? Simple C, simple. So, this quasi contract, what contract? Quasi contract. Section number क्या है? 70. See, if anybody has given services to the government has enjoyed those services, government is liable to pay for it even if there is no actual contract based on the quasi contract. What contract? Quasi contract. What contract? So there is a contractual liability as well as quasi contractual liability of the government. Next one, tortious liability. Bolo bolo, what liability? Can the government be held responsible tortiously or vicariously for the act committed by the servants? Yes. Yes or no? Yes. State is liable if the acts done were necessary for the protection of what? Life or property. Act as such judicial or quasi judicial are done in what faith? Would not invite what liability? Any liability. Judicial or quasi-judicial activities does not invite any what liability? Conscious. What is vicarious liability? Where for the wrong of one person who is held responsible, other person is held responsible. Okay. Next one is we have liability of what corporation? Statutory corporation. What corporation? What do you mean by statutory corporation? Any companies or organization incorporated as per the Laws passed in the parliament or the state legislature is called as what? Statutory corporation. For example, LIC, SBI, RBI. These are what corporation? Statutory corporation. It is not a department, not a what? Department or organ of the what? Government, which is not a department or organ of the government. Corporations, statutory bodies. What bodies? What bodies? Statutory bodies. On the principle of vicarious liability, corporation is liable. Who is liable? Corporation is liable to pay what? Damages for the wrong done by their what? Officers or servants. Officers are what? Everybody, officers are what? Servants. Essential features of what? Corporation? Public corporation. Everybody, what corporation? What is the first one? They are what bodies? Free from what? Government control, separate legal existence, managed by whom? Board of directors, self-sufficient in what? Financial matters. What matters? Financial matters. Employees are recruited as per the what? Organization's requirement. What requirements? Organization requirement. Yes or no? They're not called as government employees. They're called as what? Government company employees. Clear with this? Statutory corporation. What corporation? Statutory corporations. Understood? Everybody? Yes or no? Principles of natural justice? Yes or no? Now tell me, before we go to the question and answers, I will ask questions to you guys. Now tell me, what is administrative discretion? Authority of an administrative authority to decide the matters and decide among the various alternatives available based on rule of reason and justice. What are the check and control over administrative discretion? Judicial review. What review? As per Constitution of India, statutes are equitable remedies. What remedies? As per Constitution of India, two stages at the stage of delegation of discretion. Second one at the stage of exercise of discretion. Delegation, Article 14, Article 19. Exercise. Now, what are they? Abuse of discretion, non-application of mind. What is non-application of mind? Acting under dictation, self-restriction, mechanically without applying the mind. Clear with this? Yes or no? Now let's go to the question and answer. Question and answer, guys. First question. First question. Administrative law is the law with respect to administration. Obviously, we know it determines the organization, powers, duties of what? Administrative authorities. Can you write a short note on these, everybody? Yes or no? Clear with this? Like, what is administrative authorities? What is the administrative law? Is this law deals with what? Powers, functions, and responsibility of various organs of the state. Need for administrative law. Need for what law? Why do we need administrative law? Have I discussed increasing role of the state? Then more of changing role of the state, increasing administrative function, balance between the government rights and individual rights. Sources of administrative law, Constitution of India, Act statutes, ordinance, discrete administrative directions, notification, circular, judicial decision. This question is important from the examination point of view. Mark it important. Next question is this one. Question number 2. In the sources of administrative law, write a short note on Constitution as a source of what law? Administrative law. Majorly, this question is important. Not question number 1. Mark, this question is important, important, highly important. Okay. I don't suggest selective studies. Remember when you guys used to ask questions like which topics are important? I never used to suggest, but this is the time. The time has come. Correct, right? Where we have to focus more on what topics? Important topics. See, now we have the points for every situation, and we will gonna stress more on the important topics. Correct, right? Next one, rule of law. A rule of law embedded in the Constitution of India. This is most important. What important? Most important. I expect them to ask question based on this topic. Administrative discretion, judicial review, constitutional, statutory, ordinary or equitable, declaratory action. Clear? We discussed all the four. Judicial review. Short note on judicial relief at the stage of what? Delegation of discretion at the stage of exercise of administrative discretion. Can you write a short note on this? 14 and 19. This one, abuse of discretion, non-application of mind. Non-application of what? Mind. Next one. Under what circumstances decisions exercised by administrative authorities are considered as abuse of discretion, qualified, leaving out relevant consideration, arbitrary orders, improper use, colorable exercise of power, exceeding the jurisdiction. Yes or no? No. Next one, non-application of mind. This is most important. Market most important. मैंने बोला था ना ये क्वेश्चन आएगा based on non-application of mind. Judicial review at the stage of what? Exercise of discretion. What of discretion? Exercise of discretion. I have a strong feeling that there will be a question based on this topic. What is that? Write a short note on what? Non-application of mind. If there is non-application of mind, non-application of what? Mind by the executive, is it valid or not valid? Not valid. Who will review it? Who will review it? Judiciary, as per the Constitution of India, and declare them as what? Invalid. See, this is based on a case study. What study? Case study. Mark it most important. Because this question was never asked in the previous examination. And there is a chance that they will ask question based on this in the upcoming examination. They may not, but there are more chances of asking questions. Because remaining rest of the question, every student will study because these questions will be there in the scanner. These questions are there in the ICSI book, and no students will touch ICSI book because देखते ही डर लगता है. 800 pages. Psychology. ऐसा no. So we are covering. See, we are covering what other students are doing. Plus, we are also covering something extra. ठीक है? Read the answer. Read the answer. You'll get to know why it is so important. Why I feel it is so important. Why I feel it is so important. Let's read. Write a short note on non-application of might. Non-application of what? Might. Where the authority exercises its discretionary power under the instruction or dictation from a superior authority, it is taken as non-exercise of power by the authority, and decisions or actions is bad. In such a condition, authority purports to act on its own. But in what? Substance. The power is not exercised by it, but by the whom? Other authority. The authority entrusted with the powers does not take action on its own judgment and does not apply its what? Might. In the Commissioner of Police versus Gordon Das Haji, the police commissioner empowered to grant a license for the construction of cinema theaters granted the license but later cancelled it at the discretion of whom? Government. The cancellation order was declared as bad. Why? Because the police officer did not apply his mind and acted under the what? Dictation of the government. Remember, non-application of mind, acting under dictation, self-restriction, acting mechanically. Clear with the concept now? Yes or no? Natural principles of justice. What principles of justice? Nemo judex causa sua in causa sua. Correct, right? Pecuniary bias, personal bias, subject matter bias. Correct, right? Next one, notice of rule of fair hearing, notice, contents of notice. Next one, speaking order. What order? What is speaking order? The order should speak for what? Itself. What are the advantages of speaking order? Ensure the what? Administrative authority will apply its might and objectively look at the facts and evidences. Reasons based on judgment and orders allow the party affected by it go into the what? Merits of a decision, excludes or at least minimize the what? Arbitrariness. Minimizes what? Because you have to give a reasons for not reasons for taking a decision. Correct, right? Next one, exception to the principles of natural justice. This case was asked many times in the previous examination. Disciplinary action taken against the student, interim disciplinary actions. Tell me, is there any requirement of following the principles of natural justice? No, no, no. Exception. No, no, no. Next one. Question number two. Question number one. Two. Enumerate in short exceptional circumstances of the application of principles of what justice? Natural justice. What are they? Statutory exclusion, emergency, interim disciplinary action, academic evaluation, impracticability. Have I missed any of the topics in the short notes? No. No. Government contracts. What contracts? This question may come in the examination. The liability of the government can be either what? Contractual or tortious. Both we have discussed. Contractual liability, normal contract, quasi contract, tortious liability. Nothing but vicarious liability. Tortious liability, what liability? Tortious liability. ये बहुत ही important है, बहुत ही important है, बहुत ही important है. This one. The tortious liability of a state is vicarious for the wrongful acts of its what? Servant. Decide. A tort is a civil wrong. What wrong? Arising out of breach of civil duty or a breach of non-contractual obligation, and only remedy for which is what? Damages. Vicarious liability of a state, it means the liability arising from what act? Wrongful acts or omission of the government service that cause the harm to whom? Others. The state can be vicariously liable for the wrongful act of its what? Servant. If the act was done in the course of employment or where the act was not part of what? Purely sovereign function unless it results in the violation of what rights? Fundamental rights. What rights? In case of violation of fundamental rights, the state is vicariously liable. For example, right to vote. If somebody arrests you unlawfully, can you make state liable for the payment of compensation? Yes, you can make the state liable for the compensation. With the increase in the cases of excess and negligence of administrative authorities, resulting in the violation of personal liberty. What liberty? This point is most important. The court have held that government is liable for damages, even those cases of what function? Sovereign function. See, generally, government cannot be vicariously held liable for the sovereign functions of the executives. But however, if it is a non-sovereign function, what function? Who can be held responsible? State can be held responsible, or the government can be held what? Responsible. But with the increase with the offences where the executives are interfering with the liberty of a person, the court have extended the concept of vicarious liability even for what function? Sovereign function. What function? They were asked in the examinations. Correct, right? Earlier, sovereign function state was not liable. Non-sovereign function state was liable. But with the increase in the interference with the personal liberty, there are cases where state is held responsible even for what function? Sovereign functions of the executive. Example, we have three case studies. Let's read. I expect the based on the first case study or the based on the last case study, there can be question in the examination. What is the first case study? Petitioner. Hello? Petitioner was detained illegally in the prison for over how many years? 14 years. After his acquittal in the full test trial, the court awarded rupees how much? 30,000 as a damages to whom? Petitioner. Correct, right? Why 30,000? Because he was how detained what? Illegally. Detained what? Illegally. Yes or no? Sovereign function, but still who is responsible? State. Beam Singh versus state of Jammu and Kashmir. A person was going for attending the assembly, but he was detained wrongfully. Court ordered him the state to pay how much? 50,000 by way of what damages? Exemplary damages. Saheli Women's Resource Center versus Commissioner of Police, Delhi. Saheli, I have heard this name. Submarine. What is the specialty of Saheli? Saheli ka Sardar. Huh? What is Saheli? Saheli means friends. Huh? Oh, Saheli, a women's resource center where the death of 9-year-old boy. Wait, the death of nine. We are discussing a serious case and you guys are laughing. Pagal, concentrate karo. Where the death of 9 years old boy took place on account of unwarranted, atrocious beating and assault by a police officer. What kind of police officer he is? He has killed 9 years old boy. Oh my God! The state government was directed by the court to pay 75,000 as a compensation. The mother of what? Victim. At least that court is giving at least 75K. Earlier it was a sovereign function. What function? There was no question of vicarious liability, but at least now there is a what liability? Vicarious liability. This question may come in the examination as a what? Question? Earlier there was no tortious liability for sovereign function. What function? But now there is a what function? What liability? Tortious liability or vicarious liability even for what function? What function? Sovereign function. Driver of a jeep, non-sovereign function, punishable. State is liable. Driving is not a sovereign function, right? State is vicariously liable. Vicariously what? Liable. Lady doctor, what doctor? Of a government hospital was negligent while conducting an operation on the Dinakar's leg. Whose leg? Dinakar's leg. The lady doctor amputated the left leg of Dinakar instead of his what? Right leg. By what? Mistake. Is it amputated or operated? Something. Dinakar filed a suit against the authority of the government hospital and lady doctor for damages on the plea of negligence. Will he succeed? Yes, he will succeed. Even though it is what it's a non-sovereign function. What function? And in the recent cases, the vicarious liability of the state extend even for what function? Sovereign function. Bolo what function? Are you guys clear with this? Everybody. Next one. Corporations. These are easy question. Corporation. I was. This question. I was finding for this question. Mark it important, most important. Huh? How can you mark? Once I give, you can mark it. At least in your head, right? See, read this case study. Important case study. It is there in your question. Nobody would have. See, read this question. Everybody should read this question. Read this question. An accountant and employee of a public corporation was prosecuted for offences under the Section 161 of IPC, now it is BNS, and of the Prevention of Corruption Act 1947, and was ultimately convicted and sentenced. This was upheld by the High Court and in appeal. The appellant contended that entire proceedings before the trial court, that is lower court, as also the High Court, are liable to be set aside as there was no valid sanction. What sanction? Within the meaning of what? Section 6 of the Prevention of Corruption Act 1947. See, prosecute any public officer. What officers? Need to take the sanction of the government. What are the government? Sanction of the government or the officers of the government. Correct, right? Without sanction, there can't be any prosecution. Now the question is, was the sanction given by the executives valid or invalid? If the sanction is invalid, entire proceedings are invalid. Means the decision given by the lower court, high court becomes invalid. Why? Because what is important? Sanction is important. Now the question is that sanction valid sanction, invalid sanction? See, prosecute government employee. Let's say Shashank is a government employee. I need to prosecute Shashank for a corruption. To prosecute Shashank under the Corruption Act, I should take the sanction of the executive. Let's say Darshan is the one who is the authority whose sanction I need for the purpose of prosecuting Shashank. Now, what I am contending is that I have taken the sanction of Darshan and I filed a case in the High Court, lower court. I won the case. Same thing, I appeal went to the High Court. Even High Court confirmed that this there was a valid sanction. Now the case is in Supreme Court. There are two contention here. Opposite party saying that there was no valid sanction. If we can prove that there was no valid sanction, the entire thing, whatever was decided till today, becomes what? Invalid. Becomes what? Invalid. Now the question is, sanction given by the executive, valid or invalid? Valid or what? This contention is challenged by the state of Gujarat, who has contended that there was a proper and valid sanction granted within the meaning of the act. In this case, it was observed by the court that while exercising the power of judicial review, the court does not sit as a what? Court of appeal, court of what? But merely reviews the what? Manner in which decision was made, particularly as the court does not have the what? Expertise to correct the administrative decision. Discuss the above situation with the help of the case Manchuklal Vittaldas Chauhan versus State of what? Gujarat. State of what? Gujarat. What happened in this case? Manshuklal Vittaldas Chauhan, an assistant engineer in the public corporation, was prosecuted and convicted under section number 161 of IPC, read with section number 5 and 5D of the Prevention of Corruption Act 1947. He challenged the prosecution on the ground that there was no valid sanction. There was no what sanction? Under section 6 of the act, thus rendering the trial court incompetent to take the cognizance. The state contended that proper sanction was granted. There are two contentions. One is saying there was no proper sanction. State is saying there was a proper sanction. The court reiterated that judicial review is permissible in the matters of what? Grant of sanction. Who can review it? Judiciary. Because this sanction, giving a sanction is a what function? Executive, administrative function. What function? What function? Administrative function. What function? What function? Administrative function. Correct, right? But it is not akin to the what? Appeal. It is not same like appeal. Judicial review is not like appeal. Appeal is different. Judicial review is what? Different. What is appeal? When you challenge the decision of which court? Lower court. To be set aside or to modify decision of the lower court. It is called as what? Appeal. This is not an appeal, it is a what? Judicial review. What review? So, sanction, granting a sanction by the executive for a prosecuting a executive. Can it be judicial review by the court? Yes. Courts can examine whether authority granting the sanction had applied its what? Mind. Second one, decision was taken independently and objectively, and the relevant materials were what? Considered. In this case, Supreme Court found that sanctioning authority had not applied its what? Mind. And there was a external influence. What influence? External influence. Hence, the sanction was what? Invalid. And consequently, the trial court lacked the what? Jurisdiction to take the cognizance. Which court lacked the jurisdiction to take the cognizance? Trial court. Entire prosecution was lost. So who has the judicial review power? Judiciary. If there is no application of mind and it were acted by what? External influence. What influence? Remember, I have to discuss judicial review, non-application of mind, acting as per dictation, are influenced by the external authorities. The given case is similar to Manchuklal case, the accused accountant challenging the prosecution on the grounds of absence of what sanction? Valid sanction. If it is shown that sanctioning authority did not apply its mind and with influenced or did not consider the relevant material, then as per the ruling in Manchuklal case, the sanction is what? Invalid. Sanction is what? Simple. The sanctioning authority should apply his mind. Apply his what? What if he was acting under the influence of external authorities and has given the sanction? Is that sanction valid or not valid? Not valid. Clear with this? And we have covered every possible scenarios based on which they may ask question in the examinations. And we also covered a situation which you are not even aware of. and which would have not come across with if I have not taken this revision session. Correct, right? Are yes or no? Clear with this? Yes or no? With this, we are done with what? Administrative law, lesson number 4. Done with this? अब हम शुरू करेंगे chapter number what? 5. Important chapter. Lesson 5. Lesson number what? 5 deals with law of profit. Is it a codified law or non-codified law? Non-codified law, which is based on the precedent. Based on what? Precedents. Original precedent. What precedent? Original precedents. You know what is tort? Tort is a civil wrong. What wrong? Opposed to what wrong? Criminal wrong. Tort is a civil wrong, which is where the remedy is what? Unliquidated damages. What damages? Unliquidated damages. What damages? Unliquidated damages. In case of what? Tort. Below, what is tort? Tort is a what wrong? Civil wrong. What wrong? So, in case of tort, what is the remedy? Liquidated damages or unliquidated damages? Unliquidated damages. What is unliquidated damages? Which are not prefixed by the parties. Who will decide the unliquidated damages? Court will decide the unliquidated damages. Does it include breach of contract? No. See, breach of contract, violation of rules of trust are also civil law. But however, we have a separate law to deal with breach of contract as well as what? As the what? Breach of trust. Breach of what? Trust. So tort covers only what wrong? Civil wrong. What wrong? Remedy is what damages? Unliquidated damages. Does not cover breach of contract, the breach of trust, or equitable obligation. What obligation? Equitable obligation. Nothing but a quasi contract. What contract? General conditions for liability for a tort. What for a tort? Liability for a tort. What is the first one? Wrongful act or omission. Whether it can be a positive act as well as what? Negative act. Correct, right? It can be an act or a omission. If you have a legal duty of doing something and if you omit to do it, it is also considered as what? Tort. Maintaining the light pole is a duty of whom? Corporation. If it is not maintained properly, falls on somebody, and if he is injured, can he claim compensation? Yes, there should be a wrongful act or a wrong. The one who commits the wrongful act or a wrong is called as what? Tortfeasor. What feasor? Tortfeasor. There should be a legal damage. What damage? What is legal damage? Violation of a legal right. What right? There should be a violation of legal right, and this can be understood by two legal maxims: damnum sine injuria, injuria sine damnum, damnum cum injuria. What is damnum sine injuria? A loss without infringement of right. Is it a tort? Not a tort. Not a tort. Not a war. Why? Because there is no violation of right. But what if there is the injuria sine damnum? What damnum? Is injurious in a damnum is a tort? Yes. What is injurious in a damnum? Infringement of right without any what? Damage. Is it a tort? Yes. Damnum cum injuria. Damnum cum injuria. Tort. Damnum cum injuria means both are there. There is a violation of right as well as a loss. Is it called as a tort? Yes. Sine means without. Injurious in a tort. Damnum. Is it a tort? Injuria sine damnum, is it a tort? Damnum sine injuria, is it a tort? No. Are you guys clear with this? Next one, legal remedy. What remedy? Where there is a right, there is a what? Remedy. You be just ibi remedium. The legal remedy is what remedy is? Legal remedy is suit for what damages? Unliquidated damages. What damages? These are the essentials of tort. What is the first one? Wrongful act or omission. Second one is what damage? Legal damage. Third one is what remedy? Legal remedy. Are you guys clear with this? Next we have menstria. What ria? What is menstria? Guilty mind. Is menstria is the essential ingredient for a tort? Yes. Even in a tort, there is one requirement of what ria? Menstria. Because actus non ficitium, nis menstria means what? An act itself creates no guilt unless there is a what? Guilty mind. What mind? There has to be a guilty act as well as the guilty mind to constitute an offense or to constitute a wrong. Correct, right? But however, However, there are exceptional cases where a person can be held responsible even if there is no what rea, mens rea. इसको बोलते हैं liability without fault. बोलो, liability without fault. It is also called as no fault liability. What liability? Correct, right? Fault or state mind when relevant in case of assault, battery, false imprisonment. What is required? Mens rea is required. What is required? But however, there are situations, for example, strict liability, absolute liability. What is not essential? Mens rea is not essentials. But in general, even for a tort, what is required? Mens rea. What is mens rea? Guilty mind. Because actus non facit reum nisi mensit rea. An act itself does not create a guilt unless there is a what? Guilty mind. What mind? Types of tortious liability. Types of what liability? Tortious liability. What is the first one? Second one, absolute liability. Third one, vicarious liability. Fourth one, vicarious liability of state. Before I go to the strict liability, can anybody tell me what is strict liability? Anyone brings a dangerous substance to his land or accumulate a dangerous substance on his land, he does so at his own risk and at his own peril. If it escapes and causes the harm to the neighboring persons or anyone, he is liable to pay what? Compensation. Liable to pay what? Compensation. That is called as what liability? Strict liability. Tell me in which case law the court has very good. What case law? Ryland versus Fletcher case law. Which case law? Ryland versus Fletcher case law. Fletcher case law. No fault liability. What liability? Following are the cases where a person is liable without his fault. What is the first one? Inevitable accident, inevitable mistake, inevitable vicarious liability, or wrongs committed by you. You have not done any wrong. What your agent has done wrong. And liable or not liable? Liable. What liability? Vicarious liability. Below what liability? Vicarious liability. In which case, the court has discovered the strict liability, Ryland versus Fletcher. जोर से बोलो, Ryland versus Fletcher. Men act at his what? State, at his risk. And he is the insurer of the safety of his what? Neighbor against the accidental harm. This sentence is most important because if they ask any question about strict liability, what you will write? If a person brings, if a person what? Brings or accumulates on his land anything which if it should escape may cause a damage to whom? Neighbors. He does so. That is what peril? Own peril. If it does escape and cause the damage, is he responsible or not responsible? Responsible, however careful he may have been and whatever precautions he may have taken to prevent the war damage. Prevent the war damage. Correct, right? There are two conditions to be satisfied. How many conditions to be satisfied? Two conditions for the application of which liability? What are they? Escape from the land and non-natural use of what? Land. What use of land? Non-natural use of land. Correct, right? What is the first one? Escape from the land. Second one, non-natural use of land. Yes or no? Storing the water, storage of water in the large quantity. It's a natural use or non-natural use? Non-natural use. Growing ganja trees. Non-natural use of land. And keeping a ferocious dog. Non-natural use of land. What use of land? Non-natural use of land. So see, doing non-natural use of land is not an offense. It's not a tort. But if it escape and causes the harm to the neighboring person, liable or not liable? Liable. Are there any exception to strict liability? Everybody, what is the first one? Damage due to natural use of land. What use of land? Natural use of land is an exception. The principle of strict liability. We have discussed various natural use of land. Keeping one gas cylinder. So what use of land? Natural use of land. Correct, right? Yes or no? Next one, consent of plaintiff. If I have kept something with the consent of plaintiff for the benefit of both, if it escapes, causes harm to the plaintiff, and responsible, not responsible, not responsible. Act of third party. Act of which party? If the escape is due to the act of third party, then who is responsible? Third party is responsible. Next one is statutory authority. If a statutory authority, when statutory duty, what duty? Statutory duty. If they commit any tort, are they liable or not liable? Not liable. Act of God, heavy rain, unprecedented rain, and the damage, not damage, the dam burst and the injured has destroyed the property of the neighboring person. Is he responsible? Not responsible? Not responsible because act of God. What of God? Act of God. Last one, escape due to the plaintiff's own fault. Remember, a thief enters the house, changes the mind, drinks the poison. Is he liable or not liable? So is the quick liability applicable or not applicable? Not applicable. These are the exceptions of what liability? Strict liability. What liability? Understood? See the opposite to strict liability. We have what liability? Absolute liability. Absolute liability was discovered in which case law? MC Mehta versus Union of India. Because strict liability was invented long back. Now there is a change in technologies, and many companies are engaged in what? Hazardous and inherently dangerous industries. So there must be a non-delegable and non-exceptional duty imposed on what? The one who is engaged in the what? Dangerous industries. That is why it is called as what liability? Absolute liability. What liability? What does absolute liability provides? Tell me what does absolute liability provides for? Tell me what is absolutely liability provides for? MC Mehta versus of Union of India and others. Justice Bhagavati held that an enterprise which is engaged in a hazardous and inherently dangerous industry. These two keywords must be there in your answer. Hazardous or inherently dangerous industry. What industry? Inherently dangerous industry, which poses a potential threat to the health and safety. Health and what? Safety of the person working in the factory and residing in the surrounding areas owns an absolute and non-delegable duty. What duty? Absolute and non-delegable duty to the community to ensure that no harm results to anyone on account of hazardous or inherently dangerous nature of activity which it has undertaken. Simple, hazardous, inherently dangerous. Owes a absolute and non-delegable duty. The costs are to pay compensation if there is any losses. Clear with this? Strict liability with exception. Absolute liability without exception. Correct, right? In which case there are exception? Absolute liability, no exceptions. Clear with this? अरे हाँ है ना. Next we have vicarious liability. बोलो what liability? One more time, what liability? What is vicarious liability? Where for the wrong of one person, who is held responsible? Other person is held responsible. It is called as what liability? Vicarious liability. Bola what liability? A person may be held liable in respect of wrongful acts or omission of another in a way as given hereunder. What is the first one? By ratification. You have done something without my permission. If I ratify it, am I responsible or not responsible? Responsible. Next one by relation. Next one is by what? You are my agent. I am the principal. You are my partner. I am also your partner. For the act of one partner, who is responsible? Other partner is responsible. Employer and employee relationship. Are yes or no? Master and servant relationship. Last one by abatement. What is abatement? Supporting. These are the cases where for the wrong of one person who is responsible, other person is also held responsible. Liabilities, examples for vicarious liability. What liability? What is the first situation? Principal and agent. Principal and what? Principal and what? For the act of agent who is responsible. Principal is held responsible. Between partners for the wrong of one partner, who is responsible? All the partners. What liability? Vicarious liability. Next one, master and servant. What and servant? Master and servant. For the wrong of servant, who is responsible? Master is responsible. Bolo bolo, who is responsible? Master is held responsible. Master is held responsible. Next one, employer and independent contractor. Keep this in mind. For the act of independent contractor, master is not generally responsible. Employer is not generally responsible. But are there any exception? Very good. How many exception? Three exception. When employer authorize him to commit the tort. Second one, strict liability. Third one, negligence of independent contractor. What contractor? Next one, liability for the acts of what? Servant or employees. Bolo bolo what employees? For the act of employee, who's responsible? Employer. In the course of employment. Course of what? Employment. What liability? Vicarious liability. What liability? Then we have vicarious liability of state. Tell me, is being liable for the wrongful acts of the servants in England as per which act? Crown Proceedings Act. But in India, we don't have such specificity. But however, in many cases, the court have held that if a employee of the government is performing sovereign function, what function? Who is not responsible? State is not responsible. Non-sovereign function, state is vicariously held responsible. But now there is a shift in the approach. There are cases where the state is held vicariously liable for the act of its servant, even if it is sovereign function, if it concerning with the fundamental rights. What rights? Fundamental rights. And we have discussed example, right, where a person was sentenced for imprisonment, wrongful detention of person, a 9 years old boy was killed in the police custody. Is it a tort or not a tort? Tort. Vicarious liability applicable or not applicable? Applicable. Yes or no? Generally, activities of what nature? Commercial nature. What nature? Or what function? Non-sovereign function. Or what function? That operation case law where instead of operating left leg, not left leg, she has operated which leg? Right leg. Government hospital is government responsible? Yes, because she was performing what function? Sovereign or non-sovereign function? Non-sovereign function. Operation is not a sovereign function. Are yes or no? Are yes or no? Government is responsible, not responsible? Responsible. Admin law, tort, both are interrelated. Next one, the personal safety or freedom. What is the first one? We have detailed discussion. See, I have given the answers in detail at the previous year questions pay. When I discuss those questions, I'll get to know. There are certain extra questions, extra examples. I'll discuss them. Okay? Wrong to the personal safety or freedom. What is the first one? Battery. What is battery? Direct application of force is called as what? Battery. Second one, assault, creating an apprehension in the mind of a person that is going to commit a what? Battery is called as what? Assault. Called as what? Assault. Bodily harm. What harm? Physical harm caused to a person, however negligent it might be with the intention. Next one, false imprisonment. What imprisonment? False imprisonment. Restraint on the body, however smaller the time it is. Right. Next one, malicious prosecution. What prosecution? If a person initiate a judicial proceedings maliciously without reasonable and probable cause, which is terminated in the favor of the one, which person? Other person, results in a damage to whom? His reputation, personal freedom, or property. He can file a suit for what prosecution? Malicious prosecution, claiming the damage. You have prosecuted me maliciously without reasonable and probable cause, and I want the case. Now I can file a case against you for recovery of what? Damages. Next one, nervous shock. What shock? It's a recent origin and market important. Market important. If they ask question about tort, they will ask question based on nervous shock. 70% sure. I'm 70% sure that in the upcoming examination, there will be a question based on what? Nervous shock. What shock? Because it is a new concept, trending concept. What concept? Trending concept. I'll give the question also based on which are based on which case now there may be a question in the examination. Okay? Nervous shock, recent origin, though what you have seen or heard. From what you have seen or heard, if you experience a nervous shock, can you claim compensation for that? Yes. For example, let's say I am taking this class, suddenly somebody enters in front of you. That person came with a knife or with a log and he has chopped CSR into 100 pieces. How many pieces? 100 pieces. Will you experience nervous shock or nervous happiness? Will you experience a shock? Will it be a shock for you? Will it be a mental shock? Will it be a mental shock or trauma? Can you file a suit against the person who has done this for compensation? Yes or no? Yes, you can file a case for recovery of compensation. I will discuss the condition to be satisfied for claiming the compensation for nervous shock. There is an interesting case study. What study? What study? For nervous shock. I'll discuss. Next one is what? Defamation. What is defamation? Any imputation made considering the reputation of a person which will lower the reputation of the person in the eyes of the public. It is called as what? Defamation. How many types? Two types. Libel and slander. Next one is what? Negligence, recklessness, or carelessness. Other topics. Companies are responsible for the wrongs committed by whom? Employees, based on the principle called as Q passive per annum, passive per sale. Consumer Protection Act and liability for what? Thought. COPRA imposes strict liability on whom? Manufacturers. On whom? Service providers, sellers for any defect or deficiency in their what? Product or services, and they can be sued for damages. Unfair contracts. What contracts? Contracts whose terms and conditions are in favor of manufacturers or service providers are against the interest of consumers. Interest of consumers. Next, we have medical negligence. Bolo, what negligence? Medical negligence is within the ambit of Corporate Protection Act, Consumer Protection. That is COPRA. Liability of medical practitioner is of threefold. How many fold? Threefold. What are they? For payment of damages, civil liability for a tort, criminal proceedings under what? BNS. What is BNS? Nyaya, Sanita. Criminal liability, civil liability for tort, and also under the COPRA for medical negligence. What negligence? Next one, remedy for the tort. What for the tort? Remedy for the tort. It can be judicial remedy, extrajudicial remedy. Below what remedy? Extrajudicial remedy. What are judicial remedies? File a suit for what? Damages, liquidated or unliquidated? Unliquidated. Awesome. Very good. Next one, injunction, prohibitory order to prevent a person from committing a tort. Next one, specific restitution of property. Means what? Restoring the property. Extrajudicial remedies. What remedies? Extrajudicial remedies. What is the first one? Self defense. What defense? Self-defense is also one of the remedy as per the PNL. Remember, private defense. What defense? Private defense. We'll discuss. Next one. Prevention of what pass? Trespass. If somebody trying to trespass, you can use a reasonable force and you can prevent the trespass. Next one. Re-entry on the land. Peaceably, you can re-enter the land. Recapture the goods. What capture the goods? Recapture the goods. Next one. Abatement of what? Nuisance. Branches cut after giving what notice? Reasonable notice. Distress, damage, pheasant. Means, let's say, a kid entered your house without permission and he has consumed all the laddus which you thought of eating in the break time. Or you have planned to eat laddus in the evening, but before you uh, return to your home, a neighboring kid has entered your house and without permission he has consumed the laddus. You found him red-handed. Can you keep that kid unless until is that kid mom's pay the compensation? Yes, distress the damage, physical. Same thing used to happen in case of trespass by the cows. If cow enters into your land, can you cattle trespass? Can you distress the damage present which is causing the damage? Can you withhold it? Yes or no? These are the what remedies? Extrajudicial remedies. What remedies? Extrajudicial remedies. Why you must solve this question bank? Why this question bank is so unique? Because it covers extra topics as well. Listen, listen, listen. You solve this question bank, you can answer any of the questions asked in the examination. I want you are supposed to solve this question. फटाफट solve करेंगे. Let's start. Alok was running a school at a what? Array simple question. I'll explain it. Listen. He was running a school. Teacher left. Started one more school. So all students shifted to the other school, and he suffered a loss. Is it a tort? Not a tort. Not a tort. Because damnum sine injuria. Very good. Same case. Damnum sine injuria. Store. One more store. Loss. Not a tort. One more example. Water supply. One well, one more well, loss of water. Is it a tort? No. He is doing in his land, you are doing in your land. Tort. Yes or no? Damnum sine injuria. To constitute a tort, there must be a wrongful act and legal damages. Yes, there should be a wrongful act or commission. Second one, legal damage. Third one, legal remedy. Can you write all these things? Next one, kinds of tortious liability, strict liability. What liability? Can you write about strict liability? Ryland versus what? Fletcher case law. Mill owner employed an independent contractor. He does not diffuse this unused old shaft, water burst, damage the other person property. Is the mill owner responsible? Not responsible. Responsible. Vicarious liability, strict liability. What liability? Strict liability. Exception to the strict liability. You should read this. Listen, listen, listen. What is the first one? Damage due to the what? Natural use of land. What use of land? See, even I given the examples here. Establishing a reservoir for generating power on residential land amounts to what use of land? Non-natural use of land. Building a swimming pool, water storage tanks are considered as what use of land? Natural use of. But you build a reservoir to generate the power. Is it a natural use or non-natural use? Non-natural use of land. Next one, consent of plaintiff. Concept of what? Plaintiff. A and B living in the same housing complex. Both are boys or girls. Okay. So A and B living in the same housing complex gives permission to install water pipes. One of the water pipes leaks thereby causing leakage problem. What problem? Leakage problem. None of them are responsible because it is with the consent of whom? Other person. Act of which party? Third party. A act of which party? Third party. Surya. A has a bull tied in his garden, which is properly fenced. B a passerby opens the fence and the bull is in the on the loose. Bulls end up hitting whom? See, A will not be liable under the law of tort since he had taken a what care? Due care. Who did this wrong here? B. Liable or not liable? Who is liable? B is liable. Statutory authority, sudden bursting of water lines after taking the due care causes flooding in nearby areas. State liable or not liable? Not liable. Act of God, excessive rainfall, applicable, not applicable, not applicable. Escape due to the plaintiff's own default. Whose default? Plaintiff's own default. Remember, the this is a different example. He did not consume the spirit. What happened here? Here, he arranged the containers on one on the other for the purpose of reaching at what? One place. He fell, and the chemicals in the containers spilled on him. To reach the building, he arranged the one containers one after the other. Correct, right? He fell from the container fell on him, and chemicals fell, and he's injured. Who is injured? The thief injured. Can he claim compensation? Cannot claim compensation because it is own fault. What fault? Own fault. Are so no. This one transparent spirit entered, consumed, plaintiff own fault. No strict liability. Yes or no? Next one. Absolute liability. What liability? MC Mehta versus what? Union of India. Driver of petrol lorry struck a match. What is the employer responsible? Not responsible. Responsible. What liability? Vicarious liability. Next one. Next one. Swaraj, an employer of ABC company, appointed Rakesh as an independent contractor for the act of independent contractor employer. Liable or not liable? Not liable. Are there any exception? How many exception? Three exception. Next one. Next one. Partners liable or not liable? Liable. John, who had an account in a private bank, went to the bank to deposit the cash. While he was entering into the bank, along with the cash box, the bank was also being carried inside. The security guard, in a haste, ended up firing the what? John, thereby killing him. For the act of security guard, is the bank liable or not liable? Liable. What liability? Vicarious liability. For the act of an employee. Who is responsible? Employer. Because it was done. Authorized the act of the servant. The act then is what? Authorized act done wrongly. This question is important. I expect them to ask question based on this. P is the owner of the shop. Q is the employee. P asks you to destroy certain articles since they were found to be unfit for what? Consumption. Q, instead of destroying them, sold them off, and as a result, A fell gravely ill and sued P for the what? Damages. Is P liable or not liable? Why liable? Because he authorized him to do act, even though it is he has done in an unauthorized way. Who is responsible? Principal is responsible, employer is responsible. They may ask this question in the examination, right? Yes or no? Next one. Question number one. An autonomous body was entrusted with the duty of construction of dams. It is constructed a dam near the property of XYZ Limited. XYZ requested the autonomous body to change the location of the dam on the ground of what? To its property due to the dam. The request of the company was not acceded to it. The overflow of the water caused the loss to the valuable property of the company. The company intends to claim the damages. Advise the company in the light with the decided case. Jayalakshmi Salt Works versus what? State of Gujarat. State of is the government responsible? Not responsible. Responsible. Correct, right? Liable or not liable? Liable. Even though it is a what duty? The sovereign duty, because it is a what act? Negligent act. I want you guys to mark it as most important. Based on this, they can ask question in the examination. Okay. Thought to the person or safety or freedom. First one, battery. A incites a bull to spring upon Z without whose consent. Is it a thought? For everything, I have given a provision. You can go to this question bank to understand how to write the answers for the question. Bodily harm. Bodily harm. A Z is riding in a chariot. A lashes the Z's horses and thereby causes them to quicken their pace. Is liable or not liable? Liable. Bodily harm. What harm? Bodily harm. False imprisonment. What imprisonment? False imprisonment. Ayyo. This is like a dristy but there should be some mistake, right? मैंने font को correct नहीं किया है. ठीक है. Next one. False imprisonment. You know what is false imprisonment? Restraint on the freedom of a person. It is called as what? False imprisonment. Malicious prosecution. What prosecution? Have I discussed malicious prosecution? Prosecution with a malicious intent, suit terminated in favor of the other party. It suffered a loss to reputation or body or emotional. Nervous shock. Nervous shock. Important. Say important. This question, nervous shock. And negligently drove the carriage onto the railway tracks while the train was on the verge of crossing the place. And by this accident, there was a lady received a nervous shock, which leads to a bad impact on her health. Can she claim the compensation? Yes, because she suffered a what? Nervous shock. What shock? Nervous shock. A would be liable for the damages, for the consequences of what shock? Nervous shock. You will get a much more conceptual clarity on the concept of nervous shock if you solve this question. Most important question. I have a strong feeling that the question will come in the examination based on this concept because there were no question asked based on this in the previous examination. Okay? Can we read together? साथ में 5 minutes we'll spend this and we'll finish this chapter. Okay? Let's read. Let's read. I want everyone to focus. New concept. What concept? New concept. Let's start. Everybody. A disaster occurred in a cricket stadium. What stadium? Let's say RCB versus Chennai. Okay. Other stadium. Security agency was held responsible for allowing the large number of spectators. The scenes were broadcasted live on the television. The viewers of the match on the television brought the claims against the defendant for nervous shock, resulting in psychiatric injury. Discuss the criteria laid down in the Alcock and others versus Chief Constable of South Yorkshire AC, House of Lord for the secondary victim. If this question would have asked in the examination, none answered this question for sure. Even if you would have answered, you would have just written what is nervous shock. Yes, you would have written nervous shock. Okay, yes, he is liar. Because you have never seen this question. Have you seen this question? But this question is there in the what material? ICSM material. आप करना था, आप नहीं किया, इसीलिए next one. What happened in Alcock and others versus Chief Constable South Yorkshire case law? In this case, अरे साथ में पढ़ाई करो ना, so that it will be easy for me. Morning, since morning I'm continuously talking, guys. I'm also a human being. Do you agree CSR is a human being? So, hey, you switch on the light at this point. Next up, in this case, the court held that in the case of purely psychiatric damage caused by negligence, a distinction must be drawn between the what? Primary and secondary victim. See, when you want to claim compensation for nervous shock, you have to make a difference between the primary victims and secondary victims. A primary victim was one who was present at the event at the what? Event as a participant. As a what? Participant and would thus be owed a duty of care by D, subject to the harm caused being what? Foreseeable, of course. It's the foreseeable event, right? There should be some alternate remedies. You should have taken the alternate solutions, right? So, if the person was present at the stadium when the event happened, he's called as what victim? Primary victim. Secondary victim, by contrast, would only succeed if they fell within the criteria. What is the criteria? The following condition must be satisfied. Claim compensation for a nervous shock if you are a secondary victim. What victim? Primary victim. You can claim compensation for nervous shock because you are present at the place where the event happened. What happened? Event happened. Secondary victim. What are the conditions? First one, a close tie of love and affection to the primary victim. There has to be a close tie between the victim and the one who want to claim what? Compensation. Want to claim what? Compensation. Array, this is live telecasted. Let's say YouTube channel, somebody is watching this video, someone enters the classroom, start chopping CSR into how many pieces? How many pieces? Not pieces. How many pieces? 100 pieces. Huh? Not six. Why 106 pieces? Oh, 106 murder. 103 murder. Huh? 103. 103 pieces. Now, you are called as what victims? Are all of your what victims? Primary victims. You can claim compensation directly because you are present at the place where the event happened. Somebody is watching the live telecast. What telecast? What telecast? Beta live telecast. They can claim the compensation only if they are what? Close tie with the CSR. They should have a love and affection to the primary victim, that is, a wife who witnesses their husband's injury in a stadium disaster may have a valid claim because we have a close tie. What tie? Close tie. Next one. Adi, I heard you. I heard you. Next one. Appreciation of the event with their own unaided senses. ಅವರೇ ನೋಡಿರ್ಬೇಕು. उसको ही देखना पड़ेगा. What if somebody has seen it? Then she goes and tell in the husband, someone has killed your husband. अब husband को कोई मार रहा है. Is it called as nervous shock? Can she claim compensation? No. She should have experienced by herself without any aided senses. हाँ है ना, उसको ही देखना पड़ेगा. She should have seen it herself. Next one. Proximity to the event or immediate aftermath. A person standing near the disaster site who witnesses the aftermath directly could qualify, but a TV viewer is what? Too far removed. Too far what? Removed. There is no proximity. There is no what? Proximity. The psychiatric harm must be caused by sufficiently shocking event. What event? Shocking event. A mother witnessing her child's severe injury at the stadium could claim what? Psychiatric harm, but a TV viewer's emotional distress would no likely to meet the what? Threshold. Don't even know who that person is. You may suffer emotional injury, but not psychiatric stress, right? Only if you are his brother or sister. For example, this Pahalgam attack. Correct, right? The one who has Pahalgam attack, the victims of that attack are the one who has seen that murders. They have experienced the psychiatric distress. They can gain compensation from the terrorist, but anyway, the terrorist is already killed. Are you guys clear with this nervous shock? Can you guys write about this? There can be how many types of victims? Primary victims, secondary victims, primary victims, present at the stadium, secondary victims. There should be how many conditions? Four conditions. Close time, appreciation of the event by own unaided senses, proximity to the event or its immediate aftermath, psychiatric harm must caused by the what? Sufficiently shocking event. What event? Shocking event. Next one is what? Defamation. Can you write answers for the defamation? Everybody. Defamation of how many types? Two types. What are two types? Libel and slander. Libel and what? Next one, negligence. What is negligence? You are supposed to take a care, but if you have not taken the care which is required, it is called as what? Negligence. Called as what? See, they can give this. If ICSI want to confuse you or make your job difficult, they give this sentence. They'll say, seek non use your right as not to harm who? Others. Not to harm who? Others. Correct, right? This case, Poonam Verma case law. Shashank, this case is very important. They may ask question based on this. What happened in this case? Respondent number one practice allopathy. What pati? Allopathy without proper qualification or registration under the what? State medical register. Is she liable for negligence? Yes. Even the one who has a qualification may cause problem. He may cause death. You are not even qualified. And if you start treating the people, saying that it is the allopathy, homeopathy, that pati, this pati, senapathy, exactly. The court held him guilty of what? Negligence per se, meaning a clear violation of what? Legal duty without need of what? Separate proof of harm. Practicing medicine without required qualification is punishable with the imprisonment, fine, or both under the what? Under the what? Are you guys clear with the negligence? Based on this, they may ask question. You will be confused. See, it is not like you will not be in a position to answer. If you don't know this question belong to which topic, you'll get confused. Are which topic? Battery, assault, like getting this? Yes or no? Next one, Consumer Protection Act and liability for what? Write a short note on Consumer Protection Act and what? Liability for tort. Liability for tort, prevention of trespass, defense, entry on the land, recapture of goods, abatement of nuisance, distress, damage, present. Distress, damage, what? Present. Yes or no? With these, we are done with what? Law of tort. Follow? Tort. Keep this in negligence, mental stress, severe stress, based on which they may ask. Does that mean There can be maybe googly also. They may ask question based on some other topics, but we are already in the safer side. We have covered all those things plus also extra question. Clear? Understood? Yes or no? These are extrajudicial remedies, beta. Judicial remedies, only three are there. Clear? Understood? Yes or no? Yeah. Good morning. Good morning and welcome to the day two marathon revision of jurisprudence, interpretations, and general laws. So let's start with lesson six, the law relating to civil procedure. What procedure? Civil procedure. Tell me, civil procedure is a substantive law or procedural law? Procedural law. It provides a procedure to be followed to enforce the civil rights. What rights? Civil right. For example, we have a Contract Act, the Indian Contract Act 1872, that provides the word rights and obligations. So if there is the infringement of right, the aggrieved party can file a suit in which court? Civil court. How the suit should be filed, how the hearing happens, and how decisions are given by the court. What is a judgment? What is a decree? What is set off? What is counterclaim? What is equitable setter? What are injunction? What are equitable relief? So all those things we're gonna discuss under which chapter? Chapter number 6, the law relating to civil procedure. What procedure? So let's start. Is it a substantive law or procedural laws? Procedural laws. Generally, the substantive laws will have only a prospective effect. What effect? Prospective effect. But the procedural laws may have a what effect? Retrospective effect. What effect? The legislatures may make the procedural laws what? Effective retrospectively. Clear? So let's discuss few important definitions of code of civil procedure. What is the first one? Cause of action. What of action? Cause of action. See, cause of action is the event that gives the right to a party to file a suit. If there is no cause of action, you don't have a right to file a suit. Correct, right? There must be a what? Cause of action. Cause of what? Now tell me, if I have a contract with you and you made a promise to pay me 1 lakh rupees within 2 months. How many months? So I have to wait for how many months? 2 months. On the due date, if you default in paying the agreed amount of money, will I get a cause of action? Yes. I had a right to receive 2 lakh rupees from you and you defaulted or you violated that right to receive 2 lakh from you. Now, can I file a case against you? Yes, because there is a what? Cause of action. Now tell me, a cause of action consists of how many things? Two things. What are the two things? A right and violation of right. Bolo? A right or violation or infringement of right. So cause of action. What of action? Consists of how many things? Two things. What are the two things? A right and infringement of right. What of right? And cause of action is the bundle of facts which a plaintiff is required to prove to succeed in his case. What in case? Succeed in his case. I can get a relief from the court only if I can prove to the court that I had a right plus there is a infringement of right. Then I can claim the remedy from the court. Clear with this? What is the first one? Cause of action. A cause of action comprises how many things? Two things. What are the two things? A right and an infringement for which a relief is claimed. What is claimed? Relief is claimed. Most important one, decree. Bolo, decree. See, what is decree, sir? Listen, everybody. See, the proceedings which happens in the court are called as adjudication. Called as what? Adjudication. The judicial determination of a dispute by the court is called as what? Adjudication. During the adjudication, court will make certain formal expressions. What expressions? Formal expressions and formal pronouncement. Those formal expressions can be classified either as a decree or as a order or as a what? So what is a decree, sir? The formal expression of the court. What of the court? Formal expression of adjudication of the court. What of the court? Formal expression of adjudication of the court. So far, the court expressing it is concerned. Means only the court concerned. It conclusively means it determines the rights of the parties. What of the parties? Rights of the parties with regard to all or any of the matters in what? Controversy and in a suit, and it may be either what? Preliminary or it can be a final. That is called as what? Decree. Simple say simple. If a formal adjudication of a court determines the rights of the party, it is called as what? Decree. If it does not decide the rights of the party, it's only about the procedural aspect. It is called as what? Order. It's called as what? Both are the formal expression of adjudication. The first word should come in your answers when you write answers for a decree or order is formal expression of adjudication. Formal expression of adjudication of a what? Court. So far, the court expressing it is concerned. It is final only for a particular court, not to the appellant court. You can go for an appeal against it, right? Yes or no? The court, so far, the court expressing it concerned, it conclusively determines the rights of what? Parties with respect to what? All or any of the matters of controversy. Any of the matters in what? Are in the suit, and it may be either what? Preliminary or it can be final. It can be what? Final. When it is called as preliminary decree, if there is any further proceedings to be taken before the final disposal of the suit, it is called as what? Preliminary decree. What decree? For example, if there is a suit for partition, when the court decrees the partition, that is called as what? Preliminary decree. When the share of each person is ascertained or properly divided, it is called as what? Final decree. What decree? So decree can be of how many types? One or two types? Preliminary decree, final decree. First of all, what is the decree? Formal expression of the court, formal expression of adjudication of the court. What is adjudication? Judicial determination of disputes, which determines the rights of the parties conclusively with respect to all or any of the matters in dispute, which can be either preliminary or finals. And it includes what? The decree shall be deemed to include rejection of a plaint. Rejection of what? You filed a case. The court rejected your case saying that there is no locus standi. That is also called as what? Decree. Called as what? Decree. What is locus standi? The right to file a suit. If a court rejects your plaint, reject your what? Plaint. It is called as what? Decree. It also includes even the restitution of property. What are property? What is restitution? Restoration of property. What are property? Restoration of property. Any order of the court to restore the property is also called as what? Decree. Called as what? Are you guys clear with this? Yes or no? But does not includes dismissal of suit. What of suit? If there is a dismissal of suit by the court for default in the appearance of parties. What are the parties? If the defendant or the plaintiff does not appear on the serving of summons by the court may dismiss the suit. Dismissal of suit will not determine the rights of the parties to the suit. So dismissal of suit is not called as what? Decree. Not called as what? And an adjudication from which an appeal lies as a what? Appeal from an order. Generally, orders are not appealable, but there are exceptional cases where orders are what? Appealable. So even though the order is appealable, it is not called as what? Decree. Now tell me, please tell me, what is decree? A formal expression of the court, so far formal expression of adjudication of the court, so far the court expressing its concern, conclusive determines the rights of the parties with respect to all or any of the matters in dispute or controversy, which can be either preliminary or final. And it includes what? Rejection of plaint and restitution of property, but does not includes what? Dismissal of suit for default or any orders against which appeal is available as an appeal against the orders. Clear with this? Types of decree. There are how many types of decree? Everybody, two types. I want everyone to concentrate. How many types of decrees? One or two types. Preliminary decree, final decree. By the end of each chapter, you should be in a position to answer all the previous questions asked in the examination, as well as the study material questions. Okay? Concentrate, guys. Types of decree. What is the first decree? Preliminary decree. What decree? What's preliminary decree? Where there are further proceedings to be taken for the final disposal of the suit. It is called as what decree? Final decree. Sorry, preliminary decree. What is final decree? Completely disposes the suit and settles all the questions in controversy. What in controversy? All the questions in controversy. It is called as what decree? Final decree. What decree? Final decree. Next one, order, order, order. Order is also what expression of the court? Formal expression of adjudication. Hello? Expression of adjudication of the court, which is not a decree. It means it does not determine the rights of the parties. It is called as what? Order. Is appeal is available against the order? Not available. No appeal lies against the what? Order, except the law provides otherwise. Correct, right? There are a few exceptional cases. There are five exceptions. How many exceptions? Five exceptions where what is available? Appeal is available. What is available? Other than those five exceptional cases, appeal is not available against the what? Order. Against the what? Types of order. There are how many types of order? Two types. What are the two types of order? Interlocutory order and other orders. If any orders are passed during the pendency of the suit, it is called as what order? Interlocutory order. If any orders are passed before filing a suit, for example, I want to file a suit as a pauper or insolvent. I make an application and the court orders either approving or rejecting. It is called as what order? Other orders. What orders? If an order is passed after the suit, if the order is passed, what is passed? Order is passed after the suit. It is called as what? What order? Interlocutory order. What order? Interlocutory order. If any order is passed before filing a suit, before filing a what? Suit. See, dismissal of suit or rejection of plaint is different, dismissal is different. See, I want to file a suit as an insolvent, a pauper. I make an application to the court seeking the approval of the court, and court reject that application. The rejection of application is different, rejection of suit is different. When the court rejects your suit, it means it is saying you don't have a right to file a suit. Correct, right? That's why it is called as a decree. But if you file a suit seeking the permission, sorry, if you make an application seeking the approval of the court to file a suit as a what? Pauper, as a what? Or an insolvent, and court reject your application or approves your application to file a suit as what? Insolvent person. Is it called as a decree? No, it is called as what? Order. What order? Other order. What order? Sorry, what order? Now, what if you come and file a case against other person saying that this property belongs to you and court reject this plaint? This is called as what? Decree. When court is rejecting your plaint, it means it is indirectly saying that you don't have a right to file a suit. You don't have a right to property. What to property? Right to property. Clear with this? Rejection of what? Plaint. Rejection of what? It is called as what? Decree. Called as what? But however, approving or dismissing an application to file a suit as an insolvent is called as what? Order. What order? Is it determining the rights of the party? No. You sought permission to file a suit as a pauper. Court said no. Pay the court fees and file a case. I'm not deciding the rights of the party. It is called as an order. But what order? Other order. What order? Any order is passed after filing a suit. Interlocutory order. What order? Interlocutory order. Tell me, generally, orders are appealable or not appealable? Not appealable. Are there any exceptions? Yes. There are how many exceptions? Five exceptions. What is the first one, sir? Any order of the court. Below what of the court? Awarding a what? Compensation against any person for making a false or what claims? Vexatious claim is an appealable on the ground that no cost should have been imposed or the amount of cost awarded is what? Excessive. If the court has imposed a compensation, a court has ordered you to pay the compensation for making a wrong, a vexatious or false claims. What claims? False or vexatious claim. Against that order, can you go for an appeal? Yes. On what grounds? Two grounds. You can go to an appeal to the higher court saying that that order should have not been made, or the order should have been made for what amount? Lesser. What amount? For example, she made a wrong claim against the other person because she made a vexatious claim or a false claim. Now I ordered Neha to pay 1 lakh rupees as a compensatory cost. What cost? Or pay compensation of how much? 1 lakh rupees. Against this order, can you go for an appeal? Can she go for an appeal? Yes, she can go for a what? Appeal. On what grounds? Two grounds. She can claim that such order should have not been passed, or the order should have been passed for what amount? Lesser amount. What amount? Clear with this? What is the first situation where the order is appealable? Compensation for what? Any order imposing the compensation for what? Making a false or vexatious claim. False or second one. Any order of the court granting or refusing to grant what? Leave to institute. What do you mean by leave? Permission to file a suit for what? Cases involving the public nuisance or the alleged breach of trust. For what purpose? Public purpose. What purpose? See, if you want to file a suit, if you want to file a what? Suit for the breach of trust or any public nuisance, you need a permission of what? Civil court. You made an application to file a suit for the breach of trust or the public nuisance. court has presented the application form. Against that, can you go for an appeal? Is it an order or decree? Order. But is it appealable or not appealable? Appealable. Next one, any order imposing the what? Imposing the compensation. Imposing the what? When a party has obtained an arrest or attachment or injunction on what grounds? Insufficient grounds. Any order imposing a compensation or awarding a compensation for a party, any order seeking a person to pay the compensation for obtaining an arrest or attachment or an injunction on what grounds? Insufficient grounds. What grounds? Appealable or appealable? Appealable. Next one, any order under CPC imposing a fine or directing the arrest or detention in what prison? Civil prison. What prison? All these are appealable or not appealable? Appealable. And the last one is any order made under the rules of CPC from which an appeal is expressly allowed. How allowed? Expressly allowed. If the appeal is expressly allowed in CPC, is it appealable or not appealable? Appealable. Clear with this? Tell me which are the orders are which are appealable. First one, any order ordering a person to pay the compensation for obtaining for false or vexatious claims. On how many grounds? Two grounds. Second one, any order rejecting an application seeking a leave to file a suit for public nuisance or alleged breach of trust for public purpose. Third one, any order or directing a person to pay compensation for obtaining the arrest or detachment or arrest or attachment or detention of a person in the civil prisons. Correct, right? Next, any order imposing a fine or arrest of a persons. Arrest of a what? Person or detention of a person in the what code? Civil code or any other orders which are considered to be appealable as per the CPC. Appealable as per what? CPC. Can you write about the appealable orders if they ask question in the examinations, everybody? Yes or no? See, both are what? Formal expression. What expression? Adjudication of the whom? Court. So far, the court expressing its concern. If it conclusively determines the rights of the parties, it is called as what? Decree. If it does not determine the rights of the party, it is called as what? Orders. Which one is appealable? Order or decree? Decree is generally what? Appealable. Order appealable or not appealable? Not appealable. But are there any exceptions? How many exceptions? 5 exceptions where the order is appealable. Next one, judgment. Judgment is also important. Judgment is a formal statement. What statement? By whom? That explains the grounds and the reasons behind the what? Decision. G and R. G and what? It explains the grounds and the reasons behind the decision made by the court in the case or judge in the case. That is called as what? Judgment. Decree comes after judgment or before judgment? After judgment. After the judgment, decree is based on the judgment. Okay? Next one, structure of civil court. Structure of what court? Civil court. Well, what court? So at the top level, what do we have? Supreme Court. What court? Under Supreme Court, what do we have? High Court. Under High Court, what do we have? District Court. What court? Under District Court, what do we have? Senior Civil Judge Court, then Civil Judge Court, and the court of what causes? Small causes. What causes? This is the hierarchy of what? Civil Court. What court? Top level, what do we have? Under Supreme Court, under High Court, under District Court, Senior Civil Judge Court, then Civil Judge Court, and the Small Causes Court. What court? Small Causes Court. Then we have stay of suit. What of suit? Are you guys clear with whatever the topics we discussed till now? What is the first concept? Cause of action. Bolo, what of action? Comprises how many things? 2 things. What are the 2 things? Rights and infringement of right. These are the things which a plaintiff is required to prove in order to succeed in his suit. Second one is what? Decree. Second one is what? Decree. Third one is what? Order. Orders are appealable, not appealable. Are there any exceptions? How many exceptions? 5 exceptions. What is judgment? The reasons are the grounds. Grounds and the reasons on which what is given? Decision is given. It is called as what? Judgment. And structure of civil code. Structure of what code? Civil code. Based on section number 10, section number 11, they can ask questions in the examination. What is section number 10? Res sub judice. Stay of suit. What is section number 11? Res judicata. That is bar on suit. Simple says simple. What is section number 10 provides? No suit shall proceed. Bolo. With a word, sorry, not suit, no court shall proceed with a word. Trial of any suit. What of any suit? Trial of any suit in which the matter in issue, below what in issue? Is directly and substantially in issue in a what suit? Previously instituted suit. Well, what suit? Previously instituted suit. Between what parties? Same parties. Between the parties under whom they or any of them claim litigated under the what title? Same title. Simple says simple. It says no court shall proceed with the trial of a suit in which the matter in issue. What in issue? Is directly DSP directly and substantially is in issue in a what suit? Previously instituted suit. Between what parties? Same parties, or between the party under whom they are claiming the right. Where such suit is pending. What is pending? In a what? Same court or any court having a jurisdiction to grant the relief claim, or in any court beyond the limits of India but which are established by the what? Central government and having the life jurisdiction but are before the what court? Supreme Court, but not in the foreign court. Not in the what court? So what did you understand by section number 10? Stay of what? Suit. Stay of what? Suit. If a suit is pending in a court having a jurisdiction to decide that particular matter, the other court should not proceed with the trial. Should not proceed with the what? Trial. This is called as what? Stay of suit. What of suit? Stay of suit. Doctrine of what? Res sub judice. Bolo bolo, doctrine of what? Res sub judice. Are you guys clear with this? Doctrine of res sub judice. Can you write in the exam, if they ask question about doctrine of res sub judice, what is the first word should come to your mind? No court shall proceed. Proceed means what? Should not continue. Should not proceed with the what? Trial. With the what? Of a what? Suit. What type of suit? A suit in which the matter in issue. What in issue? Is directly and substantially in issue. In which suit? Previously instituted suit. Between what parties? Same parties. Are the parties who are claiming another particular parties, and it is pending before a what? Court. Same court. Or any other court having a jurisdiction, or any court established by the central government or the Supreme Court. What court? That is called as what? Res sub judice. Called as what? What is the first word? First word should come to your mind when they ask question about res sub judice. No court shall proceed with the trial. Of what type of suit? The suit in which the matter in issue. What in issue? Is also directly and substantially issue. In which suit? Previously instituted suit, and it is pending. Between what parties? Same parties, and it is pending between what? Court. Having the what? Jurisdiction either in the same court or in the any other court or the Supreme Court. What court? Supreme Court. Then comes res judicata. What is the next one? What is res judicata, sir? Res judicata means bar on suit. What on suit? Once a court is decided, sorry, once the case is decided, no other court should try the same case. What case? Because there should be an end to litigation. End to the what? Litigation. Nobody should be harassed over a long period of time for the same offenses. What offenses? Same offenses are the same cases. Correct, right? No court. Follow what court? Shall try what? Any suit or issue. Follow? No court shall try any suit or issue in which, in what type of a suit or issue, in which the matter has been what? Directly and substantial in issue. In the what suit? Formal suit. Between what parties? Same parties. And in what court? Competent court. In which the issue has been what? Subsequently raised and finally decided by such court. What by court? Decided by the court. Simple. No court shall try. There, no court shall proceed. Here, no court shall try. Well, in res sub judice, what you will write? No court shall proceed. Res judicata, no court shall try. What? A suit or a issue in which the matter has been directly and substantially issued in the what suit? Previously instituted suit between what parties? Same parties, and has been decided by the what? Such court. Decided by what court? Such court. Then it is called as what? Res judicata. It is based upon the principle that there should be an end to litigation. End to the what? Litigation. There should be end to what? Because nobody should be harassed over a long period of time for the same issue. What issue? Same issue. There is also a concept called as constructive res judicata. What res judicata? Constructive res judicata. What is constructive res judicata? Where if you could have claimed the right in the previous suit itself, but you omitted to claim because of your negligence, can you claim it by filing a new suit? That is called as what? Constructive res judicata. Even though you did not claim it in the previous suit, it is assumed that you have claimed it and it has been denied by the court and you cannot file a new suit for enforcement of what? The same right. What right? Same right. इसको बोलते हैं constructive res judicata. What res judicata? Otherwise, what everyone will do, they will file one suit for one right, again they will file the one more suit for the different right. Correct, right? So to avoid this kind of issues, what court has done, there is a principle called as constructive res judicata. If you want remedy, you claim everything in first suit itself. Whatever the rights available to you, you cannot file multiple suit. What suit? For the same cause of action. What cause of action? Same cause of action. That is called as what? Res judicata. One should not proceed with the trial. This one should not try the suit or issue. Try or what? Suit or issue. Clear with this? Res judi. It is based on the what principle? It is based on the public policy that there should be end to what? Litigation. Below end to what? And the parties to a suit should not be harassed on the same matter already decided. Already what? Decided. Clear with this? Next, we have jurisdiction of the court. What of the court? Jurisdiction of the court. Tell me, what is jurisdiction? Power or the authority of the court to hear and determine the what? Cause. Or a matter is called as what? Jurisdiction. Power or authority of the court to decide the matter is called as what? Jurisdiction. Called as what? Limitations on jurisdiction. There are various types of limitations which can be imposed by the state by making a law as the code. What we can classify that limitation of jurisdiction of the civil code into how many kinds? Four kinds. Well, how many kinds? What is the first one? Over the subject matter. What matter? So different court has a jurisdiction over the different subject matter. For example, family court has a jurisdiction only over what matters? Family matters. Correct, right? Civil court, civil matter. Criminal court, criminal matter. So based on subject matter, different court has a different parts. There is a limitations over the jurisdiction of the court based on what matter? Subject matter. What matter? Next one, place of suing or territorial jurisdiction. What jurisdiction? If an offense happens in Karnataka, can the suit be filed in Tamil Nadu? No. Place of filing a what? Suit. If the property is in Ramanagar, can you file a suit in Chennai? Can you file a suit in Bengaluru? Can Bengaluru court try a case with respect to the property which is situated in the Ramnagar? No. Which court has jurisdiction? Ramnagar. Territorial jurisdiction. What jurisdiction? So we can impose the limitations on the jurisdiction of the court either based on the subject matter. What matter? Or based on what? Territorial distribution. What distribution? Territorial jurisdiction. Next one, jurisdiction over the what? Powers, persons. Over whom? The jurisdiction of the court extends to all the persons except in case of foreign sovereigns. What sovereigns? They are not subjected to the jurisdiction of the what? Local courts. What courts? Local courts or any other country's courts. Correct, right? Next one, pecuniary jurisdiction. What jurisdiction? What is pecuniary jurisdiction? Monetary value. Court of small causes has a different pecuniary jurisdiction. Civil court, junior division has a different pecuniary jurisdiction. So based on the monetary value of the suit, we can impose the what? Limitations on the jurisdiction. What on jurisdiction? Limitations on the jurisdiction. There are how many limitations? First of all, what is limitation? Sorry, what is jurisdiction? Power or authority of the court to decide the dispute or matter. It is called as what? Jurisdiction. It can be of how many? There can be how many types of limitations on jurisdiction? Four. What are the four? Jurisdiction over the subject matter, place of suing or territorial jurisdiction, jurisdiction over the persons, pecuniary jurisdiction. What jurisdiction? Pecuniary jurisdiction. Next, we have classification of jurisdiction based on the what? Power. Based on what? Power. The rights. First one, original jurisdiction. What jurisdiction? Where the case is filed originally, it is called as what? Original jurisdiction. As per the CPC, all the suit should be instituted or filed in the court of what grade? Lowest grade. What grade? Next one, appellate jurisdiction. What jurisdiction? Appellate jurisdiction, the court which has the right to hear the appeal is called as what jurisdiction? Appellate jurisdiction. Then we have criminal and appellate jurisdiction. Bolo what jurisdiction? Criminal and appellate jurisdiction. High Court and Supreme Court both have criminal jurisdiction as well as the appellate jurisdiction. Bolo what jurisdiction? Are you guys clear with this? The limitations on the jurisdiction of the court. First of all, what is jurisdiction? Authority or a power of the court to decide the issue or matter. It is called as what? Jurisdiction. What are the types of limitations on jurisdiction? How many are there? What are the four? Subject matter, territorial, over the persons, and pecuniary jurisdiction. What jurisdiction? Classification of jurisdiction based on what? Power. What is the first one? Original jurisdiction, appellate jurisdiction, and criminal and appellate jurisdiction. Are you guys clear with this, everybody? Next, we have section number 9. Section number 9 is simple, say simple provision. It provides that civil court shall have the power to try all civil cases unless it is expressly or impliedly barred. It is expressly barred if it is stated in the law itself that civil court does not have a jurisdiction. Does not have a what? Jurisdiction. For example, in the civil, in many places, it is clearly mentioned that civil court does not have a what? Jurisdiction. Correct, right? Or it is impliedly barred when there is a special tribunal or a special forum is established under the act to deal with the particular matters. So unless it is expressly or impliedly barred, which court has jurisdiction to try all civil cases? Civil court. What court? Section number क्या है? 9. Section number क्या है? 9. Section number 9 provides that civil courts. What courts? Guys, which court? Shall have a jurisdiction to try all suits of what nature? Civil nature, except that suit of which their cognizance is eitherly what? Expressly or impliedly barred. Are bolo what barred? Expressly or impliedly barred. When it is expressly barred, a suit is expressly barred if the legislation specifically states that civil court do not have the what? Jurisdiction to hear such cases. Hear such what? Cases. When it is impliedly barred, when a statute creates a new right or a liability and designates a specific tribunal or a forum for the assertion and enforcement of that right or liability. Law creates a right and liability, and to enforce that right and liability, there is a separate forum, there is a separate tribunal. Then it is implied that the jurisdiction of the civil court is part. Clear with this? Section number क्या है? Section number क्या है? 9. So what is section number 9? Power of the which court? Civil court. अरे what court? Section number 9. Then we have place of filing a suit. Important day. Based on this, they may ask practical question, either a practical question or a theory question. Now tell me, before I go to the next topic, what are the topics I discussed till now? What is the first one? Cause of action. Second one, decree. Third one, order. Types of order and appealable orders. What orders? There are how many appealable orders? 5 appealable orders. Judgment. Then structure of what court? Civil court. What court? Then we discussed what? Res sub judice. Shall not try the suit, shall not proceed the trial of a suit. Proceed with the trial of the suit. Res judicata shall not try a suit which has been finally decided. Finally what? Res judicata. Then what else we discussed? Limitations on the jurisdiction of which court? Civil court. What court? How many types? What are the 4 types? Subject matter, territorial, persons, pecuniary. Based on power? What are 3? Original, appellate, civil and criminal jurisdiction. Criminal and affiliate jurisdiction. Next, section number 9 provides that civil court to try all civil cases except this expressly or impliedly not. Next one, section number 15, place of filing a suit. Important, darshan, important darshan. Every suit shall be instituted in a court of what grade? Lowest grade. What grade? Competent to try it. Correct, right? Section 16 of the Act provides that suits in respect of immovable property. What property? Arre bolo bolo, what property? Immovable property. Any suit in respect of immovable property subject to pecuniary jurisdiction. What jurisdiction? Following suits shall be instituted within the local limits of whose jurisdiction the property is situated. What is situated? With respect to immovable property, you should file a suit in a court within whose jurisdiction the property is situated. The first rule, keep this in mind. Every civil suit should be filed in a court of what grade? Lowest grade. Start from the lowest grade. Start from the scratch. Then go for the higher levels. Correct, right? Lowest grade. Then, in case of immovable property, what property? You should file a suit within in the court within whose jurisdiction the property is situated. What is situated? With respect to what? For the recovery of what property? Immovable property. What property? Somebody trespassed my property. He is staying in the property. I want to recover it. Can I recover it? Yes, by filing a what? Suit. Where I can file a suit? In a court within whose jurisdiction what is situated? Property is situated. Well, what is situated? Property is situated. Next one, partition of immovable property, same provision. Next one, foreclosure of sale or redemption in case of what? Mortgage. The mortgagee, for example, bank want to recover the property or they want to sell the property for the default in the payment of debt, where they can file a suit. Within whose jurisdiction the property is situated. Next one, determination of any right or interest in what property? Immovable property. Compensation for wrong done to what property? Immovable property. Or recovery of movable property which is attached to the what? Immovable property. What property? Immovable property. What property? In all these cases, the suit should be filed within whose jurisdiction the property is situated. Well, what is situated? Property is situated. Clear with this? First rule is that you need to file a civil case in the court of what grade? Lowest grade. With respect to immovable property, any of the suit with respect to immovable property should be filed within whose jurisdiction the property is what? Situated. Next one, suit of for immovable property. Bolo bolo, what property? Situated within the jurisdiction of what? Different courts. What courts? If the property is situated within the jurisdiction of the different court, in that situation, the suit can be filed in any of the court. What court? That has jurisdiction over one of the properties, provided the court has the jurisdiction over the what? Total claim value. What value? Total claim value. One property is in Ramnagar, one property is in Bengal, one property is in Mandya, and you want the partition of all this property, where you can find any of this court having the what jurisdiction? Pecuniary jurisdiction. What is pecuniary? Monetary value. What value? Next one, where the local limits of jurisdiction of the court is uncertain. Two or more court is having a jurisdiction over the same property. In that situation, any of the court can try the suit after recording the fact that jurisdiction is uncertain. What is uncertain? Jurisdiction is uncertain. Correct, right? Section number 19. Section number 19. Suit for compensation. Below what for compensation? For wrong done to whom? Person or movable property. What property? Are simple say simple. We were discussing about which concept? Jurisdiction for filing a suit. Or place of filing a what? Suit. Tell me, where do you start your suit? Where do you file a case? Lowest grade. Immovable property, where you file a case? In a court within whose jurisdiction what is situated? Property is situated. It can be for foreclosure, it can be partition, it can be recovery of immovable property, or wrong to the immovable property, or recovery of anything attached to the immovable property. What if the jurisdiction of the court is uncertain? Which court can try the suit? Any of the court, after recording the fact that Jurisdiction is uncertain. But however, if the property is situated in the jurisdiction of more than one court and multiple courts, any of the court can try the suit. Having what jurisdiction? Pecuniary jurisdiction. Next one, in case of suit for a wrong done to a person. What done to a person? Wrong done to a person. Or in case of movable property. What property? In this situation, the suit can be filed within what? Where you can file a case? The court within whose jurisdiction what has been committed? Tort has been committed. What has been committed? Or within whose jurisdiction the defendant resides. Who resides? There are two options here. Either you can find a case at a place where who resides? Defendant resides. Who decides? In case of movable property or a wrong or a tort. Correct, right? Or a cause of action arises, means the place of contract or the place where the wrong is done. For example, Chirant is from Mandya, but wrong is done in Bengaluru, where the case can be filed in Bengaluru or Mandya. Any of these places, I can file a case either at a place where the defendant resides or carries on the business for profit, or place where what arises? Cause of action. What arises? Cause of action. What arises? Cause of action. Next one, other suits. What suits? Other suits, simple say simple, any other suit should be filed within the local limits of whose jurisdiction the defendant actually or voluntarily resides or carries on the business or personally work for the gain, or where the cause of action wholly or partly in his what? Arises. Either at a place where the defendant resides or at the place where the cause of action arises. What arises? Cause of action arises. Next one, in the case of body corporate. What corporate? Where you can file a case wherever the company has a registered office or wherever the cause of action arises. However, parties by an agreement can confer the jurisdiction to any one of these court. For example, Reliance Company has a registered office where Mumbai. Contract is made in Bengaluru. Where is the cause of action? Bengaluru. Where the company resides? Mumbai. Where can I file a case? Mumbai or Bengaluru. Mumbai or what? However, parties by an agreement can confer the jurisdiction to any one of these places, either to Mumbai or to the Bangalore or to the what? Are you guys clear with this? These are the provision with respect to what? Place of filing a suit. Bolo? Or a jurisdiction. Tell me immovable property. Where do you file a case? Where the property is situated. Movable property, where the defendant resides or cause of action arises. Other suits, wherever defendant resides or the cause of action arises. In case of if a jurisdiction of the court is uncertain with respect to immovable property, which court can try the suit? Any of the court. After recording the fact of that jurisdiction is uncertain. Are you guys clear with this? Yes or no? Place of filing a suit. They may ask questions for 6 marks in the examinations. Next one, set off. Counterclaim. Equitable set off. The moment the word set off comes, you should remember that set off is a acquittal of debt. What of debt? Acquittal of debt. A reciprocal acquittal of debt is called as what? Set off. Set off has the effect of extinguishing. Effect of what? Extinguishing the claim of the plaintiff to the extent of claim of whom? Defendant. Claim of whom? Defendant. Yes or no? See, you have claimed 1 lakh rupees. Defendant is claiming 50,000 rupees. To the extent of the claim of the defendant, the claim of the plaintiff is extinguished, destroyed. That is called as what? Set off. A reciprocal acquittal of debt is called as what? Set off. I claimed 1 lakh rupees. You are claiming 50K from me. Both are set off. And I'm liable to pay only how much? 50,000. Listen, for claiming the setup, there are 4 conditions to be satisfied. How many conditions? 4 conditions. First one, the suit must be a money recovery suit. What suit? Recovery of money. Second one, it should be legally recoverable. Legally what? What should be legally recoverable? The money, the whatever defendant is claiming, set of money should be legally recoverable. Legally what? Recoverable. And third one, the third condition is that it will be an ascertained sum of what sum of money? What sum of money? Ascertain sum of money, and the claim you make should be within the pecuniary jurisdiction of the court. and it should be claimed at the first hearing itself. What hearing itself? First hearing itself. However, the court may permit it to be claimed even at a later stage. What stage? Later stage. For example, I filed a case against you for recovery of 1 lakh. Recovery of how much? Can you also claim set off? If I am liable to pay some amount of money to you, yes. How much you can pay? 1 lakh, 2 lakh, 3 lakh, 4 lakh, 5 lakh. How much ever you want, how much ever the claim you have against me, provided it is a what sum of money? Ascertain. Fixed sum of money, not uncertain sum of money. Yes or no? What sum of money? Should be what? Legally recoverable. Legally what? Legally. Third condition, it should be within the what jurisdiction? Pecuniary jurisdiction of the court from where you are claiming it, and it should be claimed in the what statement? First statement. Nothing but your return statement. What statement? However, the court may allow you to claim it even at a later stage. What stage? Later stage. That is called as what? Set off. Called as what? See, for example, I have taken a loan of 2 lakh from you. You have taken a loan of 3 lakh from me. Now I filed a case against you for recovery of how much? 3 lakh. Can you claim set off here? Are you claiming a fixed sum of money or uncertain sum of money? Ascertain sum of money. What is ascertain sum of money here? 2 lakh rupees. Correct, right? Is it legally recoverable? If it is time barred, can you claim set off? No. Should be what? Legally recoverable within the what jurisdiction of the court? Pecuniary jurisdiction of the court. And in what statement? First statement. What statement? Are you guys clear with set off, everybody? What is set off? Reciprocal acquittal of debt. It's called as what? Set off. What is the effect of set off? Extinguishing the what? Claim of the plaintiff to the extent of claim made by whom? Defendant. Can you guys write about set off in the examination? Tell me, set off is allowed only for ascertain sum of money or unascertain sum of money? Very good. In what suit? Money recovery suit or any suit? If I file a suit for tort, can you claim the set off? No. It should be what suit? Money recoveries. Can you claim set off for unascertain sum of money? Only for what sum of money? Ascertain sum of money. Is it required to be legally recoverable? Yes or no? Yes. Next we have counterclaim. What claim? Counterclaim is nothing but what? It's a cross action. What action? Whatever the claims you make in your return statement against the claim made by whom? Plaintiff. It is called as what claim? Counterclaim. Counterclaim also includes set off. Set off is also one of the what claim? Counterclaim. What claim? All the claims you make in your return statement is called as what claims? Counterclaims. What claims? Arey sir, no. Arey sir, no. It is a what action? Cross action. What action? Counterclaim need not arise out of what transaction? Same transaction. What transaction? Same. But equitable set off. What set off? Regular what set off? Should arise out of what transaction? Same transaction. What transaction? Counterclaim may exceed the what claim? Plaintiff's claim being the nature of what action? Cross action. What action? For example, let's say I am liable to pay 5 lakh rupees. How much I'm liable to pay? How much I'm liable to pay? 5 lakh rupees to you. You are liable to pay me 1 lakh. So I filed a case against you for recovery of how much? 1 lakh. Can you claim set off of 5 lakh here? Can you recover 5 lakh? See, I filed a case to recover 1 lakh, but I am liable to pay you 5 lakh. So when you appear and file return statement, can you claim 5 lakh rupees? Yes, you can claim. That is called as counterclaim. What claim? Court will set off 1 lakh and orders the plaintiff to pay remaining how much? 4 lakh. Set off amount may exceed the claim of whom? Plaintiff. Are you guys getting this point? Yes or no? Clear with set off and counterclaim. What claim? Next one. Next one. Equitable set off. What set off? Wherever the word equity comes, it is a discretionary power or a matter of right? Discretionary power. For example, equitable reliefs, injunctions are all what? Discretionary power of the court. Court may grant it, may not grant it. In the interest of what? Justice. In the interest of what? Justice. Yes or no? Applied in the case of what? Unascertain sum of money. What sum of money? Equitable setup available for ascertain sum of money or unascertain sum of money. Unascertain sum of money. For example, I promise to supply 500 kg of goods to you. I supplied 400 kg. How much? 400 kg. Remaining 100 kg, I refuse to supply. And you bought the remaining 100 kg in the market by spending extra 50 rupees. How much? 50 rupees. If I file a case against you for recovery for money for the 400 kg of goods in the same suit, what you can claim? You can claim the loss suffered. What suffered? By you for not supplying remaining how much? 100 kg. Are you claiming the ascertained sum of money or unascertained sum of money? Uncertain sum of money. Uncertain. You don't know what is the amount of compensation the court is going to give. Is it arising out of same transactions or different transaction? Same transaction. What transaction? So the concept of equitable set-off is available only if it is a same transaction and it is a what sum of money? Uncertain sum of money. And the one more thing is that in case of equitable set-off is allowed even if it is what word? Time bar. Even if it is what word? Clear? But set-off should be legally recoverable. Legally what? Recoverable. No court fees is required for claiming the what? Equitable set-off. What set-off? Can you guys write about set-off, counterclaim, equitable set-off? Tell me, which one is a cross action? Counterclaim also includes what? Set-off. Can the counterclaim exceed the claim made by the plaintiff? Which one should arise out of same transaction? Which one may not arise out of same transaction? Set-off. Set-off or counterclaim. Correct, right? Which one should be legally recoverable? Which one may not be legally recoverable? Equitable set-off. What set-off? Equitable set-off. Are you guys clear with this? Yes or no? Next one. Next one. Temporary injunction. What injunction? Temporary injunction. Based on this, they may ask question in the examination. First of all, what is injunction? Injunction is a equitable remedy in the form of an order. Form of what? Is it a decree or order? Decree or order? Does it determine the rights of the parties? No. But it's a formal expression of adjudication. Well, what expression of adjudication? Formal expression of adjudication. Injunction. Injunction. Which junction? Injunction is an equitable remedy in the form of court order that requires a party to do or refrain from doing certain act. If it requires a person to do something, it is called as mandatory injunction. If it prohibits a person or refrains a person from doing something, it is called as what? Prohibitory injunction. What injunction? And most important, when the injunction is granted, the court, in the exam, they may ask this question, in what cases the injunction may be granted? If any of the following things are proved by what? Affidavit. Bolo, affidavit, a temporary injunction. What injunction? Can be issued. Can be what? Issued. What is the first one? If the property involved is in the danger of what? Being wasted. Being what? Are damaged or alienated by the defendant. If the defendant is planning to waste it, damage it, or transfer it, in that situation, you can get the injunction of the court to prevent the person from doing it by filing an affidavit. Filing a what? Affidavit. Correct, right? For example, we have a dispute over 100 kg of mangoes. I am claiming that that belongs to me. You are claiming that that belongs to you. Now, can I file a case? Yes. And during the pendency of suit, to prevent the goods from being wasted, damaged, or sold, can I get a restraint order of the court? That is called as what? Injunction. What injunction? What injunction? Temporary injunction. What injunction? Temporary injunction. If the defendant is about to sell, about to what? Or transfer the property in violation of the valid claim or in execution of a decree that is disputed. That is what? Disputed. If the defendant is about to sell it or transfer it in violation of a claim of the plaintiff or the execution of decree of the plaintiff, what can be issued? Injunction can be issued. Next one. If the defendant intends to remove or dispose of their property with the intention of what? Defrauding the creditors or evade the legal action. What action? With the intent to defraud the creditors, if you are removing the property to prevent you from removing the property, can court issue injunction? Yes. Next one. If a defendant Threatens to disposes the property, disposes the plaintiff of the property, or otherwise cause injury to whom? Plaintiff. If the defendant make a threat to dispossess the property from the plaintiff or to cause injury to the plaintiff can get what? Injunction. Get a what? Injunction. Next one, the plaintiff is required to prove that he has a what case? Prima facie case means at the outset he has a right. Third one, if injunction is not granted, it would lead to what? Irreparable loss. What loss? If we can prove all these things, then the court will grant a injunction. Court will grant a what? Injunction. First of all, what is injunction? It's an equitable remedy in the form of what? Order. When a person, a plaintiff proves that by an affidavit, any of the following, the court may grant an injunction. What is the first one? The property of the dispute is in the danger of being wasted, damaged, or perished, or alienated by the plaintiff. Next one, if the defendant is about to sell or transfer the property in violation of valid claim or in execution of decree, if the defendant intends to remove or dispose of their what? Property with the intention to defraud whom? Creditors. Next one, if the defendant threatens to dispossess whom? Plaintiff of the property, otherwise cause injury to whom? Plaintiff. Necessary for the plaintiff to prove that he has a what case? Prima facie case. What case? Correct, right. Are you guys clear with this? Can you write in the examination when the injunction can be granted? What can be granted? Injunction can be granted. Have you heard about interlocutory orders? Any orders passed during the pendency of a suit is called as what orders? Interlocutory orders. These are issued when the court feels that irreparable harm may cause to the what? Other person. Court can pass the interim orders or interlocutory orders for the following purpose. What is the first one? Order for the detention, preservation, inspection of any property that is a subject matter of the one suit or disputed, authorized any person to enter the land or a building in the possession of any party for the purpose of what? Detention, preservations, or inspection, authorized taking of samples, making observations, conducting experiments to obtain the what? Evidences. Obtain the what? And for these purposes, who can issue the interlocutory orders? Court can issue the interlocutory order. Order for detention, preservations, inspections of any property, and for that purpose, it can authorize a person to enter any land or a building and to carry out any experiments or collect the samples or collect the evidences. Collect the what? Evidences. Clear with this? Next one, deposit of money or property. What are property? Court can order. Who can order? For deposit or delivery of what? Money or things in the cases where subject matter of the suit is what? Money or what property? Movable property. Below what property? The subject matter of the suit is a money or what property? Movable property. One party admits that money or property they hold belongs to which party? Another party. Or they are holding it as a what? Trustee. The court may order it to be deposited to the custody of what? Court. It's simple. In a money recovery suit. What suit? Or a movable recovery of movable property. If the other person admits that he is having the possession of the property which belongs to the plaintiff, or he admits that he is holding the property as a trustee. In that situation, who may order for restoration of the property, deposit of the goods or money? Court may order the person to deposit the goods or the money to the custody of the court. Clear with this? Yes or no? These are what orders? Interlocutory orders. What orders? And what orders? Interlocutory orders. Are we clear with this, everybody, boys and girls? Yes or no? अब हम डिस्कस करेंगे हाउ टू फाइल ए सूट इंस्टीट्यूशन ऑफ व्हाट सूट are stages involved in the suit. Important. I will tell you important concepts or important topics based on which they may ask questions in the examination. Concentrate, everybody. Parties to the suit. What is the suit? See, in a suit, there will be how many parties? Minimum two parties, plaintiff and what? Defendant. The one who files the case is called as what? Plaintiff. Person against whom the case is filed is called as what? Defendant. If the case is X versus Y. X versus what? Who is X? Who is X, plaintiff or defendant? Not your X. This X. Who is X? Plaintiff. Who is Y? Defendant. The one who files the case is called as what? Plaintiff. The person against whom the case is filed is called as what? Defendant. Called as what? Defendant. The one who files the case is called as what? Plaintiff. Other person is called as what? So, between X and Y, who is the plaintiff? X is the plaintiff. Who is the defendant? Y is the defendant. Next, we have important concept called as joinder of parties. What are parties? What is joinder of parties? When two or more parties is joined in a suit is called as what? Joinder of parties. The joinder of parties can be what? Plaintiff or defendant. Plaintiff or what? When two or more parties is joined as a plaintiff, it is called as what? Joinder of plaintiff. When two or more parties are joined as a defendants, they are called as what? Joinder of defendants. Joinder of what? Defendants. Correct, right? Joining up one or more parties to the suit is called as joinder of parties. When the act is done by two or more person, or it affects what? Two or more person, it is called as what of parties? Joinder of parties. What of parties? Array, what of parties? Joinder of parties. Then we have misjoinder. What joinder? Array, bolo, what joinder? Misjoinder. For example, X and Y is fighting. X is an husband, Y is a what? Wife. Both are fighting. Wife to file a case. Who want to file a case? Y. So she can file a case against whom? X. So instead of filing a case against X, sorry, she filed a case against X and also against whom? Mr. Z, who is nowhere related to what? This case. Now this joinder of Mr. Z is called as what joinder? Misjoinder. Joinder? What joinder? Misjoinder. Clear with this? When a person is joined in a suit against whom there is no relief. There is no what? Relief. Against whom the right to relief does not arise, against whom a separate suit is brought. What is what? Separate suit is brought. If a separate suit is filed, there is no common question of law or fact would arise. What will not arise? There is no common question of fact or question of law. Then it is called as what? Misjoinder. What joinder? If a person is joined in a suit against which there is no right of action, right of what? Action. That is called as what? Misjoinder. What joinder? There is no common question of law or common question of, for example, I made a contract with partners in a partnership firm. There are three partners in a partnership firm, and they have taken a loan from me. The default in repaying the loan. Tell me, can I join all three of them as a defendants? Yes or no? I have a right to file a suit against whom? All three of them. I have a right to relief from all three of them. Hi, na? That is called as what? Joinder of plaintiff or joinder of defendant? Joinder of plaintiff. Correct, right? They are necessary party. What, sorry, defendant. Joinder of what? Defendants. Clear with this? Now, what if I had someone else also against whom there is no right to relief? It is called as what? Misjoinder. There is no common question of law or common question of fact. Next one, non-joinder. What joinder? What is non-joinder? Where a party wrongly. No, no. This is also what? Misjoinder. This answer is wrong. Provision is wrong. See, where a person who is required for the proper disposal of the suit is not added in a suit. It is called as what? Non-joinder. What joinder? If a person who is necessary to dispose the suit is not added in a suit, it is called as what? Non-joinder. If there is a common question of fact or a common question of law, and if that party is not added in a suit as a party to the suit, it is called as what? Called as what? Non-joinder. What joinder? Non-joinder. Next one, necessary party and proper party. Important, important. Necessary party and proper party. I expect ICSI to ask question based on these two topics in the upcoming examinations. Listen, everybody. Necessary party. What party? Regular what party? Who is necessary party? One whose presence, one what? Whose presence is indispensable for the suit to proceed. What to proceed? Suit to proceed. And suit cannot be effectively disposed without involving the party. Without involving the what? Party is called as what party? Necessary party. What party? He is very much essential. Without him, you cannot dispose the property. Dispose of what? Property. For example, there are two brothers who have made a promise to me to sell the property. Can I file a case against only one of the person? For example, let's say X and Y. Oh, अरे बोलो who X and Y are the joint owners. What owner? Joint owners. बोलो what owners? Who are the joint owners here? X and Y. Are who are the joint owners? X and Y. They have a joint owners, and Mr. Z is claiming this property. Who is claiming the property here? Z. If you want to claim the property, you should file a case against who? Both X and Y. Both whom? Now, what if he only makes Y as a party? What as a party? Tell me, is it possible for the court to dispose this suit completely? No, because who is also required? X is also required. Who is also required? Yes or no? You know. So if X is not added, it is called as what? Non-joiner. What joiner? Non-joiner. What joiner? Non-joiner. The presence of a person whose presence is indispensable. Means इसका जरूरत है. He should be present in the suit, or he should be made as a party to the suit for an effective disposal of the suit. Then he is called as what party? Necessary party. Bolo what party? The presence of whom is indispensable in a suit. He is called as what party? Necessary party, and the suit cannot be effectively disposed without he involve that particular person. To determine the necessary party in the Hardeva versus Ismail case, what happened? There must be a right to some relief against the person in respect of the matter involved in the suit. The court cannot pass a what decree? Effective decree. What decree? If a court cannot pass an effective decree without the presence of that person, it is called as what? What party? Necessary party. What party? There are two joint owners. I need to file a suit, or I should make both of them as a party to the suit. Why? Because without the presence of other person, I cannot get an effective decree from the court, or the court cannot dispose the case. Then that particular party is called as what party? Necessary party. What party? Next one, we have a proper party. What party? A be important. Someone whose presence in the suit is required. His presence is also required, but it is not indispensable. If the presence of a person is indispensable for effective disposal of the suit, he is called as what party? Necessary party. But however, where the presence of a person is required in a suit for a complete and final, complete and what? Final decision, but not necessarily indispensable for the suit to proceed, then he is called as what party? Proper party. What party? If it is indispensable. Presence of a party, if it is indispensable, he is called as what party? Necessary party. Where the presence of a person is required, but however, it is not indispensable. Then is called as what party? Proper party. Means the court can still pass an effective decree. What decree? Effective decree. What decree? But for a finality and completeness of the decision, the court may require their what? Presence. For a completeness of the decision. For example, let's say there is a contract made by Darshan on behalf of Sanjay. Behalf of whom? Sanjay. Now the contract is made by Sanjay with whom? CSR. With whom? CSR. Correct? Contract is made by whom? Sanjay. Sanjay is the principal, CSR is the third party, Darshan is the agent. Darshan is a what? Agent. Now tell me, if I want to recover the property from the principal, can I file a case against the principal? Yes or no? Because I have a right against the principal, not against the agent. But tell me, am I required to add even agent as the party to the suit? Yes, but it's completeness of the suit. What of the suit? Completeness. But what if I don't add this agent as a party, can I still get an effective remedy from the court? Yes. That is why here the agent is called as what party? What party? Proper party. What party? Proper party. But principal is called as what party? Necessary party. What party? Without him, how can you get remedy from the court? How can you get an effective decree from the court? Yes or no? I have a strong inside that they may ask question based on what? Based on what party? Necessary party and proper party. Clear? Understood? Yes or no? Next one. Misjoinder. What joinder? What is misjoinder? Adding a person who is not required in the case is called as what? Misjoinder. It can be a misjoinder of a party, misjoinder of cause of action. Cause of what? Action. Cause of what? Action. So cause of action that do not logically belongs together are joined in the same suit. It is called as what? Misjoinder. What joinder? Misjoinder of what? Cause of action. For example, I have given this building first to Mr. X, second floor to Mr. Y, third floor to Mr. Z. Mr. Whom? Z. Different contract. I want to evict them all from this building. Can I file a single suit against all of them? Yes or no? Answer is no. Because there is a different cause of action. For every person, I have a different contract, right? I cannot add all of them together. If I add all of them together, or if I add all these three cases together, it is called as what? Misjoinder of cause of action. Bolo, what are cause of action? Misjoinder. What joinder? Are you guys clear with this? Yes or no? These are the provision with respect to the parties to a suit. I want everyone to concentrate. Look here, everybody. Concentrate. Tell me. Tell me. How many parties are required in a suit? What are two parties? Plaintiff and defendant. Plaintiff and one who files the case. The one against whom the case is filed. The person who is essentially required and without whose presence or the whose presence is indispensable, where the presence of a person is required but his presence is not indispensable. Proper party. What party? Joining of two or more parties to a suit. Joinder of what? Joining two or more cause of action. Joinder of cause of action. If you join a party against whom there is no common question of law or common question of fact, or there is no right to file a suit, it is called as what? Misjoined. What joinder? What if a person who is necessary party or a proper party is not joined in a suit? Then he is called as what? Non-joiner. What joiner? Are we clear with all these terms? Can you write in the examination if they ask any of this topic? Next one. Next one. Concentrate. What is the next one? What's the next one? Summons. What is summons? It is an order or it's an instrument issued by the who? Court. Call upon a person to appear before the court to answer the court. It is called as what? Summons. Called as what? Summons can be served in the following ways. They may ask questions based on this. They ask questions based on this in the previous examination. The summons is served upon a person in the following ways. What is the first one? Deliver ordinary mode of what? Service of summons. Important thing. What is the ordinary mode of service of summons? Say simple. The summons can be delivered by sign. Yes, sending a what copy? Signed copy of a summons by the judge or a competent officer of the what? Court. It is delivered to whom? Defendant personally or defendant's agent or adult male or female member of the what? Family who is residing with him. Important. He should be residing with whom? With that defendant. Clear? And the person receiving must acknowledge the service by signing the what? Acknowledgement receipt. What is the ordinary mode of service of summons? Summons, a signed copy of the summons signed by either the judge of the court or officer of the court by delivering the same to whom? Defendant or to authorized agent or adult male or female member of the family. Earlier, only male member was there. Then the females were like, it's a violation of right to equality, discrimination, gender discrimination. Because of that, they added the word called as what? Male or female, residing with what? Him. And the person who receives it must acknowledge the receipt of what? Summons. Next one, defendant resides within the jurisdiction of the court. What of the court? Jurisdiction of the court. See, We are discussing ordinary mode of service of summons. Deliver a signed copy of the summons to defendant or his agent or adult male or female members. Now, how to send it? What is the mode of sending it or how to deliver it? Two scenarios. If the person resides within the jurisdiction of the court, then the officer of the court or any other officers of the court, the court will deliver the copy to the officer of the court, and the officer of the court, what of the court, will deliver the same to whom? The defendant or through a approved courier services. Surya, what services? Approved courier services. What services? Courier services. Clear with this? When this mode of service is done, when the defendant resides within the jurisdiction of the court. What of the court? Within the jurisdiction of the court. Clear with this? What if a defendant reside outside the jurisdiction of the court? What of the court? Outside the jurisdiction of the court. Then how summons is done? Delivering or transmitting a copy by what post? Registered post. And what post? With what you acknowledgement you address to the defendant or their agent authorized to accept the what? Service. Accept the what? Service. Other methods includes speed post, courier services, any other means of document transmission, fax, email, in accordance with the what court rules? High court rules. Clear with this? If a defendant resides outside the jurisdiction of the court, the same can be sent either by what post? Registered post or speed post or any other courier services or any other means of what? Document transmission, including the email. This is ordinary mode of service of summons. What mode of service of summons? Now, what if the defendant refuses or intentionally neglects the delivery of summons? If the court receives an acknowledgement or a receipt signed by the defendant or their agent and a receipt endorsed by the postal employee stating that defendant or their agent refused to accept the what? Summons. Refused to accept the what? Summons. The court may declare that summons has been duly served on whom? Defendant. Duly served on whom? Who can declare that? Court can declare that. Court can declare that summons is already served because you rejected the summons. Next one, this is called इसको बोलता है substituted mode of service of summons. Important. Based on this, they ask questions many times in the previous examination. If the service of summons is not possible in any of the above ways, there is something called as substituted. बोलो mode of service of summons, where the court is satisfied that the defendant is deliberately avoiding the service of summons. How he is avoiding? Deliberately avoiding the service, or he is keeping out of way to avoid the service of summons. In that situation, the court may order the summons to be affixed where? In a conspicuous place in the courthouse or the house where who resides? Defendant resides or work for the gain. This is called as what mode of service of summons? Substituted mode of service of summons. What mode of service of summons? Substituted mode of service of summons. In case if he is a public servant, what servant? The summons is sent. What is sent? Summons is sent. Summons is sent. If the in case of defendant is a what? Public servant. What servant? Public servant. Then the summons is sent to the head of the department, and the head of the department will serve the summons to the defendant, and he'll also send a signed copy that the summons has been delivered to the court. Next one, in case of suit against the company or corporation. Company or what? Corporation. In case of suit against the company or corporation, the summons may be served on the secretary, on the what? Secretary or any director or other principal officer of the what? Corporation. What of the corporation? Principal officer of the corporation. I repeat, in case of suit against the company or corporation, the summons may be served. What may be served? On the what? Secretary or director or any principal officer of the corporation by leaving it or sending it or by post addressed to the corporation at what office? Registered office. What office? Registered office. What office? Registered office. If there is no registered office, generally there is no question of not having registered office, because as per Companies Act, which act? As per which act? Companies Act. Having what office is mandatory? Registered office is mandatory. But however, if there is no registered office, then at the place where the corporation carries on the what? Business. Carries on the what? Business. Are you guys clear with this? This is the place of what? Place of sending the summons. Tell me, what is the mode or in what ways a summons can be served? In case of company or corporation, it is sent to whom? Either the secretary or director or officer of the corporation by leaving it at registered office, or addressed to the corporation at what office? Registered office. What office? Registered office. Next one, in case of suit against the firm. Suit against the what? Firm. A partnership firm. The summons may be served upon whom? Upon one or more of the partners. One or what? More of the partners at a principal place at which the partnership business is carried on. What is carried on? Business is carried on. Correct, right? You can serve upon whom? One or more partners. One or more what? Partners. What place? Principal place. What place? At which? Who carries on the business? Partnership carries on the business. Upon any person having the control of what? Management of partnership business. Management of what business? Partnership business. Are you guys clear with this? Yes or no? These are the modes of service of summons. Concentrate, everybody. Hello, listen. First party, first stage in a suit is what? Parties. Who are the parties? Plaintiff, defendant. The one who files the case, plaintiff. The person against whom the case is filed, defendant. If you join two or more parties in a suit, it is called as what? Joinder of party. If a person whose presence is indispensable but he is not added, it is called as what? Non-joinder. What joinder? And if a person whose presence is indispensable and if he is not added, it is called as non-joinder, and he is called as what party? Necessary party. What party? Where a presence of a person is required but it is not indispensable, called as what party? Proper party. What party? Joinder of two or more cause of action. Cause of joinder of what? Cause of action. Joinder of what? Cause of actions. Correct, right? Tell me, what is summons? It's an order issued by whom? Court, directing a person to appear before the court. What is the ordinary mode of service of summons? Delivering a copy of the summons signed by the officer of the court or by the judge of the court. Delivering it to whom? Defendant or his authorized agent, or to the adult male or female member of the families. Within the same jurisdiction, by delivering it personally or by courier services. Outside the jurisdiction, then either by what? Speed post, registered post, or any approved courier services are email. Approved courier services are what? Emails. Yes or no? Clear with this? Understood? All these things are clear. Have I discussed the concept of what if defendant intentionally avoids or neglects the delivery of summons? The court can declare that summons is already served. And in case of defendant keeping out of the way to avoid the summons, in that situation, there is a concept called as what? Substituted service of summons. What of service of summons? Substituted service of summons. Are you guys clear with this, everybody? Next one, appearance of parties. What are parties? Once a summons is served upon the person, is he required to appear and file what statement? Return statement. What statement? If both the parties fails to appear when the suit is called for hearing, the court may order the dismissal of what? Suit. So we're going to discuss now consequences of non-appearance. Consequences of what? Non-appearance. When the court calls upon the persons to appear in the suit and both the parties does not appear, who can dismiss the suit? Court can dismiss the suit. Tell me, this order of the court to dismiss the suit, is it called as a decree? No, it is not called as decree. Rejection of plaint is a decree. Dismissal of the suit for default in appearance of the party, is it called as a decree? No, it is just an order. Just a what? Order. Next one, if the defendant is absent, who is absent? On the service of summons, plaintiff appears, the court may proceed what? Ex parte. What is ex parte? Without hearing the other person. If the defendant is not served with a summons, court will order that second summons be served. What should be served? Second summons be served. If the summons is served on the defendant with insufficient time to appear, the court may give what? Postpone the hearing. Remedies for the defendant after ex parte decree. Important here. If an ex parte decree is passed, what is ex parte decree? Without hearing the defendant. See, if a defendant fails to appear within the prescribed time after the summons is served and the plaintiff is present, who can proceed ex parte? Court can proceed the ex parte. Who can proceed ex parte? Court. And can pass a decree. Pass a what? Correct, right? Against that decree. What are the remedies available to whom? Defendant. What is the first one? Defendant may file a what? Appeal. Against what decree? Ex parte decree. What decree? Who can file an appeal? Against the what decree? Ex parte decree. The defendant may file an application for the what? Review of judgment. What of judgment? He can file an application to the same court to review its own judgment. What is the first one? He can file an appeal. Second one, review petition to the same court. Third one, the defendant may apply for what? Setting aside what decree? Ex parte decree. What decree? Ex parte decree. To set aside the decree. And the last one, a suit can be filed. What can be filed? To set aside an ex parte decree if it was obtained by what? Fraud. Obtained by way of what? Fraud. So these are the four remedies available. What is available? Below what is available? For the what? Defendant. After what decree? Ex parte decree. What decree? What is the first one? Appeal. Second one, review. Third one, he can file a he can apply to set aside the what? Ex parte decree to the same court, or he can file a what? Separate suit if a decree was obtained by fraud. Obtained by what? Clear with this? Next one, discovery and interrogation. Discovery and what? Interrogatories. Interrogatories, not interrogations. Interrogatories and production of what? See, discovery can be done either by interrogatories or by what? Production of documents. Production of what? Documents. These are the two ways of discovery. There are how many ways of discoveries? There are two ways of discoveries. Discovery of by interrogatories, discovery by what? Documents. Discovery by what? Documents. Simple, see, simple. What is discovery, sir? Discovery means finding out the material facts. What facts? And the documents. And the what? Documents of whom? An adversary. That is opposite party. What party? Opposite party. In order to know and ascertain the nature of the case. What of the case? What is discovery? Finding out the material facts and the documents from whom? Adversary, in order to know and ascertain the nature of the case, in order to support his what? Own case. Support his what? Own case. Or narrow the points at issue, or avoid what? Proving the admitted facts. What facts? Admitted facts. What facts? Admitted facts. Case no problem. What problem? Case no problem. What is the case? To know and ascertain the nature of the case in order to support his own case, to narrow the points at issue, and to avoid proving the what facts? Admitted facts. What facts? These are the modes of what? The reasons for discovery. What is discovery? Finding out material facts and documents from the adversary to know and ascertain the nature of the case, or to support his own case, or to narrow the points at issue and to avoid the proving admitted facts. See, this will help us to reduce the, to shorten the time taken for litigation, because once a fact is admitted by the other party, there is no requirement to prove it. There's a requirement to what? Prove it. Discovery by interrogation. Discovery by what? Interrogations. Let's start. Written questions which is formally put by one party to another party in case with leave of the court. What of the court? Interrogatories means what? A person can put a written list of written questions to the other party to be answered with the permission of the court. It is called as what? Interrogatories. It's a way of obtaining the what? Admission of the parties. What of the parties? Admission of the parties. It could shorten the litigation and serve the interest of what? Justice. Serve the interest of what? Justice. What will shorten the litigation and serve the interest of justice? Interrogatories. What is interrogatories? It's the formal questions put by one person to one person, another person with the leave of the court. What of the court? Leave of the court. Interrogatories will not be allowed for the following purposes. They may ask this question in the examination. For what purposes interrogatories is not allowed? What is the first one? Cannot be used to obtain the what? Facts exclusively related to the what? Adversary's case. Second one, discovery cannot compel the disclosure of what communication? Confidential communication between the adversary and the lawyers. Cannot force the release of information harmful to the what interest? Public interest, that is states, army secrets, or public informations. Next one, phishing interrogator. What is phishing interrogator? Is just random question. You don't know what information you want. You just put some random question so that you may get some information. That is called as what? Phishing interrogatories are prohibited. Or what? Prohibited. They may ask question in the examinations. What type of interrogatories will not be allowed? What is interrogatories? First of all, formal questions put by one person to which person? Another person with the permission of what? Court. Permission of what? Court. Next one. Discovery by document. Discovery by what? Documents. Any party can apply to whom? Court. In order directing any other party to the suit to make what? Discovery. What is discovery? Produce on oath the documents which are or which have been in his possession to any matter in the question. Matter in the what? Question. A party may apply to the court to get an order directing the other party to produce the documents which are in his possession or which were in his possession. With respect to the matter in dispute, it is called as what? Discovery by document. Discovery by what? Documents. A party may refuse to produce the document for inspection on the following grounds. What is the first one? Where it discloses what evidence? Party's evidence. Second one, when it enjoys a legal professional privilege, professional communication between the advocate and client. Next one, when it is injurious to what interest? Public interest. What interest? Or if he denies the possession of document, if he is saying that he doesn't have a document, there is no question of discovery by document. Important stages in the proceedings of a civil suit. What are the stages in a civil suit? They may ask this question in the examination. They may ask you to write in brief the important stages in the civil suit. What is the first one? Presentation of plaint. What are plaint? Or what are plaint? Presentation of plaint. Second one, service of summons. Third one, filing of what statement? Written statement, set of counterclaims will happen. Next, appearance of parties, consequences of non-appearance we discussed, right? Next one, examination of parties. What are parties? Examination of parties. Then framing of issues. Who frame the issues? Court frames the issues based on the document submitted and the argument made by the parties. Then hearing of the parties, and the last stage is what? Judgment. What is the last stage? Judgments. So these are the important stages in a what? In a civil suit. What suit? Next one is appeal. Next one is what? Appeal. What is an appeal? Appeal is an application. Appeal is a what? By which a party requests the appellate court either to set aside, to declare it as invalid, or to modify the decision of which court? Subordinate court. What court? Subordinate court. An application by which a party requests the appellate court to set aside or modify the decision of which court? Subordinate court. It is called as what? Appeal. Types of appeal. They may ask this question in the examination. Appeal from what decree? Original decree. Tell me against original decree. What decree? Appeal is available, not available. Available, not available. All decrees are what? Appealable. Orders. Are there any exceptions? How many exceptions? 5 exceptions. Appeal can be filed against any decree passed by a court exercising what jurisdiction? Original jurisdiction. Excuse me. Directed to a court that has been authorized to hear the appeal. Appeal can be addressed both question of law as well as what? Question of fact. Correct, right? You can go for an appeal against the lower court based on the question of fact as well as the question of law. Next one. No appeal against the decree of court of what causes? Small causes where the value of the suit does not exceed how much? 10,000 rupees. Keep this in mind. If a value of the suit does not exceed 10,000 rupees and the case was filed in the court of small causes, what is not available? Appeal is not available. Next one, second appeal. What appeal? What is second appeal? A right to appeal to the High Court from a decree passed in an appeal by which court? Subordinate court, but only on a what question of law? Substantial question of law. What question of law? Substantial question of law. It is called as what appeal? Second appeal. So second appeal is available only on the question of law. What of law? Question of law. First appeal is available both on question of law as well as question of fact. But second appeal is available to the High Court based on what? Question of law. Question of what? Law. A memorandum of appeal must clearly state the substantial question of law. You are challenging the law itself or the law applied by the court. Correct, right? That is called as question of law. Second appeal cannot be entertained on what grounds? Factual grounds. What grounds? Because second appeal is allowed only on the question of what? Law. Question of what? Tell me which court has the right of second appeal? High Court. Decrees, there is always a what appeal? Second appeal. What appeal? But against the order, is there any second appeal? No. Even in the case of appealable orders, there is no what appeal? Second appeal. What appeal? Second appeal. Clear with this? Next one. Appeal to Supreme Court. Appeal to what? Generally, appeal to Supreme Court is not allowed. There are exceptional cases where appeal to Supreme Court is allowed. First one, any decree or order of a civil court when the case is certified. What is certified? Case is certified by the court, deciding it to be fit to the appeal to which court? Supreme Court. Court itself should certify that this case is fit to be heard by which court? Supreme Court. Then you can go to which court? Supreme Court for an appeal or a special leave. What leave? What is special leave? Special permission of the court has been granted to hear the appeal. Next one, from any judgment or a decree or final order passed on an appeal by which court? High Court or any other court of what jurisdiction? Final appellate jurisdiction. Against the decree of the High Court, you can go to which court? Supreme Court. Which court? Next one, from any judgment or a decree or final orders passed by the High Court in exercise of what jurisdiction? Original civil jurisdiction. Bolo what jurisdiction? Original civil jurisdiction. Clear with this? Against this, we can go to the Supreme Court. First of all, tell me what is appeal? An application to the appellate court to set aside or modify the decision of the lower court or subordinate court. Types of appeal. First appeal, that is appeal from decree. Second one, second appeal, appeal against the order. Third one, appeal to Supreme Court. Appeal to what court? Supreme Court. Next one, additional evidences. See, keep this in mind. Additional evidences are not allowed in what? Appeal. Not allowed in what? Appeal. However, the court has the discretion. Who has the discretion? Court has the discretion. Admit evidence in what cases? Following cases. What cases? Following cases. I repeat, at an appeal stage, evidence should be given at the lower court itself, trial court itself. Evidence is not allowed in which court? Higher court or appellate court. But in the following exceptional cases, evidence is allowed. What is the first one? Lower court has refused to admit the what? Evidence, which ought to have been admitted. Appellate court may take the evidence into consideration. Second one, appellate court requires any document. Court itself requires the production of any document as an evidence. Allowed. Third one, for any other substantial cause. What cause? So in general, tell me, is any evidence allowed at an appellate stage? Allowed or not allowed? Not allowed. Allowed or not allowed? Not allowed. Are you guys clear with the concept of appeal? Yes or no? Are you guys clear with discovery? Discovery of how many types? What are two types? Interrogatories and documents. Clear with this? Next one, reference, revision, review. I want everybody to concentrate. Concentrate, guys. Reference, revision, review. Bolo? Reference, revision, review. R. Or, here. What is that? Or. Triple R. Correct, right? Huh? Reference, review, revision. Tell me, reference is made to which court? Lower court to the high court. It is one of the remedy available in case of administrative discretion, right? What discretion? Administrative discretion. Correct, right? Judicial review. Reference of a case by lower court to which court? High court. Before the judgment is pronounced, before what is pronounced? Judgment is pronounced. The court in which the suit has been instituted can refer the specific legal question or the issue to which court? High court for its opinion. Once the reference is made for the clarification or guidance of the high court, the opinion of the high court becomes what? Binding upon the lower court. Which court? Lower court. I repeat, before the judgment is pronounced, the court can refer a specific legal issue to which court? High court for its opinion. Once the opinion is given by the high court, it is binding upon which court? Lower court. That is called as what? Reference. Called as what? Reference. Next one is what? Review. See, the review application is made to which court? The same court which has passed the order or decree. Order or what? Any party aggrieved by the order of the court. Bolo what of the court? Order of the court may apply to which court? Same court for the review of its what? Judgment or order. The judgment or what? Grounds on which the review application can be made, either because you have discovered what evidence? New and important matter of evidence. Second one, mistake or error apparent on the face of the record, or other sufficient reasons. What reasons? Other sufficient reasons. On these grounds, what can be preferred? Review petition. What is the first one? Discovery of new evidence. Second one, error on the face of the record or other sufficient reasons. For these cases, you can make a what? Review petition. Next one, revision petition. Keep this in mind. Revision petition is available to the high court. Which court? Revision petition is made to the high court. But however, listen to me carefully. Revision petition is available only when there is no provision for appeal. If appeal is available, go for an appeal, not for a revision. When the appeal provision is not there, in that situation, a person can make a petition or application for what? Revision. To which court? High court. Or which court? Tell me which court has the jurisdiction of revision petition? High court. His revision is available if the appeal is available. When the revision is available, appeal is not available. Party aggrieved by the decision of the subordinate can apply to the high court for the revision of what? Decision. Revision is available where no appeal lies. What lies? No appeal lies. Grounds for revision petition: exercising the jurisdiction not vested in it by what? Law. That is, if you are assuming the jurisdiction which is not with you, if there is a lack of jurisdiction, you can prefer a revision petition. Next one, failure to exercise the jurisdiction vested in it. Means you have a jurisdiction, but you're not entertaining the jurisdiction, not deciding the matter. Then you can file a revision petition. Last one, acting illegally or with material irregularity. In these three cases, you can file a what petition? A revision petition. What petition? First one, lack of jurisdiction. Second one, non-exercise of jurisdiction. Third one, acting illegally or with material irregularity. Are you guys clear with these? There are how many terms here? Three terms. What are the three terms? What's the first one? Reference, review, and revision. Revision is available if there is an appeal provision. Revision is not available if there is an appeal. Correct, right? Next one, suit by minor and the corporation. Tell me who is a minor first of all. Below how many years? 18 years. The person who has not completed the age of 18 years is called as what? Minor. And if there is a guardian is appointed, who is appointed? Guardian is appointed by a court, or whose property under the courts of wards, then the age of majority is how many years? 21 years. If they ask question about a short note on minors, a case sued by a minor or against the minor, the first provision to write is what? Who is a minor? Who is a minor? The person who has not attained how many years of age? 18 years of age. But if a guardian is appointed, what is the age of majority? 21 years. How many years? 21 years. Tell me, can a minor file a suit? Yes. Every suit by a minor, below, every suit by who? Minor shall be instituted in his name by a person who is in such suit shall be called as what? next friend of the minor. So a suit should be filed on behalf of the minor by a next friend. What friend? So the next friend should be a sound mind. Plus it should be a major. Should be what? Major. Correct, right? Next one, third condition. When a major minor becomes major, who becomes major? Minor becomes a major. Let's say a case is filed by next friend on behalf of whom? Minor. So once the minor becomes a major, he would be having two options. What is the first option? He can continue with the suit and discharge the next friend, and the case title is corrected by replacing the next friend with the name of what? The minor who is a major now, or the minor may decides to abandon the what suit. At that time, while dismissing the suit, the court may order that minor to pay what compensation. Minor to pay what? To which party? Other party. Which party? Are you guys clear with this? This is a suit by a minor. Suit by what? Minor. Against a minor. If there is a suit against a minor, the court should appoint a guardian. Who will appoint a guardian? Court will appoint a guardian to take care of the interest of who? Minor. So any decree or an order passed by the court without appointing a guardian, valid or not valid? Not valid. Valid or not valid? There should be a guardian if there is a case against whom? Minor. Case against whom? Clear? Next one, suit by or against a what? Corporation. Against a what? Or against a what? Corporation. Tell me who does the verification of pleadings or who will sign the pleadings if a company file a case either by secretary or director or other principal officer of the what? Corporation. Service of summons. Have I discussed how the summons is served on the company? How it is sent? To whom it is sent? Secretary, director, or principal officer of the company by addressing to what office? Registered office or any principal place of business where the company carries on the business. Or yes or no? These are the provisions. These are the what? With respect to what? Suit by a minor or suit by a company or corporation. They may ask this question in the examination. Next, we have summary trial. What trial? What is summary trial? The speedy disposal of the suit is called as what? Summary trial. What trial? Order 37. Bolo which order? Order 37 of CPC provide for a summary procedure in respect of certain suits. Not all suits are eligible for summary trial. Correct, right? The object is to prevent the what? Unreasonable obstruction by whom? Defendant. Or what obstructions by defendant? Unreasonable obstructions by whom? Defendant. Application to the suits upon the bill of exchange or hundies or a promissory note or a suit for recovery of what? Debt or liquidated damages. These type of suits are eligible for what trial? Summary trial. What trial? What is the first one? Suit upon a what? Bill of exchange. Well, suit upon a what? Second one, hundis. Third one, promissory note. Fourth one, recovery of debt. Fifth one, liquidated damages. These suits can be tried what? Summarily. For what reason? To dispose the suit in a speedy manner. Applicable to which code? High code, civil code, court of what causes? Small causes. Defendant is not entitled to defend the suit. In case of summary trial, defendant is not given the option to defend the what? Suit. Unless he enters upon appearance within how many days of summons? 10 days. He must appear within how many days of summons? 10 days of summons. The plaintiff shall be entitled to judgment provided the defendant has not applied for the what? Leave to defend. Means if he has not appeared within how many days? 10 days. And sought the approval of the court to defend this suit. In that scenario, who can decide the case? Who can decide the case? The court. And give a what? Judgment. Give a what? Judgment. Inherent powers of the civil code. Which code? Civil code. See, civil code has an inherent parts. What is inherent parts? Implied parts. What parts? Implied parts. See, it is not possible, as I said earlier. Listen, CPC is not an exhaustive. What law? Exhaustive law. It does not provide for each and every scenario. To deal with the gray areas or the causes omissions means where certain things are not covered. In that situation, the discretionary powers is given to which court? High court. Which court? or the civil code. Which code? Civil codes. The civil code under section number 151, section number what? 151. By using section number 151, can deal with the scenarios. Deal with the what? Scenarios which are not covered, which are not what? Covered under the CPC. Under the what? CPC. Section 151 provides the implied powers or inherent powers to which code? Civil code. Which code? Civil code. Section 151 provides, they may ask question based on this in the examinations. Okay? Section 151 provides power of the civil code to make such order as may be necessary for the ends of what? Justice, or to prevent the abuse of what? Process of the court. What of the court? Process of the court. Section number 151 does not confer a new power. It only recognizes and affirms the what? Inherent powers that every court possesses. It is not creating a new power. It only recognizes the inherent powers which who has every civil code has. CPC is not an exhaustive codes. CPC is not an exhaustive code. CPC is not exhaustive, and the court can use the inherent parts to resolve the matters which are not specifically covered, having regard to the what? Justice. Right? Because we got an exhaustive law. Deal with the gray areas. Section number 151 can be invoked in the interest of justice. Interest of what? Justice. Next one, inherent powers cannot be used to contravene the what? Laws. Court cannot go against the law using section number 151. Using section number what? 151. Next one, inherent parts are complementary. What are complementary? Inherent parts are complementary to the what provision? Specific provision. What provision? They will not override the specific provision. They are just complementary to the what provision? Specific provision. Tell me, can the code, civil code, go against the express provision by using section number 151 of the CPC? No. Next one, the courts must exercise their inherent powers with regard to what? Caution. With regard to what? With great caution. What caution? Great caution. Correct, right? They cannot override the express provisions, right? They can use this only in the interest of justice. Only in the interest of what? Justice. Court should use the power under section number 151 only when it is absolutely necessary. That to prevent the abuse of justice. Abuse of what? Justice. They may ask you to write a short note on what part? Inherent parts of what? Civil code. What code? Civil code. Next one, power of the civil code. Power of what code? Civil code. And their exercise by whom? Tribunal. Remember, there are various uh, cases in which we have come across this word called as tribunal has the civil code power. What power? Civil code power. What are the civil code powers? Powers of the civil code. First one is what? Summoning and enforcing the what? Attendance of any person and examining them on what? Oath. Civil code power. Second one, requiring the discovery and production of what? Document. हम लोग discuss किया ना, what is discovery? Discovery by interrogatories and discovery by documents. Next one, receiving the evidence on what? Affidavit. Next one, requiring any public record or a document or a copy of such record or document from any office. Court can require the production of document from any government offices. Next one, issuing the commissions for examination of witnesses or documents. Next one, dismissing a representation for default or deciding the case on what? Ex parte. What is ex parte? Without hearing the other party. Setting aside any order of dismissal of any representation for default or any order passed by what? Ex parte. It can dismiss that ex parte order as well. Any other matters which may be prescribed. These are the powers of which code? Civil code. Which code? Next we have this Yeshpal Jain case law. इस दयाल नहीं है. Yeshpal Jain versus what? Sushila Devi. What Devi? Sushila Devi. See, in this court has given it 12 directions. How many directions? 12 directions. Based on this, the court may they may ask questions in the examination. There are 12 directions given in the Yeshpal Jain case for the speedy disposal of what cases? Civil cases. What cases? Civil cases. What is the first one? Timely execution of what? Summons. Arey bolo, what execution of summons? Timely execution of summons. Next one, timely filing of what statement? Written statement. Within how many days? 30 days. Arey how many days? If any person seeks extension beyond 30 days, he has to provide a reasons for it. What for it? Reasons for it. Next one, completion of pleadings and ADR. What is ADR? Alternate dispute resolution mechanism in a speedy manner. Next one, issue to be framed within how many weeks of failure of ADR? Within 1 week. Next one, court should consult with advocates to fix the trial date. And once fixed, trial should proceed what? Day to day without any adjournment. Without any what? Adjournment. The judges must maintain what diary? Case diary to manage the number of cases. Next one, narrowing down the disputes through what? Discoveries. You know what is discoveries? Discoveries by what? Interrogatories and the documents. It can narrow the case, means shorten the case. That is the purpose of interrogatories, right? Raisa, no. To know the nature of the case or to support your claim or to ascertain the case or to narrow down the case. Next one, trial courts must ensure that once the trial begins, it proceed what? Day to day. Proceed what? Day to day. Court should ensure the payment of what? Cost for the adjournment to prevent unnecessary delay. If anybody seeks adjournment, the court should impose a cost upon the person who seeks the adjournment so that there will not be any unnecessary delays. Next one, at the conclusion of trial, oral argument should be heard immediately and also what? Continuously. Also what? Continuously. And the court to send statistics of cases pending for more than how many years? 5 years. To which court? Principal district judge. Who will forward them to which committee? Review committee. The committee appointed by the chief justice of each state must meet every 2 months. Every how many months? To monitor and take corrective actions on the cases pending for more than how many years? 5 years. So these are the 12 directions which were given by the court in which case law? Yashpal Jain versus Sushila Devi and others case law. Okay, with this, and these are the provisions with respect to what? Civil procedure code. What code? Civil procedure code. Tell me what is appeal? Application made to the appellate court either to set aside or modify decision of which court? Subordinate court. Types of appeal. First appeal, appeal against the original decree. Second appeal, appealable orders, and appeal to which court? Supreme Court. Which court? Supreme Court. So let's discuss the previous year questions and answers for the CPC, Civil Procedure Code. Below what code? Civil or Code of Civil Procedure. Chapter number? Chapter number 6. Concentrate. Question number 1. Explain the cause of action. Can you explain the cause of action? How many ingredients of cause of action? What are two ingredients? Right and increasement of rights. Distinguish between the decree and order. Decree and what? Order. Can you write decree and order? Decree is passed when? After presentation of plaint. But order can be passed even before the what? Presentation of the plaint. Which one determines the rights of the parties conclusively? Decree. Which may not finally determine the rights of the parties? Order. Which one can be preliminary and final? Decree. Correct, right? Order cannot be preliminary order. Number, there will be only one decree or at the most one preliminary and one what? Final decree. But orders can be what? More number of orders can be there. Repeat, generally decrees are appealable, orders are what? Not appealable. Are there any exceptions where order is appealable? How many exceptions? 5 exceptions. Second appeal, decree, second appeal is available, order, second appeal is not available. Clear with this? Next one. Discuss the remedies available to the defendant when an ex parte decree is passed. Have I discussed the concept of ex parte decree? What is ex parte decree? When the defendant fails to appear, court will proceed what? Ex parte without hearing whom? Defendant and pass a what? Decree. In case of ex parte decree, what are the remedies available to the defendant? Either he can go for an appeal or he can application to the review or he can apply for setting aside the decree or he can file a suit if a decree was obtained by what? Fraud. Obtained by what? Fraud. Next one. Section number 10. Section number 10. Section number what? 10. Day of suit. A doctrine of what? res sub judice. Doctrine of what? Res sub judice. Question number one. A suit was instituted by the plaintiff company alleging the infringement by the defendant company for using the what mark? Trade name of the medicine and selling the same in the wrapper and carton of identical designs with the same color combination as that of plaintiff company. A subsequent suit was instituted in a different court by whom? Defendant company against the what? Plaintiff. Can the court proceed with a trial? Cannot proceed with a trial. Because of what concept? Doctrine of res sub judice. Doctrine of what? Section number क्या है? 10. Very good. Res judicata. You know what is res judicata, right? Bar on the suit. The court shall not try a suit in which the matter and issue is what? Already decided. Already what? Decided. Correct, right? Anil was a trustee of a trust. Listen to this case properly. Listen. Anil was a trustee of a what? Trust. After Anil's death, Rich wrongfully takes the possession of the trust property. Chandar, the son of Anil, files a suit for recovery of what? Possession of the property against Rich as the what? Legal heir of the Anil in his individual capacity. What capacity? But Chandan did not succeed. Who did not succeed? Chandan did not succeed. Who filed a case here? Chandan. As a legal heir of whom? Anil. In that capacity, he filed a case. He did not succeed. Now, second, he wanted to file a case as a trustee, as a what? Or beneficiary of a trust. What of a trust? Beneficiary of a trust. Can he file one more suit here? Yes. Because earlier he filed a suit in what capacity? As a legal head. What head? Now he want to claim the property as a what? Beneficiary. As a what? In earlier suit, he was acting in a different capacity, right? And what capacity? Different capacity. What capacity? Different capacity. Let's read the answer. No court shall try any suit or issue in which the matter directly and substantially in issue had been free directly and substantially issue. In what suit? Focus suit between the what parties? In a court competent to try such subsequent suit or the suit in which the issue has been what? Subsequently raised and had been finally decided by the such court. The matter must be directly and substantially issued in the what suit? Two suits. Prior suit should be between what parties? Same party. Under the same title, the court determined the what suit? Earlier suit and must be competent to try it. But in this situation, he filed a case in what capacity? Different capacity. What capacity? Allowed or not allowed? Allowed. Yeah. Whether consent, case of consent and compromise decree in between the parties, principle of res judicata shall apply? No. Consent decree means if both the parties with the consent enters into a compromise and the court passes a decree, will it act as a res judicata? No, unless the court specifically mentioned that it is a final decree. What decree? Final decree. Then what is applicable? Res judicata is applicable. Place of filing a suit. Place of filing a suit. A transport company has its head office in Delhi and branch office at where? Chennai, Jaipur, and Mumbai. A dispute cropped up between Sam and the company in respect of transaction made to the what? Chennai office. What office? Sam files a suit in respect of these disputes against the company in the court at what? Jaipur. How will the court decide? Is the suit valid or not valid? Not valid. You need to file a case either where? Delhi or Chennai. Delhi or what? Can you file a case in Jaipur? Why no? The cause of action in case of suit with respect to what suit with respect to companies. Either you can file a case at where the company has what office? Registered office, or where the cause of action arises. In this case, where is the cause of action? Chennai. Where the defendant resides? Delhi. Either you can file a case in Delhi or in the Chennai or in the what? Chennai. Next one, explain the limitation under the Civil Procedure Code that every suit shall be instituted in a court within the local limits of whose jurisdiction the defendant actually resides or carries on the what? Business. Place of filing a suit. Can you write in brief? Next one. Next one. Set of counterclaim. Distinguish between set off and counterclaim. Set off and what? Which one is only for ascertained sum of money? Set off. Which one can be even for unascertained sum of money? Equitable set off or even the counterclaim. Even the what? Counterclaim. Which one is a cross action? Counterclaim. Correct, right? Which one is requires to arise out of the same transaction? Set off. Sorry, equitable set off or counterclaim also. Counterclaim includes both set off as well as what set off? Equitable set off. Counterclaim, nothing but you make some claim against the plaintiff in your retention. That's called as what? Counterclaim. Correct, right? Next one. Distinguish between what? Set off and equitable set off. Set off and can you answer this question? Set off and what set off? Equitable set off. Next one, temporary injunction. What injunction? When the court can pass a temporary injunction for deposit of money or deposit of goods. Correct, right? What is injunction and when the court can grant a temporary injunction? What injunction? Temporary injunction. Mode of service of summons. Ordinary mode, then substituted mode of service of summons, serving summons on the public officer. What officer? Public officer or employee or corporations or to the firm. Write a short note on the suits by or against the corporation. Suits by or against whom? Corporation. Verification of pleadings. How the service of summons happens. Correct, right? Next one. Discuss the law with respect to suit by or against whom? Minor. Who is a minor? How the case is filed, and once he becomes a major, how the what are the consequences? Next one. A minor. When a minor is a defendant, court shall appoint a proper person to be a what? Guardian. We discuss this. Write a short note on reference, review, and revision. Other topics, discuss the provision with respect to pre-mediation and Commercial Courts Act 2015. For mediation, pre-mediation. See, in case of we have a law called as Commercial Courts Act 2015. As per this law, pre-mediation is compulsory before you take the order of the court. And the mediation should be completed within how many months? 3 months. It is extendable up to how many months? 2 months. How many months? 2 months. Once the if mediation is successful and signed by both the parties, the case is settled by the mediation. So mediation is compulsory in case of what? Any cases under the Commercial Courts Act 2015. So these are the questions, and as I said, this chain question, and more important, this necessary party. What party? Necessary party and proper party. They may ask question based on joinder of parties. What are parties? Joinder of parties and joinder of cause of action, necessary party and proper party. Simple C, simple chapter. This is one of the simple chapter compared to the PNS and BNSS. You have chances of scoring more marks in this chapter. Clear with this? Code of civil procedure. Code of what? Civil procedure. So with these, we are done with what? CPC, Civil Procedure Code. Now we'll start with what? Lesson 7, Law with respect to crime and procedure. Crime and what? Procedure.